ಇದ್ರೆ ಸ್ವಲ್ಪ ಕೂಗಿ ಬನ್ಸಿ. ಹೋಗಿ ನಾನು ಕೇಸ್ ಕ್ಲೋಸ್ ಮಾಡಿಲ್ಲ ಇವತ್ತು. ನನಗೆ ಗೊತ್ತು ಆಗತ್ತೆ ಇವತ್ತು ಹಿಂಗೆ ಅಂತ. ಎಷ್ಟು ದಿನ ಹೇಳ್ತೀರಿ ಒಂದ್ ರೂಮಿಂದ ಇನ್ನೊಂದ್ ರೂಮ್ ಓಡ್ತೀನಿ ನೀನು? ಎಲ್ಲ ಲಾಕ್ ಮಾಡ್ಬಿಡ್ತೀನಿ, ಎಲ್ಲ ಲಾಕ್ ಆಗಿದೆ ಇವಾಗ. ಹಿಂಗು ಕೇಳಿದ್ದೀನಿ, ಸ್ವಲ್ಪ ಅಮ್ಮಗಾರು ಬಂದ್ರೆ ಸಾಹೇಬ್ರಿಗೆ ಕೇಳಿ ಏನು ಕರೀತೀರ ಫೈಲ್ ಇವತ್ತು ನಂಬರ್ ಬರ್ತಾರೆ CH-10 ಗಾಡಿವಾಲ ಅಂತೇಳಿ ಅವರು ಗೊತ್ತು.
5 ನಿಮಿಷ ಕೈಗೆ ಬರ್ತಾರೆ.
Sir, my case not come, sir, on the list. You are not here. ರಾಜಗಾರು ನಾನು ಆಮೇಲೆ ಬರ್ತೀನಿ. ಹೆಂಗು ನಾನು 2:30 ಸೆಷನ್ಗೆ ಹಾಕಿದ್ದೀನಿ, ಬಂದಿಲ್ಲ, ಲಿಸ್ಟ್ ನಲ್ಲಿ ಇಲ್ಲ. ಸುಮ್ಮನೆ ಅಮ್ಮರಿಗೆ ನೆನೆಸಿ ಸಾಹೇಬ್ರು ಊಟ ಮುಂಚೆ ಸರಿ ತಗೊಂಡ್ಬಂದ್ರೆ ನಾನು ಒಂದು 2 hours ಬಿಟ್ಟು ಬರ್ತೀನಿ. ಪ್ಯಾಕ್ ಮಾಡಿಸ್ತಾರೆ ಬಾಬು ರೆಡ್ಡಿ ಜೊತೆ. ಆಕ್ಚುಲಿ ಅವರೇನು ಪರ್ಮಿಷನ್ ಹೇಳ್ತಾರೆ ಬೇಕಾಗುತ್ತೆ ಏನು ಮಾಡೋದು ಅಂತ ಸೆಕೆಂಡ್ ಸಲ ಇದೆಯಾ ಅದೇ ಇದು ಪಾಸ್ ಆಗಿದೆ. ಯಾಕಂದ್ರೆ ತಹಸೀಲ್ದಾರ್ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಮ್ಗೆ ಕರೆಕ್ಟ್ ಮಾಡಿಸ್ತಾರೆ.
Post ಆಗಿದೆ ಸರ್ ಸಾಹೇಬ್ರಿಗೆ ಏನು ಕೇಳೋದು ಬೇಡ. ಥ್ಯಾಂಕ್ ಯು ಸೊ ಮಚ್ ಸರ್.
ಸರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು ಪೆಂಡಿಂಗ್ ಆದ್ರೆ ಏನು ಮಾಡಬೇಕು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ ಪೆಂಡಿಂಗು
ಗೊತ್ತಿಲ್ವೇ ಯಾಕೆ ಇಷ್ಟ ಆಗಿಲ್ಲ ಅಂತ. ಲಾಸ್ಟ್ ಫ್ರೈಡೆ ಯಾವತ್ತು ಥರ್ಸ್ಡೇ ಬಂದಿತ್ತಾ?
ಕೊಡ್ತಾರೆ, ಡೇಟ್ ಬೇಕಂದ್ರೆ ಸಬ್ಮಿಷನ್
ಬರ್ಕೊಟ್ಬಿಡಿ.
ಕೊಡ್ತಾರೆ, ನೀವು ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡಿ
ನಮ್ಗೆ ಸಬ್ಮಿಷನ್ ಬೇಡ.
ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ ಬರುತ್ತೆ ಕೊಡಿ, 3rd ಡೇ ಬರುತ್ತೆ ಫೈಲ್ ಆದ್ಮೇಲೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಎಲ್ ಬಿ ಇಲ್ಲಿ ಬರಲ್ಲಪ್ಪ, ಇಲ್ಲಲ್ಲ ಈ ಕೊಟ್ಟಲ್ಲ 6. ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಸಬ್ಮಿಷನ್ 2:30 ಆದ್ರೆ ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಆಯ್ತಾಯ್ತು ಆಯ್ತು, ನಮ್ ಕೆಲ್ಸ ಮೆಮೊ ಕಳಿಸ್ತೀವಿ ಅಷ್ಟೇ. ಯಾವುದು ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ 1 ವಾರ. ಹಾ ಹೌದು ಬೇಡ ಇದು ನಾಳೆಗೆ ಹೇಳ್ತೀನಿ ನಾನು. ಫೈಲ್ ರಿಸೀವ್ ಆಗಿದ್ರೆ ಹಾಕ್ತಾರೆ. 1 ವಾರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ಯಾವ ವರ್ಷದ್ದು? IA 3 of 16 for amendment.
Yeah, and some developer too, not come here. To find go down, can you just ask someone to find it? Yeah.
ಯಾವ್ದಿದ ನನ್ನ ನಂಬರೇ ನೋಡಲ್ಲ, ನಮಗ್ ಬರುತ್ತೋ ಇಲ್ವೋ ನೋಡ್ತೀವಿ ಅಷ್ಟೇ.
49. ಇಲ್ಲ ನಾಳೆ
ಯಾರು R1 R1 ಅವ್ರಲ್ಲಿ ಬಂತ ಅಂದ್ರೆ ಅವರು ಬೇರೆ ಕೇಸಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅವರಿಗೆ. ಹೌದಾ? ಮಾಡಿ ನಾನೇ ಇಟ್ಟೆ. ಆಯ್ತು, ಫೋಟೋ ಇಟ್ಕೊಳ್ಳಿ. ಯಾಕೆ ನೀವು ಹೋಗಲ್ವಾ? ನಿಮಗೆ ತಾನೆ ತುಂಬಾ ಗೊತ್ತಾಗೋದು. ಹೋಗಿ ಸರಿ ಸರಿ. ನನಗೆ ಫೋನ್ ಮಾಡಿದ್ರು ಅವರು, ನೀವೇ ಇರ್ಲಿಲ್ಲ ಅಂತ. ಇಲ್ಲಿ ಮೆಮೊ ಹೇಳಿ ಬರ್ಸ್ಕೊಂಡು ಹೋಗಿ, ಅವ್ರು ಇಷ್ಟೇ ಮಾಡೋದಕ್ಕೆ ಇದು ಮಾಡ್ತಾರೆ, ಆಮೇಲೆ ಬರ್ಕೊಡಿ ಅಂತ ಕಳಿಸ್ತಾರೆ. ಮುಂದೆ ನೀವು ಮೊನ್ನೆ ಬರ್ಸ್ಕೊಳ್ಳಿಲ್ಲ, ಫ್ರೆಶ್ 3rd ಡೇ ಬರುತ್ತೆ. ಫೈಲ್ ಆದ್ಮೇಲೆ 3rd ಡೇ. ಸೀರಿಯಲ್ ನಂಬರ್ ಮಾಡಿ ನೀವು ಸರಿಯಾಗಿ ಬರೆಯಲ್ಲ, ನನ್ನನ್ನು ಬೇರೆ ಫೋನ್ ಮಾಡ್ತಾರೆ, ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂತಾರೆ. ಯಾರೋ ಒಟ್ನಲ್ಲಿ ತಪ್ಪಾಗಿರೋದೆಲ್ಲ ಮಾಡ್ಕೊಂತಾರೆ. ಅದಕ್ಕೆ ಮಾಡುವಾಗ ಸರಿಯಾಗಿ ಮಾಡಿ. ಅದಕ್ಕೊಂದು ಫೋನು, ಅದನ್ನ ಅಟೆಂಡ್ ಮಾಡೋ, ಬೈಕೊಳ್ಳೋದು ನಿಮ್ಮನ್ನ. ಕಂಪ್ಯೂಟರ್ ಅವ್ರು ಇದಾರ ನೋಡಿ. ಆನಂದ್ 3 ದಿವಸದಿಂದ ಆನಂದ್ ಇಲ್ಲ. ಇಲ್ಲ ಫೋನ್ ಮಾಡಕ್ಕೆ ಅವ್ರು ಶಿಫ್ಟ್ ಆಗಿದಾರಂತೆ ಬೇರೆ ಕಡೆ.
The Lordship's kind of one matter for 230 minutes is an RTI matter. 85,000 cost has been imposed on me. Tomorrow is the last day to deposit it, or else disciplinary action will be initiated against
So deposit it.
Lordship may kindly after 230 minutes. Or tomorrow, my lord.
Tomorrow.
Not district register, not see extends the terms of the governing body for a period of 6 months and thereafter for another 6 months. Now that illegal body not is proceeding to conduct election with several irregularities. I request this matter be taken up tomorrow. It's covered by Shivanna judgment. Lordship said.
Good.
And on last occasion, your lordship already given a date for July 9, but matter is not listed. My lord, today contempt of court is listed. They are not giving time, my lord. Without any reason, they have initiated.
Charges frame ಆಗಿದೆಯಾ ಇಲ್ವಾ?
Allah. Today, my lord, if possible, my lord, please, my lord.
Tomorrow.
Your lordship heard at length.
No, you should have moved it earlier. You can't come like this in a pending matter and move it at 10 o'clock for 2:30. Pending matters will not be taken up at
At
2:30.
least tomorrow, my lord.
Tomorrow.
Matter is covered by judgment, my lord.
Pending matter, fresh matter.
Pending matter.
It will come in seniority.
My lord, dispose the matter being spoken.
Disposed matter. Put in
My lord, this is a 2009 matter, my lord.
2000?
2009 matter in the trial.
We don't, we don't have any 2009 matters.
I'm seeking for early disposal.
Fresh matter, old matter.
Pending matter, my lord.
It will come in seniority matter.
Constantly creating third party rights.
Yes.
My lord, parents are Indians. Child is born in Canada. Their citizenship application is rejected. As the father has not consented for citizenship application, my only prayer is to consider the offline application for writ of mandamus I have filed.
How old is the child?
Child is 3 years, my lord.
3 years.
My visa will expire in next month, my lord. There's an agency Monday, tomorrow or day after tomorrow.
Day after tomorrow.
Matter for 230, my lord. The recovery officer posted the matter for confirmation of sale certificate, my lord. 27th, the matter is.
Dear, surface matter.
Please, my lord, I am seeking mandamus.
Surface matter will not be before us.
Surface matter, my lord. I am seeking mandamus to the warehouse corporation to pay the loan, my lord, to the bank, my lord. The bank initiated recovery proceedings and.
Can't ask for a mandamus to do that. Kodi, we are wasting it.
In similar matter, my lord, the coordinate bench has already.
You are wasting your time. Kodi.
230, my lord.
Yes, tomorrow.
Without jurisdiction, my lord, 6 months and is being adjudicated before the consumer firm.
Kodi, tomorrow. Who has issued the sale auction? Waqf Court. Yes, madam. ಏನು? Selection in what
ಹೋಗ್ ಬಂದ್ರ ಮೈಸೂರಿಗೆ ಎಲ್ಲ ಆಯ್ತಾ? ಪೂಜೆ ಮಾಡಿದ್ರ? ನಿಮ್ಮ ಹೆಸರಲ್ಲೂ ಪೂಜೆ ಆಯ್ತಾ? ಏನ್ ಇದೇನು? ಹ್ಮ್. Allotment is already done. Day after tomorrow. DRT matters don't come before us. Stay in what matter? The GM residuary matter. So it's a pending matter. If they've started proceedings, we initiate contempt in the regular seniority. Yes. Yaudu that gas HP? You can file it until once we get the report, we'll consider everything. You file it along with the memo in the counter, it will be put up in the file. When the matter is listed, it will be taken up on that. Whatever you want to file, you file it.
My lord, the matter is covered by judgment. It's a pending matter, my lord.
It will come in seniority. Good. Comply with the orders. Tomorrow day after notice.
The work officer has issued a notice to hold a selection without publishing the calendar of list or the electoral list. It was scheduled on 28th March.
Selection of the management committee.
Yes.
Day after tomorrow.
Execution proceeding, they had issued a take open law and false protection. They are challenging, my lord.
Execution proceedings you are challenging before this court.
It has been classified as GMRES only.
How will it be GMRES?
Fresh matter.
CPC agala, not posted before the appropriate.
2025 matter, fresh matter, my lord. The last year matter was reached, but not reached, my lord.
So it is last year.
Last
So
year.
it's not a fresh matter. It will come in seniority.
My lord, conservative forest officer issued the notice to the.
Madam, pending matters will come in seniority.
Fresh matter, but matter was not reached, my lord. The fresh matter.
Serial number ena? What is the number, Amma? 25 tane?
Yes, my lord, but in the year 2025.
My lords, kindly.
Day after tomorrow.
It will come in seniority, please.
My lords, kindly, my lords, a matter for 230, my lords. The order for blacklisting was already withdrawn before this on. Sorry, in WP number 9450/2020. In spite of the withdrawal before this honorable court, now it's uploaded. The very same order is uploaded before the orders of the government.
Tomorrow.
Police gadi parrada.
Grateful, my lords.
Reach agli. Petitioner wife 8 months pregnant ಇದೆ.
You had heard and notice and hearing ಆಗಿತ್ತಾ ಇಲ್ವಾ?
ಆಗಿಲ್ಲ. ರೀಚ್ ಆಗ್ತಿಲ್ಲ.
ಅಲ್ಲಿ 55 ಅಲ್ಲಿ.
ನೋಡಿ.
55 ಆಗಿದ್ರೆ ನೀವು 59 ಅಪೀಲ್ ಹೋಗ್ಬೇಕು. ಇಲ್ಲಿ ಡೋಂಟ್ ವೇಸ್ಟ್ ಯುವರ್ ಟೈಮ್.
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ.
ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದೀಯೋ ಅದು ಬರುತ್ತೆ ಅದು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್.
My lord's threat to arrest, my lords, there's no section 35 clause 3 notice has not been served upon me. However, the police is trying to arrest me, my lords. There's threat to
Trying
arrest.
to unsuccessfully.
My lord, taken at 2:30, my lords.
Tomorrow.
My lords, then
Get
27th, my
serve
lords.
it on Mr. Panni. He'll get instructions. Police arrest 35.
This case, my lord, there was direction for AG to obtain, my lord, the opinion on the medical report submitted by the petitioner from, my lord, medical superintendent of Kidwai Institute of Oncology. My lord, there was direction for this matter on 31st 7th. 2:30. And that it has not got listed. Unless that is this matter.
31st ಇಂದ ಇದುವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
Not my colleague has tried to move the matter.
ಡೇಟೆಡ್ ಮ್ಯಾಟರ್ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ನೋಡಿ ಲಿಸ್ಟ್ ಮಾಡಿ ಅದು ಯಾಕೆ ಡೇಟೆಡ್? Come in seniority, ma'am. Will come in seniority, please.
Your Lordship, I had secured an interim order wherein this court had permitted me to collect maintenance charges. I filed an application seeking an extension of further 6 months of the interim order. The interim order also asked me to figure out which is the appropriate law under which the association can be registered.
Apartment.
Correct.
So have you registered?
The association is still considering which is the appropriate law.
You will have to advise them that it's KOA, please advise them and let them do it. They cannot be considering for 6 months. We won't
I
extend
filed an
time.
application, it may be, matter may be listed
It's a
for
pending
consideration
matter,
of the
it will come up in
application.
seniority, otherwise we'll reject that. We have rejected in n number of matters. Yes.
Adjournments. List number 1, page number 5, serial number 30 to 32.
Serial number 17.
What is being called out?
Page number 6, serial number 33 to 36.
30? Huh? Inform ಮಾಡಿದಿರಾ respondent ಗೆ? 36 at the request of counsel for the petitioner released on 22nd September.
Page number 7, serial number 37 to 42.
Serial number 42, Your Lordship. And for the respondent, we have informed the petitioner's counsel.
You're for which respondent?
Respondent number 3, Your Lordship, MRPL.
What about the other respondents? Have you informed the other respondents?
No, Your Lordship. We have informed the petitioner.
I'm appearing for the petitioner.
When it reaches, please. Next.
Page number 8, serial number 43 to 48.
44.
Have you informed the respondent? 44 at the request of counsel for the petitioner, 22nd September. Have you informed everybody?
One day accommodation. One day.
Who are you appearing for?
Tomorrow.
Have you informed the other counsel for the respondent? I will, but yes, next.
Page number 9, serial number 49 to 53.
Who is the respondent number 1? Martha's Hospital. Yeah. When it is called, we'll see that it's not a matter to be mentioned.
Page number 10, serial number 54 to 58.
My lord, serial number 57, madam, appearing for the petitioner.
Yes.
Seeking for 1 week time maybe.
57 at the request of counsel for the petitioner, 22nd September.
Bacha.
Page number 11, serial number 59 to 65.
3, my lords. Appearing for the petitioner, 2 weeks time, my lords.
22nd September.
63, my lords.
22nd.
Interim order may be extended.
Interim order.
Obliged.
Page number 12, serial number 66 to 72.
72. At the request of counsel for the petitioner, 22nd September.
Serial number 70, my lord. We have informed the petitioner. We are R1.
Your for?
Respondent 1. So.
Respondent number 1, 22nd September, interim order earlier granted is extended till next date.
Number 13, serial number 73 to 81. Page number 14, serial number 82 to 90.
87, my lord. I'm for the petition. Premature release matter. Kindly have this matter on 27.
87 released on 27th.
Page number 15, serial number 91 and 92. It's number 1, fresh matter, serial number 1. MR Hide matter.
My lord, petitioner's wife left him about 30 years ago. Thereafter, my lord, he got some properties by virtue of self-acquired and will, my lord. Now, the assistant commissioner also directed the superintendent of police to give protection to the petitioner. In spite of several complaints by the petitioner to the jurisdiction police, my lord, the second respondent police insisting the petitioner to settle the matter.
Complaint about.
My lord, kindly come to the page number, my lord. Annexure C, my lord. Annexure C and D.
Page?
My lord, 18 and 19.
That's the endorsement. Where's your
Endorsement ಕೊಡ್ತಾರೆ ನಾನು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ my lord.
Complaint ಎಲ್ಲಿದೆಯಪ್ಪ? Where's your complaint and what is the complaint that you have lodged?
Seeking protection, my lord.
Protection for what?
Protection from the defendants of, plaintiff of the suit. So, though their suit rejected, my lord.
To seek for in the that suit. Is there an order passed by the court seized of the suit?
Well, suit by the private party, my lord. In that suit, my lord, injunction rejected, my lord. And assist.
Unless there is an order of protection in your favor,
Well,
you cannot be going to the police. Ellaru protection.
Protection is order. Kindly come to the page number 37.
37.
Please, my lord.
ಎಲ್ಲಿದೆಯಪ್ಪ?
My lord, ಹಿರಿಯ ನಾಗರಿಕರ assistant commissioner order by the
page 36, my lord. Annexure H.
37. Yes.
ಪ್ರಸ್ತಾಪಿತ ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸದರಿಯವರು ಹಿರಿಯ ನಾಗರಿಕರಾಗಿದ್ದು ಸದರಿಯವರ ಪೋಷಣೆ ಮಾಡುವುದು ಸಂಬಂಧಿಗಳ ಹೊಣೆಗಾರಿಯಾಗಿರುತ್ತದೆ. ಪರಂತು ಹಿರಿಯ ನಾಗರಿಕರಾದ ಗಂಗಾಧರ ರಂಗಪ್ಪ ಅವರಿಗೆ ಕಿರುಕುಳ ನೀಡುತ್ತಿರುವ ಬಗ್ಗೆ ದೂರು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ವಯೋವೃದ್ಧರ ಮನವಿದಾರರ ನಿರ್ವಹಣೆ ಮಾಡಲು ಅರ್ಜಿದಾರರ ಶಾಂತಿಯುತ ಸ್ವಾಧೀನಾನುಭವಕ್ಕೆ ಎದುರುದಾರರಿಗೆ ಹಸ್ತಕ್ಷೇಪ ಮಾಡಬಾರದೆಂದು ಸೂಚಿಸಿ ಸಂಬಂಧ ವ್ಯಕ್ತಿಗಳಿಗೆ ನಿರ್ದೇಶಿಸಲು ಕೋರಿದೆ.
ಅಷ್ಟೇ. ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, this is direction by the assistant commissioner to the SP, my lord.
Saying ಅವ್ರಿಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡಿ ಅಂತ.
Yes, my lord.
Not for police protection. Police have other things to do.
I will file detailed complaint, my lord. Kindly direct the respondent to consider my complaint, my
PGA
lord.
accepts notice for respondent 1 to 3. After arguing for some time, learned counsel for the petitioner seeks permission to withdraw the above petition with liberty to file a detailed complaint. Reserving such liberty, petition stands disposed.
Kindly direct the consider my complaint, my lord.
You file it and.
Complaint ಕೊಡ್ತೀನಿ.
Serial number 2, Akash Kumar Gowda.
Yes, Mr. Ravi.
The petitioner is the owner of the land. Certain lands is around 116, 17, and 18. And there was a joint development agreement between the petitioner and the fifth respondent. My lord, the fifth respondent, by virtue of the sites which are allotted to him, he had entered an agreement to sell 2 sites in favor of the fourth respondent. Since the site in question was not allotted, my lord, he filed a complaint before the RERA. There is a direction to allot the sites or else, my lord, to pay the compensation. Now, my lord, the first respondent has directed the second respondent as per annexure F at page 90 in view of the direction issued by the RERA not to register any sites formed in the land bearing around 116/4, 117/4, 117/5.
Appellate remedy before the appellate authority.
But this is because I was not a party.
You are a co-promoter. Being the landowner, you are a co-promoter and 2 ZK.
But my lord, here, my lord, there's a specific allotment of the sites in favor of the developer. There is an agreement. It's a registered document is there.
Writ petition link bartira.
Because this is a, my lord, order. It is a direction. It's not even an order. Lakshmi, kindly see, my lord. It is at page F. It is not an order.
ರೇರಾ ಪ್ರಾಧಿಕಾರದ ಪೂರ್ಣ ಪೀಠ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ದಿನಾಂಕ 18/5/24.
That is
as against, there is a further direction.
That is against
18/5/24.
That is against fifth respondent.
Where the 18/5/24 order?
It is against the fifth. I was not a party. I was not a party. He is the developer, my lord. Certain sites were as per
now the developer is firing on your shoulders. That's all.
ಅಲ್ಲಿ ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಲಕ್ಷ್ಮಿ kindly see, there is a specific allotment of the sites. Lakshmi, kindly see page 47.
And have it, Mr. Ravi, it's the entire project only is the issue where the order has been passed. Where is the 18/5/24 order?
Lakshmi, kindly see at page 88, 87,
87.
the appellate order.
ಇದು order date 18/5 is confirmed. 18/5 ಎಲ್ಲಿದೆ?
Confirmed. It is at
This is
page
appeal filed by the developer.
Insofar as the sites which are given to the developer, I have no objection. This order, this direction shall not come in the way of the
You are
owner.
a co-promoter, it won't be. Lord, K. Rajshekhar for respond number 1, AGA for respond number 2, 3, issue notice to respond number 4 and 5, written out by 12th October.
Meanwhile, the stay, my lord.
No stay at all. Considering that the petitioner is a co-promoter, the interim order is not granted.
ನಾನು ಓನರು ಅವ್ರು
Co-promoter
ಕೊಟ್ಟಿದೀವಲ್ಲ ಅದ್ರ ಮೇಲೆ ಹೋದ್ರೆ ಹ್ಯಾವ್ ನೋ
ನಿಮ್ ಫ್ರೆಂಡ್ ಇದಾರಲ್ಲ ಡೆವಲಪರ್ ಅವ್ರಿಗೆ ಹೇಳಿ ಕೊಡಕ್ಕೆ. Next.
Serial number 3. Aishi Goyal.
My lords, I appear for the petitioner.
Yes, madam.
My lords, this is a posh matter wherein the IC has refused to conduct an inquiry and
Refused
resolution
to
of-
conduct.
Indeed, my lords. This is a similar matter. There were 2 other writ petitions, my lord.
Issue notice to respond number 1, 2, 3, counsel for the petitioner shall for the limited purpose of issuance of notice to respond number 3 furnish the details.
I just have
Details,
one.
the address details of respond number 3. Connect with WP number so and so.
Grateful. I'll finish that. My lords, I just have one submission. My lords, this particular petitioner, because the inquiry has been closed, interim measures were not considered. She's constantly been facing retaliation within the company.
Without notice, we can't do anything, right? It's been closed.
My lords, I may be granted liberty to move the court in the event that she faces some retaliation, my lords. Just to
Counsel
that
for the
extent.
petitioner is also permitted to take out and summons on the respondent.
Grateful, grateful.
What is that number? When is that matter posted?
15 September, my lords.
15 September.
Grateful.
Serial number 4. Basuraj P.
Yes.
The respondent number 7 and her sister have filed a suit for partition and separate possession. Trial court decreed this suit. Lordship, that the petitioner has filed appeal before this honorable court, but in RFA 4567 of 2019. And this honorable court pleased to pass an order of directing the parties to maintain status quo. My lordship may kindly come to page number 61.
61.
Please.
Yes.
My lord, last paragraph, bottom. Bottom last paragraph. Meanwhile, the parties are directed to maintain status quo in all as respects, as on today, as indicated in photographs annexed to IA number 5/2023 till the next date of hearing. My lord, that there are another appeal, my lord, it was clubbed with the another appeal. The division bench of this honorable court, my lordship may kindly come to page number 67. Modified the interim order permitting the petitioner to, my lord, the usage of usufructs in the air canal trees, page number 67. In view of, my lord, the middle para.
Yes.
In view of the fact that order of status quo dated 27/11/2023 was intended to be maintained only till the next date of hearing, and since the appeal is of the year 2019, we are of the opinion that the status quo requires a clarification. Pending disposal of this appeal, the parties are permitted to take usufructs from the property which is in their possession. But the respondent number 7 and another would have filed the execution petition against me for delivery of possession. Page number 72, my lord. Page number 72. It's an
Yes.
execution petition. My lord,
What are you challenging in this proceedings?
No, my lord, despite, my lord, the petition is pending for delivery of possession, the Tahsildar directed the jurisdiction police sub-inspector to provide the protection to the respondent number 7 to remove the usufructs from the air canal trees.
So it is as per the division bench's order.
No, my lord. That is the reason page number 72, my lord, I come.
Any clarification you go before the court. with
Page
the
number
seal of the-
72 for a moment. She filed the possession is with us.
The
My lord,
RFA is pending. Any order that you need, you go in that court.
my lord, Tahsildar has no jurisdiction, my lord, to direct the sub-inspector to.
There is RFA pending.
Please, my lord.
You are asking for implementation or non-implementation of that order depending on from which side.
No, my lord, I am not asking for implementation. My lord, the what Tahsildar has done
He issued a letter to the PSI.
Non-implementation because Tahsildar cannot.
My lord, page, that is the reason, my lord, page number 72 for a moment.
You go before that court.
My lord, the
AGA for respond number 126, notice to respond number 7 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following.
page number 14, humble request for a moment. Page number 14 for.
Number 1567 of 2019 and RFA 3 of 24 being pending between the petitioner and respond number 7, where the Honorable Division Bench of this court, while order dated 9/7/25, had directed the parties, had clarified the order of status quo by permitting the parties to take the usufructs of the property which is in their possession. Respond number 7 having approached the Tahsildar directed police help to take out the take the usufructs. It is challenging the same. The petitioner is before this court contending that the Tahsildar did not have the jurisdiction to do so. Since the regular first appeals are pending between the parties, it will always be available for the petitioner to move the said court seeking for any reliefs as that done in the present matter. Reserving liberty to do so, the petition stands disposed.
Please.
Serial number 5, Mohammed Tahir.
Lordship, kindly pass over the motion. Pass over the motion.
What is this matter?
This is a matter, KPID matter, my lord. Notice is being challenged. Appointment of the authority, competent authority. I will argue the matter, Your Lordship. Kindly pass.
Pass over.
Serial number 6. Yes, Kumar.
Yes.
Really? Lords, I have lodged a complaint before the station house officer, my lords, the respondent number 3, alleging that, lords, the complaint is at page number, kindly come to page number 13, my lords.
13. Yes.
13, my lords. They have induced me to invest for holiday package for 5 years, my lords, rupees 1,89,000.
Non-cognizable offense.
Please, my lords.
Non-cognizable offense. So you'll have to
Lords,
move the
cheating, my lords. Kindly see the endorsement, my lords, which they have issued.
cheating 318(3) only is cognizable. This will come under 1 and 2.
Lords, kindly see the entire.
You'll have to move the next senior officer and then PCR.
Lords, true, my lords. My lords, in the judgment, my lords, in the BH Nagaraj versus State of Karnataka, my lords, clearly held that refusal, difference between refusal and rejection.
Yes.
Lords, kindly see the endorsement, my lords, which is at page number 10, my lords.
Those were in the peculiar facts and circumstances where the senior citizen was injured on the head.
Please.
And that was not considered.
Please.
And that was a cognizable offense.
Please.
This is not a cognizable offense.
But they have locked the doors, my lords. They have blocked my phone number.
All of it is non-cognizable.
Cheating, my lords.
Petitioner
clearly case
takes up notice for respond number 1, 2, 4. Notice to respond number 5 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the complaint which had been submitted by the petitioner alleging that respond number 5 had induced the petitioner to invest in a holiday scheme has not been considered and necessary FIR registered. A perusal of the complaint would indicate that the offences which have been alleged are non-cognizable offences. That being so, it would always be available to the petitioner to escalate the same to the next superior officer, and even if then action is not taken, to file a police complaint in terms of decision of the Honorable Apex Court in Priyanka Srivatsava versus so on. So reserving such liberty, petition stands disposed.
Great.
Number 7.
Petitioner is the life member of the one Kalidasa Vidyavartaka Sangha. Kalidasa Vidyavartaka Sangha is election conducted by the 19 to 24. Lapse of 2 years, not conducted any election. The direction the election.
When was the last election conducted?
2024 last.
Term of the ಎಷ್ಟು?
5 years.
Bylaw ಎಲ್ಲಿದೆ?
5 years.
ಮತ್ತೆ 27 ವರೆಗೂ ಎಲೆಕ್ಷನ್ ಹೆಂಗೆ?
Yes, 2019 to 24.
Bylaw ಎಲ್ಲಿದೆ?
Bylaw.
Which is the applicable bylaw?
15 to 34 page. Annexure B 15 to 34 page number.
The relevant bylaw ಎಲ್ಲಿದೆ?
Yes. Yes, same.
Term of the office bylaw ಯಾವ್ದಪ್ಪ?
15. Page number 15.
5 years. So last election was conducted in 2019.
19, yes.
10/3/2019. And AGA accepts notice for respond number 1 to 3, issue notice to respond number 4 and 5. And AGA to secure instruction, make a submission as to what are the steps proposed to be taken in terms of the complaint filed by the petitioner. In as much as from the records, it is clear that the last election having occurred on 19/3, on 10/3/2019, the term of the office as per the bylaws is only for a period of 5 years. And the submission of learned counsel for the petitioner is from the year 2024, no elections have been held, which would come within the purview of section 27, capital A, 1A of the KSR Act 1960, released on 21st September.
Also not to continue the body.
I think, Madaka.
Yes.
First we'll have to see that.
Yes.
Serial number 8, Suvarna Lakshmi.
Yes.
Appear for the petition in this case, my lord. My lord, there is a family emergency for the council on record in this case, my lord. I request you to have it tomorrow. My lord. I genuinely apologize for the inconvenience.
Rejected and appeal is pending.
Appeal is filed.
Please.
And AGA accepts notice for respond number 1 to 3 at the request of counsel for the petitioner, released tomorrow.
Much obliged.
Serial number 9, Rajwal BS.
Lords, 9, I appear for the petitioner. Lords, I'm challenging an order of externment passed under section 55, Lords, of the Karnataka Police Act. Lords, what happens is, Lords, an order is passed on 13/7/2026. Lords, I am informed of the order on 3/8/2026. Lords, same day I get arrested. I am externed to Gangavati Police Station. Lords, the interim.
Without appeal remedy being provided.
Lords,
Appeal period only, you are not provided an appeal period.
Lords, I was not informed of the order in the first place.
You are not served with notice.
I was not served with notice. Lords, may kindly see operative portion of the order.
Page 29.
Lords, page 29 may kindly be seen. Lords.
Yes.
Lords, it says that ಹಾಜರಾಗಿ ಹೇಳಿಕೆ ನೀಡುವಂತೆ ಹಾಗೂ ಈ ನ್ಯಾಯಾಲಯವು ನೀಡುವ ಪ್ರತಿ ಉತ್ತರ ವಿಚಾರಣೆಗೆ ತಪ್ಪದೆ ಹಾಜರಾಗುವ ಬಗ್ಗೆ ಕೂಡ ಇದೇ ಕಾಯ್ದೆ ಕಾಲಂ 58 ಅಡಿ ಅಪಾದಿತನಿಗೆ ಎಲ್ಲ ಅಂಶಗಳ ಸಮಗ್ರ ವಿವರದೊಂದಿಗೆ ನೋಟಿಸ್ ನೀಡಿ ವಿಚಾರಣೆಗೆ ದಿನಾಂಕವನ್ನು ಗೊತ್ತುಪಡಿಸಿ ದಿನಾಂಕ 12/6/25 ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಲು ಪ್ರತಿವಾದಿಗೆ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ನೀಡಿದ್ದು. They mentions that a notice was issued. When the notice was issued is not mentioned in the order. 12/6/2025 is the date on which they say that I was summoned to appear. However, Annexure B may kindly be seen. It's at page 32. On 7/8/2025, what happens is an order of externment is passed against me. That order is challenged by way of filing a criminal revision petition before courts in Mysore. There was a stay operating, and that order came to be. This petition was dismissed as having become infructuous because the order dated 7/8/2025 was lapsed due to efflux of time. On 29 June 2026, this order was passed. So throughout till 29 June 2026, a stay was operating against the externment of the petitioner.
The order of the deputy commissioner was confirmed.
On 7/8/2025,
your revision petition was dismissed and the order was confirmed. There's no further notice which is required to be issued.
Subsequently on 13/7/2026, an order is passed without issuing a notice to me.
Why is it required? Because it's confirmed. The order is confirmed, not set aside, Allah. It's not a remand.
On 7/8/2025, that order was operational. From 7/8/2020. Please,
that challenge to it has been dismissed.
That order was operational only for a period of 6 months. 7/8/2025's order.
That is your interpretation to it. Because it was stayed for that period of time, then later
Please.
It has been dismissed. This is not an order of remand. This is an order of dismissal.
It was dismissed.
Confirming the order. Why is it required that you should be issued a notice?
Now, that is one of my ground is that the second ground is under section 55 of the act, there are 3 provisions. A, B, C, which says that which provision it has to be invoked is not
All
specified.
that you had challenged, all that has got rejected.
Please, my lords.
You cannot again come in a writ petition after that challenge which has been made under appeal.
My lords, I may be permitted to go before the appellate court, my lords. My lords, but here what has happened is,
Appeal dismiss ಆಗಿದೆಯಲ್ಲಪ್ಪ.
my lords, appeal dismiss ಆಗಿಲ್ಲ. Appeal file ಮಾಡಿರಲಿಲ್ಲ, my lords. First, ಈ criminal revision petition ಏನ್ file ಮಾಡ್ತಾರೆ, it was not before the, not under section 60.
And AGA accepts notice for respondent 1, 2, 3. Petitioner is before this court seeking for the following leaves. Against the order of extendment, the petitioner had filed a revision petition under section 438 of the Bharatiya Nagarika Suraksha Sanhita 2023 in criminal revision petition number 152 of 25, which came to be dismissed on 29 June 2026. Confirming the order of externment.
My lords, that order was not confirmed. My lords, they say that an appellate remedy is available. So,
Please read the operative portion. Second para of the operative portion.
please, my lords.
ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
My lords, it is hereby confirmed ಅಂತ ಹೇಳ್ತಾರೆ. But my lords, may kindly see para 15, my lords.
What is the operative portion?
My lords,
Your
it says that the
submissions
order
are
of the
different.
respondent, deputy commissioner,
You can
police.
submit everything, but finally the order is what matters.
Please, my lords.
Confirming the order of externment. After arguing for some time, learned counsel for the petitioner seeks liberty to withdraw the above petition with liberty to file an appeal under section 58, reserving such liberty.
My lords,
petition stands disposed.
in the meantime, my lords, I may be permitted to reside in Mysore, my lords, please.
You have failed in two this one, we can't do that.
Serial number 10. Shankaren, what?
I appear for the petitioner, my lord.
Yes.
That the writ petition is filed questioning the order appointing administrator.
I think the statement that copy has been served.
Then IA 1 of 26 is allowed. The M. Keshav Reddy who has filed caveat for respond number 6 and 7.
6 and 7.
Accepts notice for respond number 6 and 7. One statement of objection filed by respond number 6 and 7 is taken on record. It is stated that the said copies have also been served on the counsel for the petitioner, who duly acknowledges same. Learned AGA accepts notice for respond number 1, 2.
1, 2, 4.
4.
3 also.
Three
no?
also, man.
3 is is an officer
8.
named by person.
What about 3?
And 5 and 8. no?
3 is also government officer, of course, they have named.
Will accept notice?
Yes, my lords.
My lord, I undertake to file wakalat for R5.
R5.
Returning officer.
ಅದೇ
ನೀವೇ ಇಲ್ಲಿ ಬರ್ತೀರಾ?
Returning officer.
No, no, might be my officer, my lords. It's
That
an
is why we are
administrative-
looking at you.
That's what I was trying to find out from
For you to sort
learned
out.
friend. The Tahsildar was my officer.
And AGA accepts notice for respond number 1 to 5 and 8.
Please.
Registries direct print his name as such. Yes,
Yes.
Mr. Arnand.
But the society term came to an end in April 26. And we wrote a letter even before the term came to an end on 13/3/26 that there is a sports meet going on. We allow us to conduct the election in September. Kindly go to my lord, page 50.
Yes.
Page 50.
Same.
This is on 13/3/26. There we wrote saying that because of some difficulties, we will conduct election in
So what
September
provision
26.
can they extend the period?
Yeah. ಸೆಪ್ಟೆಂಬರ್ 26ರ ಮಾಹೆಯಲ್ಲಿ ಕಲ್ಪತರು ವಿದ್ಯಾಸಂಸ್ಥೆಯ ಸರ್ವ ಸದಸ್ಯ ಸಭೆ ಕರೆದು ಆಡಳಿತ ಚುನಾವಣೆ ಮಾಡಲು ಅಲ್ಲಿವರೆಗೆ ಕಾಲಾವಕಾಶ ನೀಡಬೇಕೆಂದು ಕೇಳಿರುತ್ತೇವೆ.
ಯಾವ provision ಕೆಳಗೆ? What provision do they have the power to extend?
Generally, Lord, under the provision of AGM, conducting of AGM, under section 11, he has the
Yes,
power
sir.
to extend the meeting by around about 6 months. Now, anyhow, Lord, that apart from that, thereafter, Lord, they appointed at page 122. Page 122. They said that it is come to an end, so I am appointing one, that is the fourth respondent, to conduct inspection and give a report. Third respondent.
122.
Yeah. Page 122.
Yes.
Now on that, my lord, on that a report is given to the government at page 128 by the registrar on 4/8. On, I'm sorry, on 14/8.
14/8.
14/8.
Yes.
Well, by that time, the calendar of events had already been announced, which is at page 56. On 8th of August itself, calendar of events had been announced. Lord, on the basis of this 14/8 report, on 18/8 at page 184, the administrator has been
8/8
appointed.
is after the report was submitted.
No,
4/8
before.
report was submitted.
8/8,
thereafter-
my lord, is before. 14/8 is the report to the government. 14/8, kindly see at page 128.
4/8 when the report was called for.
4/8, the report was, he was asked to inspect and report.
So after that is 8/8.
Yes, yes, after that 8/8, but even before that on 13th itself, we had indicated that we will conduct election on September. Then, my lord, at page 184, the administrator is appointed on 18/8/2026. After the calendar of events had already been announced on 8/8/26.
Yes.
Now, my lord, the courts have taken the view that there is no 25 inquiry in this matter. He has only conducted a report. Now, before the state government passes an order of appointing the administrator, the state is required to issue show cause notice and thereafter satisfy itself that there is a need to appoint the administrator. No such show cause notice has been issued to us by the state government before appointing the administrator. Lord, kindly, there are similar judgments. Kindly go to page 5. Is the judgment of Justice K.S. Swami, which has been followed. Page 5. At page 7, para 6.
Yes.
The grounds mentioned in the aforesaid clause A, B of subsection 1 of 27A of the Act are not exhaustive. The report made by the registrar under subclause C thereof may be on other grounds other than the grounds mentioned in clause A and B thereof. The state government under section 27A1 of the Act is empowered to appoint an administrator for a society registered under that, either on a report made by the registrar or otherwise, but on inquiry, the state government has to be satisfied that it is necessary in public interest to appoint an administrator. No doubt the registrar has no power under 27A of the Act to appoint an administrator for a society registered under the Act, but he is entitled to make a report to the state government for appointing an administrator to the society. If for the purpose of making such report, the registrar gives notice to the society, calls upon it to show cause as to why action under 27A1 of the Act should not be taken, such an act cannot be held beyond the competence of the registrar. Show cause notice issued by the registrar is only for the purpose of making a report to the state government under 27A1C of the Act, and not for appointing an administrator by himself. Therefore, it is not possible to hold that the notice issued by the registrar is illegal and is opposed to the provision of 27A1 of the Act, even though the report is made by the registrar after affording an opportunity to the society. State government on receipt of such report is still required to afford an opportunity to the society, and it has to be satisfied on holding an inquiry that it is necessary in public interest to appoint an administrator for the society for a specified period, as per the provisions contained in clause E of subsection 1 of section 27A of the Act. As the power to appoint administrator is vested in the state government, the fact that the registrar has given notice before making a report under clause C of subsection 1 of 27A of the Act does not dispense with the inquiry to be held and an opportunity to be afforded to the society by the state government before it decides to appoint an administrator to the society. Therefore, point number 3 is answered against the petitioner. Then the next judgment below, page 9, similar lines, at page 16, ink page 16, para 11.
Yes.
Even otherwise, if there were certain reports adverse to the society, even if a situation for exercise of power under 27 years Act had arisen, government was required to notify the society, should have provided an opportunity as held by this court in the case of People Education Society Supra. In fact, this aspect has been amplified further by a subsequent decision of this court. As such, it will be useful to refer to the case of Bharat Ratna Mokshagundam Vishweshwaraya Education Society, so and so, wherein it is held as under. Even though a report that is on the same lines, that is the extraction of the same observation in the first judgment also blood is by the on the same lines. Now in the present case blood, now we had indicated it is not a case of being unable to hold the election. Kindly see section 27A. Where any society on account of pendency of litigation or otherwise has not held or is unable to hold the annual general body meeting. Now, it was never our intention that we are not holding the election. We initially itself said that there is a sports meet going on, we will hold it in September. Now, after the 18/8 is issued, the state government should have
clause B.
Yes, clause B, my lord, where the term of office of the members of the government body of a society is expired and a new governing body has not for any reason been constituted. Both will have to be read together along with the first clause, where any society on account of or otherwise has not held or is unable to hold, or where the term of office of the society has expired and a new governing body has not for any reason been constituted. Now, in such a case, my lord, it is not mandatory for the government to do it. Now it is a case, my lord, April it has expired. Now we are holding the election in September. There is only a delay. It is not a case, my lord, for years together we have not held the election. Then in such a case, state should be satisfied that this is a case where
that satisfaction is only in respect of clause C, but not for A or B.
No, yes, that is a satisfaction, my lord, which the state government will have to arrive at, having regard to the facts and circumstances of each case. Now, in a case, my lord, where the calendar of events is already issued, election is to be held on 18/8. Now, we are not concerned with the earlier report. On 18/8, the state should have taken into consideration the fact that the calendar of events is already issued.
Subjective satisfaction will only be for C, not for A and B.
No, A and B also.
And the whole purpose of appointing an administrator is to hold the election.
Hold the election, but here is a case
you are
where
doing it. Why appoint administrator?
But here, now kindly see the order passed by the Tahsildar. I mean the government. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಇವರು ಯಾವುದು 27A ನಲ್ಲೂ ಹೇಳಲ್ಲ, B ನೂ ಹೇಳಲ್ಲ. Kindly see the operative portion.
Yes.
Now kindly see the first para also. It is not just on the basis of the not holding the election. Kindly the ನಿಯಮಾನುಸಾರ ಸಂಘದ ಚುನಾವಣೆ ಕ್ರಮವಿಟ್ಟು ಅಲ್ಲದೆ ಸಂಘದ ನಿಯಮ ನಿಬಂಧನೆಗಳ ವಿರುದ್ಧವಾಗಿ ಸದಸ್ಯತ್ವವನ್ನು ಮಾಡಿಕೊಂಡು ನಿಯಮ ನಿಬಂಧನೆಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿರುವ ಬಗ್ಗೆ ವರದಿಯಲ್ಲಿ ತಿಳಿಸಿದ್ದು, ದೂರು ಅರ್ಜಿಯಲ್ಲಿ ಆರೋಪಿಸಿರುವಂತೆ ಅಧಿಕಾರ ಇಲ್ಲದಿದ್ದರೂ ಸಹ ಟೆಂಡರ್ ಪ್ರಕ್ರಿಯೆ ನಡೆಸಿರುವ ಬಗ್ಗೆ ಹೆಚ್ಚಿನ ತನಿಖೆ ಅಗತ್ಯವಿರುವುದರಿಂದ ಸದರಿ ಸಂಘಕ್ಕೆ ಕರ್ನಾಟಕ ಸಂಘದ ನೋಂದಣಿ ಅಧಿನಿಯಮ 27A ಪ್ರಕಾರ ಆಡಳಿತಾಧಿಕಾರಿಗಳು. Now they are also making allegation against the society. It is not a case where they are only saying that on the basis the term is over.
Yes.
So, blood, this is a case, blood, ultimately society has to function in a democratic setup. If it is a case where some deliberately we are not holding the election, then one can understand the appointment. Now, calendar events is already issued.
What provision are you entitled to extend the term?
No, that blood is a difficulties because of that. Blood, there is.
You can create your own difficulties.
No, the intention that is only to show that there was no intention of not conducting of the election.
The only argument that we can consider is that you already issued the calendar of events.
Yeah.
Any other this one, we cannot condone you are not holding the election and saying that I'm holding a sports meet. Tomorrow you'll say I'm holding something else. That way you can you postpone your elections?
No, because of certain exigencies, blood, we are not able to hold election.
There are no exigencies for that.
Blood, is there a need to appoint an administrator after the calendar of events is issued?
That is the only argument.
But
That is the only argument we can consider.
no,
The
that
rest
is
of
an
the
argument
arguments
which
cannot
the
be
state should have considered. They should have heard us. They have not even taken into consideration that calendar of events is issued. Our earlier conduct also that it was not a case of deliberately not holding the election. It only shows, my lord, by conduct that a bona fide conduct on our part. In a case,
Can that be considered? But shows the law for it to be considered. That's what we have been asking you.
therefore, my lord, that is in this background.
My friend has not come across. This point was argued and court has taken the view for 27B notices.
Whether 27A and B is not clear. I understand.
Your first contention that your bona fide extended the period. Under what provision can you extend it? Show the provision.
I am only saying, Lord, that there is, except under section 11, where there is a provision to extend the period for holding the general body meeting. Kindly see section 11. Subclause 11(2) proviso.
So has the registrar granted you the permission?
He did not answer. He did not consider our. We had
So you
submitted the
assume
request
that he
that
has
is not
granted.
even considered.
You assume that he has granted.
I am not assuming. I am only saying that at the beginning itself, we made a request that we will conduct it. That has not been rejected. Our request
Has it
saying,
been accepted? It requires a positive order.
correct. But he should either say yes or no, my lord. If he just keeps it, sits on it and then say, no, you have not held the
What
election.
did you do after that?
What?
That he has not passed order on even Madhuri.
I understand. But only it shows, my lord.
Maunam Sanmati
My lord,
Lakshmi
ultimately, society has to administer on its own. Now, in a given case, my lord, let us say a election has not been held for years together, one can understand. In a case for 2-3 months, my lord, election, August itself, we have issued the calendar of events. Now, it is a case where the appointment of administrator is being done after the election process has commenced.
Yes, anything else? Ashtana? Yes.
In the impugned order, second paragraph can be seen. ಸರ್ಕಾರಿ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಸಂಘಗಳ ಜಿಲ್ಲಾ ನೋಂದಣಿಕಾರಿ ತುಮಕೂರು ಜಿಲ್ಲೆ
Mike.
Page number 184, my lords, annexure U,
Page number
second
184.
unnumbered para.
Yes.
ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಹಾಗೂ ಸಂಘಗಳ ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿ ತುಮಕೂರು ಜಿಲ್ಲೆ ತುಮಕೂರು ಇವರ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿದ್ದು, ಕಲ್ಪತರು ವಿದ್ಯಾಸಂಸ್ಥೆ ತಿಪ್ಟೂರು ಸೋನ್ಸೋ ಈ ಸಂಘದ ಆಡಳಿತ ಮಂದಿ ಅವಧಿಯು ಮುಕ್ತಾಯ 21/4/26 ಮುಕ್ತಾಯಗೊಂಡಿದ್ದು, ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಆಡಳಿತದಲ್ಲಿ ಮುಂದೆ ಬರೆಯಲು ಅಧಿಕಾರವಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸದರಿ ಸಂಘಕ್ಕೆ ಕರ್ನಾಟಕ ಸೋನ್ಸೋ 27A ಆಡಳಿತಾಧಿಕಾರಿ. Yes, my lord. 27 clearly reads, my lords, to say the term of the office of the members of the governing council has expired and a new body. The question of the expiry happened in April 21st of April 26. At Tadnantra, nobody will have power to even propose for a calendar of events to say that somebody has promulgated this to say that we will hold elections on. They don't have powers once they have expired.
For in March, what did you do on that?
No, we got a complaint only in the month of, may just submit this, my lords.
They
A
requested
complaint was
on
given to us on 30th of July, my lords. Till then, we were also.
13/3/26, they sent a letter to the registrar to extend the period, which you could have extended under proviso to subsection 2 of section 11.
Please, my lords. But the question of expiry of an extension wouldn't come because of the fact that once the 5 years period as per their bylaws expires, they can hold elections only prior to the 5 years expiry and not subsequently.
That is why we asked Mr. Arnandi also the date.
I understand, my lords.
The letter was sent prior to the expiry.
Yes.
Why did you sit on it?
I have to get instructions on that, but nonetheless, otherwise, my lords, the fact remains that once the expiry happened, for them to now rely on a calendar of events which has given subsequently in August will not lie because they don't have powers to even issue that. Our
Anyway, now whole purpose of appointing an administrator.
only to conduct elections. We have nothing else.
Already calendar of events has been issued.
Please. Adu expire agogide. Calendar of events, what dates they had proposed, that's expired.
Where is that?
22/8 was supposed to be the
Okay.
elections which were supposed to be held.
Election to be held on 6/9.
Page
which
number
will not be held.
56
Before that
annexure
only
F.
the Page 156. Vote is supposed to take place on 6/9. September.
What all has happened in this, has it been given effect to?
This is given effect
Annexure
on 6/9, my lord, is the date of voting. Kindly see.
Voting, but what about the nominations?
Nomination, my lord, kindly see on 13/8/26. ಸದಸ್ಯರುಗಳು ನಾಮಪತ್ರಗಳು 13/8. That has commenced. We have received nomination paper also.
How many nominations have you received?
That, my lord, that I don't have.
You won't be aware.
Because ನಾಮಪತ್ರವನ್ನು ಹಾಕೋದಕ್ಕೆ before 18/8 was the last date. 18/8 itself they have passed the order. Last date for submission of nomination 18/8. The impugned order is passed on 18/8 itself. They have come and locked the door on 18/8 itself.
So item number 3, 4, 5 have not happened.
Has not happened because the impugned order is on 18/8. And even before we could receive the order, immediately evening itself, they came and Lord, there are about six nomination is received for the post of president, and for vice president about 15 names have been received. Secretary also another 15 names have been received.
Yes.
That's all, Milords. In so, sorry. ಇಲ್ಲ ಮುಗಿಸಿದ್ರು.
ನೀವು ಶುರು ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ ನೀವು ಮುಗಿಸ್ಬಿಡಿ.
Milords, my only submission is this, Milords. On 30th of July, we received a complaint based on which 4th we have issued a notice, and subsequently a report is there prior to passing of this order under 27A, appointing an administrator. Milords. We will conduct the elections, Milords. 1 lakh and odd members are there is what I am told, Milords. If Milords give me some time, I can get instructions next week sometime as to what could be our calendar of events, which the administrator will look into it, and I'll place it before Milords.
Yes, Mr. Patil.
Madam.
We also came to know about it after this bylaw 5 ದಲ್ಲಿ.
Yes.
Governing council members grant patrons who donate 20,000, patrons who donate 2,000, donors who donate 5,000, life members who donate 2,000. They will be the governing council members. Now, without there being an amendment, the voter list as made by them is, the Lordship may kindly take the objection statement given by.
Objection statement. Yes.
Page 3, para 10.
Yes, please.
First one is as it is in the bylaw. Now the change made by them without there being amendment. Managing committee members who pay an amount of 1 lakh, governing council members who pay an amount of 25,000, life members who pay an amount of 5,000. And recently they have created another class of membership from amongst the landowners who have sold their land in favor of the society. Your Lordship may kindly turn to annexure R5, page 16. That is the voter list published by them.
Yes.
Managing committee, annexure R5. 1 lakh, 1 lakh ಗಿಂತ ಹೆಚ್ಚಿಗೆ ಡೊನೇಷನ್ ಕೊಟ್ಟವ್ರನ್ನ ಮ್ಯಾನೇಜಿಂಗ್ ಕಮಿಟಿ ಮೆಂಬರ್ಸ್ ವಿತ್ ಎ ವೋಟಿಂಗ್ ರೈಟ್ ಅಂತ ಒಂದು ಕ್ಲಾಸ್ ಮಾಡಿದ್ದಾರೆ. Then your lordship may kindly see page 30, 93 members ಆ ಕ್ಲಾಸ್ ನಲ್ಲಿ ಸೇರಿಸಿದ್ದಾರೆ. Then page 30, governing council members ಅಂತ ಹೇಳಿ ಒಂದು ಕ್ಲಾಸ್ ಅನ್ನು ಮಾಡಿದ್ದಾರೆ. That class
is 25,000.
contains about 135 or they have 117. Then another clause of 6 members ಅಜೀವ ಸದಸ್ಯರು ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೇಜ್ 49 ನಲ್ಲಿ ಜಮೀನು ನೀಡಿದವರಿಗೆ ಸದಸ್ಯತ್ವ ನೀಡಿರುವ ವಿವರ 49 ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ. This is not what the bylaw provides. This we came to know after this administrator this thing and getting the body the final voter list publication. This clause, creation of this clause and enrolling of members prior to election, I am not sure about the dates on which they have done it. According to us, prior to election, these dates have been.
AGM has not been called for amendment at all.
No, it's not amended. ಮೊದಲಿನೊಳಗೆ patron members would be the direct voters. They will be members of governing council and they will be direct voters for the election of office bearers and managing committee. ಈಗ patron members ನ maybe change ಮಾಡಿ 1 lakh ಕೊಟ್ಟರು patron members ಅಂತ ಹೇಳಿ ಮಾಡೋದಕ್ಕೆ, that's what they might have thought, but that's not an amendment carried out anywhere.
Okay. Yes.
This is something which continuation of election on the calendar issued by them may not be a circumstance available under this society. This thing they may have to do a voter list.
So the electorate is itself has
they will
got
have
changed.
to do a voter list afresh.
So far as my lord's question to say why we had not considered their request for extension, my officers instruct me to say that there is no provision under law for any extension beyond the 5 years period.
Proviso to subsection 2 of section
No,
11.
lords, that is only in cases where, when I read that.
We are all surprised, but it is there.
The first annual general body meeting.
That is subject to
For any special reason, extend.
clause 5, my lords. Clause 5, once the administrator gets appointed.
No.
But the first proviso reads, provided that for reasons to be recorded in writing, the state government may, by like order, extend either prospectively or section 11, I'm sorry.
11(2). The first proviso to subsection 2 of section 11.
Okay, the yelaya anta.
Annual general body and the election body.
It only refers to the AGM and not for the elections as such. Generally,
are
elections go with the AGM, lords, that's a different issue.
Elections are held in the AGM or SGM.
Distinction is to be drawn whether an AGM can be held other than the time of election also.
But insofar as your allegation as regard membership, Mr. Patil, there is no inquiry which has happened.
There is no
No
amendment of
complaint.
bylaw.
There's no complaint, there's no allegation, there's no inquiry.
In the complaint, there is a reference made. Kindly see, but that is not a reason given by the government for appointing the administrator. But in the complaint that is given, kindly see the letter of 30th July, annexure D1, page 50.
Yes.
50A and 50B ಮಾಡಿದ್ದಾರೆ. Page 50A and
50B, 37. I think there is a typed copy ಇದೆ. That would be
Page 52.
52.
Yes.
ಕಲ್ಪತರು ವಿದ್ಯಾಸಂಸ್ಥೆ ತಿಪ್ಟೂರು ನೋಂದಣಿ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ 5 ವರ್ಷಗಳ ಅವಧಿಗೆ ಚುನಾವಣೆ ನಡೆದಿದ್ದು, ಅವಧಿ ಮುಗಿದರೂ ಕೂಡ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಚುನಾವಣೆ ನಡೆಸಲು ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳದೆ ಅಕ್ರಮವಾಗಿ ಮುಂದುವರಿಯುತ್ತಿದ್ದಾರೆ ಮತ್ತು ಕೋಟ್ಯಾಂತರ ರೂಪಾಯಿಗಳ ಟೆಂಡರ್ ಕರೆದು ಹಣ ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಸಂಘದ ನಿಯಮ ನಿಬಂಧನೆಗಳಿಗೆ ತಿದ್ದುಪಡಿ ಮಾಡದೆ, ಸಕ್ಷಮ ನೋಂದಣಾಧಿಕಾರಿಗಳಿಂದ ಅನುಮೋದನೆ ಪಡೆಯದೆ, ಸದಸ್ಯತ್ವ ನೀಡದೆ, ಸದಸ್ಯರಿಂದ ಲಕ್ಷಾಂತರ ರೂಪಾಯಿಗಳ ಹಣ ಪಡೆದು ವ್ಯವಹಾರ ನಡೆಸಿರುತ್ತಾರೆ.
ಅಷ್ಟೇ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ದಂಗೆನೆ ಇದು ಮಾಡಿದ್ದಾರೆ.
ಡಿಫ್ರೆಂಟ್ ಕ್ಲಾಸ್ ಮೆಂಬರ್ಶಿಪ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಏನು ಅಲಿಗೇಷನ್ ಇಲ್ಲ.
ಅಲ್ಲ, ಆವಾಗ ನಮಗೆ ಪೂರ ಗೊತ್ತಿರಲಿಲ್ಲ. ಈಗ ಅವ್ರದ್ದು ವೋಟರ್ ಲಿಸ್ಟ್ ಇಶ್ಯೂ ಮಾಡಬೇಕಾದ್ರೆ ದೇ ಹ್ಯಾವ್ ಮೇಡ್ 3 classes. ಮ್ಯಾನೇಜಿಂಗ್ ಕಮಿಟಿ ಮೆಂಬರ್ಸ್ ಇದು
ಸದಸ್ಯತ್ವ ನೀಡಿರುತ್ತಾರೆ.
ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ
ಸಂಘದ
ಅಫ್ಕೋರ್ಸ್ ಸಂಘದ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಸದಸ್ಯತ್ವಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದರೂ ಕೂಡ ಯಾವುದೇ ಕ್ರಮ ವಹಿಸಿರುವುದಿಲ್ಲ. ಸ್ವಜನ ಪಕ್ಷಪಾತ ಮಾಡಿ ತಮ್ಮ ಕುಟುಂಬದವರು ಸಂಬಂಧಿಕರಿಗೆ ಮಾತ್ರ ಸದಸ್ಯತ್ವ ನೀಡಿರುತ್ತಾರೆ. But that creation of managing committee, a class of members like managing committee and governing council was something which was not known to us till we got this voter list.
Anything else? Yes, Mr. Arnoldi.
Lord, this report, on the basis of which it is made, now the allegations are in relation to this bylaw and other things. So naturally, this is not an order traceable only on this issue because there are other allegations are also being made. Kindly see page
Have you carried out the
128.
amendment for this change in membership?
What?
Have you carried out the amendment for the change in membership? Has the AGM approved it?
Lord, whatever amendment they have made, it has to be done as per the approved bylaw only.
Amendment ಆಗಿದೆಯಾ ಅಂತ ಫಸ್ಟ್, ಆಮೇಲೆ as per the bylaws in second question.
ಅದಾಗಿಲ್ಲ.
The Patil's submission is that there is no amendment which has happened, and the petitioner has classified the membership into 3 further categories.
Amendment approval ಆದಾಗಿಲ್ಲ.
ಮತ್ತೆ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ?
Lord, what I would suggest is, if they can always say, Lord, do as per, they can always issue direction saying that the manner in which election to be held, that is all.
We were with you on point number 1, but with this membership being done like this, there's no confidence in the society.
Lord, in so far as conducting of the election is concerned, if the registrar is of the view that the bylaw is not approved, he can always say, no, you have to conduct election in this manner according to the bylaw.
You
But
want to conduct election as per your calendar of events,
as
per which you have published the list of your list of electorate. That cannot be continued.
Lord, allow us to conduct election in the according to the bylaw itself.
Does not inspire confidence. You wrote a letter, you did not wait for it, you postponed.
Lord, now what they would do is, in respect of the membership list itself, they will alter and conduct election. That is the difficulty because of some political issues. That is why they do not want to
indicate that your client is altered.
Lord, what so far as the creation, this publishing of the voters list and other things, they can always say, publish it in this particular manner and conduct election.
When will you get back? Next week?
Next week, Malad, next Monday, Tuesday, Malad. Tuesday, Malads may have it so that I can get some.
The submission of Shri Ashok Arnoldi, learned senior counsel appearing for the petitioner, is that though the term of the management governing body na management committee na
Office bearers and managing committee.
Office bearers of the first of the petitioner society was coming to an end in April 2026. A request has been made by the governing body for extension of time to conduct the AGM and the elections on 13/3/2026, which could have been considered and granted by the registrar in terms of proviso to subsection 2 of section 11 of the Karnataka Societies Registration Act 1960. Presuming that they were so granted the permission, the petitioner had subsequent. I mean, you're not even done a AGM. How will it get approved? Your whole purpose is to delay the AGM. You're not conducted the AGM. Verify my daily. If it has been approved by the earlier AGM, then we'll consider it. We'll have it on next Tuesday. We are only recording the submission so that it is clear. Presume that such permission had been granted, the petitioners had issued a calendar of events on 8/8/26, detailing out the dates on which the nomination could be, last date of nomination could be filed, that is 13/8/26. The verification and the final election to be held on 6/9/26. His submission is that once a calendar of events had been issued on 8/8/26, the appointment of an administrator under Section 27A of the KSR Act 1960 on 18/8/26, the very last date on which nomination were to be filed, would not serve any purpose since the election process is already going on, and by way of appointment of administrator, the election process will only be delayed, affecting the democratic functioning of the petitioner. Both the learned additional advocate general and additional advocate general appearing for the state, and Sri Jaikumar S. Patil, learned senior counsel appearing for respondent number 6 and 7, who were the complainants, submit that there was a complaint which had been filed on 4/8/26, followed by a further complaint sorry, 4/8 allow. A complaint had been filed on 37/26, followed by another complaint on both are 37. Two complaints were filed on 37/26, alleging that the Mahing committee was governing body was continuing in office beyond the period which it was so for which it was elected, which expired on dated
21/4/2026.
They submit that the term of the governing body expired on 21/4/26, and as such could not continue in office in terms of Section 27 capital A 1 small b of the KSR Act. Sri Jaikumar S. Patil and senior counsel further submits that it is only after the administrator was appointed that it came to light that the membership structure had been changed, inasmuch as the earlier membership structure under bylaw 4 provided for grant by patrons who donated 20,000, page 3 of the statement of objection in Flapper, para 10(1). And as such, he submits that without any amendment to the bylaw, since there is no approval by the AGM which has not been conducted, the holding of the election by the existing governing body will not be as per the bylaws, and as such, that elections cannot be held in that manner as per the calendar of events published by the petitioner, since it would be in violation of the bylaws. The additional advocate general submits that the state does not want to delay the holding of the elections. If the matter is taken up next week, he would place on record the calendar of events and the methodology of conducting of the elections as early as expeditiously and early as possible. Shri Ashok Karnali, learned senior counsel, seeks for a week's time to place on record whether the amendment has been placed before the AGM for approval and thereafter has been approved by the registrar and brought into force as regards the changes made in the membership structure, there being no dispute as regard the change having been made. Relist on 1st September.
Great, Vinod.
Serial number 11, Naveen J, General Perul.
General learned AGF for respondent, relist on 27th.
Serial number 12, Somanna JP.
Yes, Somana. Anil.
That's, I'm challenging the section.
Externment.
Externment notice issued by
Where
the.
you issued notice?
I'm sorry, my lord.
Where you issued notice under 55.
No, my lord. Notice is issued under 58, my lord. I'm challenging the notice that is issued to me, my lord.
You are challenging the notice. Karana. You reply to it.
My lords, my contention is that, my lords, the allegation in the notice is that, my lords, that cases were registered against
Not
me.
decide the merits of the matter and a writ petition when you have the show cause notice. Only when it is without jurisdiction, we can interfere.
My lords, I may be permitted to withdraw, my lords.
And AG accepts notice for respondent 1 to 3. Petitioner is before this court seeking for the following release. After arguing for some time, learned counsel for the petitioner seeks permission to withdraw the above petition with liberty to reply to the show cause notice dated 7/8/26 at Annexure A, reserving such liberty. 10/8 ಆಗೋಗಿದೆಯಲ್ಲಪ್ಪ. Please reserving such liberty and permitting the petitioner to reply to the said show cause notice on or before 29th August 2026. The petition stands disposed. If such a reply is submitted by 29/8/26, the respondents are directed consider the said reply and pass necessary orders in accordance with law.
Grateful.
13, K.S. Narayan Swamy.
To Narayan Swamy.
In this case, my lord, serial number 13.
Yes.
Well, in the present petition, I have challenged a tender notification of the respondent as well as the notice issued by the respondent, my lord. The petitioner is a tenant under the respondent institute for a vacant space, my lord. The petitioner himself have built a Nandini parlor therein and run a Nandini parlor therein, my lord. And thereafter, without issuing a notice earlier, the respondent issued a tender notification of a similar tender notification, which I have challenged in a writ petition before this honorable court, my lord. Kindly see annexure L, my lord, page number 41. Issued a tender notification. I have challenged it before this honorable court, and this honorable court has stayed the tender notification at annexure L, my lord. Page number 41. And the said writ petition is still pending consideration, my lord. When this interim order is in subsistence, issued a very similar tender notification at annexure M, my
And that
lord.
was stayed because your lease was there in force till October 25.
Please, my lord.
How do
It
you have
is
the lease
even,
in force?
my lord, even though they have to evict me, my lord, they have to go through the due procedure of law, my lord.
They have
They
issued the
cannot.
tender. Your lease is only till then. Your term has come to an end. You cannot
My
hold
lord,
on to a
then they have
public
to issue
property.
notice under the Public Nuisance Act, my lord. Then they have to go through the procedure of law. Then only they can evict me, my lord. Because even the tender, even the agreement is only for a vacant space. I have built the Nandini parlor there in investing my own money, my lord. As per the agreement terms also, I have to hand over the position vacantly, not in terms of the shop, my lord. So they have to issue notice and
We'll ask
go through
them
the
to
procedure.
initiate this. You can't be holding on to public property like that. Kidwai Memorial yaru?
Piyush Kumar Jain.
Hmm?
Piyush Kumar Jain.
Piyush Kumar Jain for respondent. Connect the above matter with WP number 1707 of 26. The submission of learned counsel for the petitioner is that though the lease agreement came to an end in October 2025, no action has been taken under the Public Premises Act against the petitioner. Without such action having been taken, a tender has been issued for the purpose of operating the Nandini milk parlor which has been constructed by the petitioner. In that view of the matter, the respondents, though shall go on with the tender, the finalization tender shall be subject to the result of the above petition. It is made clear that the above order will not come in the way of the respondent initiating proceedings under the Public Premises Act, released on 15th September.
Bless me.
14, Chidambara GS.
Case.
And Annexure K endorsement issued by the respondent declining to delete the entry in the encumbrance certificate, entry regarding agreement for sale. What has happened is an agreement, registered agreement was entered into between Satish and original owner of the land, Sushilamma, as per Annexure A. Specific performance suit was filed as per Annexure B. It was partly decreed in respect of earnest money. Specific performance dismissed the suit. During the pendency of suit,
Is there any appeal filed?
No appeal has been filed. You last may kindly see observation in the.
Make them a party.
Please, I will implement.
No, even
You
apart
last may
that,
kindly
Madam,
permit me, then.
they are seeking deletion of entries of a registered instrument.
It can't
Which
go
is-
away.
It can't go, it stays there, the decree prevails.
Decree only in
Written-
respect of earnest money. Decree for specific performance dismissed.
If you have a sale deed in 1970 and subsequently somebody buys in 76.
Please.
And somebody else buys in 88 and somebody buys in 2000. Can the person buying in 2000 say all the other entries prior to that have to be deleted?
My request is only in respect of agreement for sale.
There was
cannot-
an agreement of sale. It has been registered.
Registered agreement, but now in view of this judgment, an observation of the.
So you move the court saying for registration of the decree. You can register the
Register
decree.
decree. You can register decree.
My difficulty is I am not the party to the suit and I am the subsequent purchaser. And those parties are now not ready to come forward for cancellation because they have settled the dispute between themselves.
You can move the court. We can't advise you, but we can't delete this. You can avail of such remedies as are available. But how will it be deleted?
Now
It's a
I can't take loan on this property and
And
offer it.
AGA for respondents.
Last
Petitioner
may
is
kindly
before this court.
liberty to
Liberty.
pay.
Petitioner is before this court seeking for the following leaves. If you were a party to that agreement, making them a party here, then we could have asked them to execute a cancellation.
Cancellation deed.
Since you are not a party and here there's no need to make them a party. You will have to move that.
But may I make one submission? If Lordship permits, I will implead them and take out notice in the event they have no objection.
Agallappa.
Please.
They'll
Inquiry
have
as
to-
to.
You'll have to examine the law on the point. You have to register the decree.
Only
How to do
by
it, you examine. Petitioner is before this court seeking for the following leaves. The petitioner claims to be a subsequent purchaser of the property in survey number 56/2, situated at Ubrani village, Ubrani Obli, Channagiri Taluk, Davangere. The submission is that prior to the purchase, there was an agreement of sale entered into by the original landowner with certain others, which, as regards which a suit for specific performance had been filed, which came to be partly decreed directing the refund of the earnest money and denying the relief of specific performance on 2nd April 25 in OS number 60 of 23 by the senior civil judge and JMFC Channagiri. The subsequent thereto, the petitioner having purchased the property subsequent thereto, the petitioner had requested the sub-registrar to remove the details of the registered agreement of sale entered in the encumbrance certificate. Same not having been done, the petitioner is before this court seeking for the aforesaid relief. An encumbrance certificate records all the transactions which have occurred in respect thereto. No entry in the encumbrance certificate can be deleted at the request of any parties, even if it were to be even if such party had purchased the property subsequently. It would be for the petitioner to avail of such remedies as are available, including the registration of the decree in OS number 60 of 2023. Reserving such liberty, the petition stands disposed.
15, other comment?
1 and 2 are allowed. Yes.
Petitioner is the owner of a site in a layout developed by respondent number 4. Respondent number 3 is a society that is registered under the 1960 Act. And this society is now trying to administer the layout and collect maintenance.
You are for 4.
4, the developer. 3 has formed a 3 is the society. Certain plot owners have come together, formed this society and compelling me to pay maintenance. And this is a plotted layout, not even an apartment.
What is Annexure D?
Annexure D is the letter given by the Deputy Registrar Societies.
Page number?
Not page number, your lordships will get it. 38 and 39. Your lordship see 39, lord. The last 2 lines. It is on the basis of this letter that they are coming to me with demands to pay the maintenance.
When was it registered?
Lord, after your lordship's judgment in Sharmishta Nag on 33/9/24. Your lordship judgment in Sharmishta Nag was 28/24, in which there was a direction to issue a circular. This is on 3/9/24. The letter is given on 6/8/25, expressly authorizing them to collect maintenance for a plotted layout.
DGA accepts notice for respondent number 1 and 2. She so and so accepts notice for respondent number 4. Issue notice to respondent number 3, returnable by 28th September. In view of the decision of the Honorable Division Bench of this court in WA number
PDB Celadon, WA number
914. Number kodabeku.
Different. I'll get that.
So and so. The respondent number 3 is restrained from collecting any maintenance charges or the like, since the Honorable Division Bench has categorically held that a society registered in Societies Registration Act 1960 cannot have as one of its objects the maintenance of an apartment complex and or layout antilla adರಲ್ಲಿ.
Layout illa, completely without jurisdiction. Apartmentally agila, because in apartments what happens, there are these common amenities.
That judgment only referred to
apartments.
Yes. It did
So
not refer to
that analogy will have to be extended to layouts.
maintenance of apartment complex, which would also equally apply to a layout which has been formed, since the purpose of collecting maintenance charges for maintenance of an apartment complex would stand on the same footing as that applicable to a layout, and that cannot be an object under the KSR Act 1960. Process fee and copies to be furnished by end of day 25th August, failing which the interim order will stand automatically vacated. The AGA is direct to secure instruction as to how a registration of respondent number 3 has been carried out on 6/8/25, despite the direction which had been issued by this court
In Sharmishta Nag,
so and so on so and so.
I'll hand it over. I'm so grateful.
1 and 2 of 26 allowed.
Yeah, ಕೊಟ್ಟಲ್ಲ 28/9. ಇದೆ. ಇದೆ ರೀಚ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇಲ್ಲ. ನನಗ್ ಗೊತ್ತಿಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾರಲ್ಲ advocate ಹೇಳ್ತೀನಿ ಅಂತ. ಅದು ನಾಳೆ ಸಪ್ರೇಟ್ ಆಗಿ. List number 1, serial number 16, Navina Jia.
Yes. Annexure M is there in the original petition? Annexure M is K. Where is Annexure M? Page number 2 of 26. Mark ಮಾಡಿಲ್ಲಲ್ಲಪ್ಪ ಯಾವ್ದಿದು ಅಂತ. Which is Annexure M? I number 3. I number 3. What is IA 3? ಇಲ್ಲಿ 2 ಅಂತ ಬರ್ತದೆ. IA 3 for amendment. 4 for ಕೊಡಿ. ಅದು ಕೊಡಿ. ಮತ್ತೆ you are not even marked it. Please ಕೊಡಿ ಅವ್ರಿಗೆ. The council, you can't be doing like this for this is the 4th time. ಅದಲ್ಲಪ್ಪ Annexure M ಅಂತ ಬರೀರಿ ಅದ್ರ ಮೇಲೆ. ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಇದೆಯಾ?
Dispensation.
including the
Yes.
Regarding the including application, my lord, I have no. That will be allowed.
Amendment also will allow.
Amendment of
You
pay
can make your submission on that.
Then I'll have to file my statement of objection.
31st ಏನೋ last date ಇದೆ ಅಂತಪ್ಪಲ್ಲಪ್ಪ.
That's seeking cancellation of a notification of 86. We have to file a.
Been telling him last 3 weeks he's been delaying the matter.
I really have it on.
ಕೊಡಿ. This is 94. Where does it say 86 is cancelled? What is the methodology of calculation ಇದರಲ್ಲಿ? Calculation of income ಏನಿದೆ ಇದರಲ್ಲಿ? ಇದರಲ್ಲಿ ಏನಿಲ್ವಾ? So which is the notification which is applicable as on today? Now, if you are referring to 86 order, that order will have to go.
No, but 86, 86 order it said the amount was fixed. 2002 we followed 88. And the fixed at 8 lakh, saying the income.
86 ರದ್ದುಪಡಿಸಲಾಗಿದೆ ಅಲ್ಲ.
ಇದು my lord, I'll have to verify on this thing. What my lord, what is it?
If it is.
The date. I think first is the date. I can understand. I have to find the SOV. We'll find the SOV.
Even this application cannot be considered if 1984, 86 has been already cancelled. There is no question of quashing.
It says ಮೇಲೆ ಒಂದು ಹೋದಾಗ ಆದೇಶವನ್ನು ಹೊರತುಪಡಿಸುತ್ತಾ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡು ಮತ್ತು ಪಂಗಡ ಮತ್ತು ಇತರ ಹಿಂದುಳಿದ ನೇಮಕಗಳಲ್ಲಿ ಉಳಿಸಲಾಗಿರುವ ಪರಿಶಿಷ್ಟ ಮೀಸಲಾತಿಯನ್ನು ಜಾರಿಗೆ ತರಲು ಈ ಕೆಳಕಂಡ ಆದೇಶವಾಗಿದೆ. ಅತ್ಯಂತ ಹಿಂದುಳಿದವರು, ಬಹಳ ಹಿಂದುಳಿದವರು ಮತ್ತು ಕಸುಬಿನ ಮುಂತಾದ ಸಹ ಸಮೂಹ 4ರಲ್ಲಿ ಓದಲಾದ ದಿನಾಂಕ 2019 ಸರ್ಕಾರಿ ಆದೇಶದಲ್ಲಿರುವ ಅರ್ಥವನ್ನೇ ಹೊಂದಿರುತ್ತದೆ. ಸಮಾಜ ಕಲ್ಯಾಣ ಇಲಾಖೆ ದಿನಾಂಕ 20 ಏಪ್ರಿಲ್ 2019 ಆದೇಶದಲ್ಲಿರುವ ಅನುಬಂಧವನ್ನೇ ಹಿಂದುಳಿದವರ ವರ್ಗೀಕರಣ ಉದ್ದೇಶಕ್ಕಾಗಿ ಅನುಸರಿಸಲ್ಪಟ್ಟದ್ದು. ನೇರ ನೇಮಕಾತಿಗಳಲ್ಲಿ ಮೀಸಲಾತಿಗಳ ಮೇಲಿನ 4 ಮತ್ತು 5ರ ಓದಲಾದ ಆದೇಶಗಳನ್ನು ನಿಗದಿಪಡಿಸಿದ ಶೇಕಡಾವಾರಿನಲ್ಲಿ ಪ್ರತಿಯೊಂದು ನೇಮಕಾತಿಗೆ ಪ್ರಾಧಿಕಾರದಡಿಯಲ್ಲಿ ಪ್ರತಿಯೊಬ್ಬರು ಉನ್ನತಕ್ಕೆ ಅನ್ವಯಿಸತಕ್ಕದ್ದು. 3 and 4, my lord, again 3 and 4 is in 1989 and 1994.
They are also gone.
But it does not say that 12/12/1986 to 86 also.
12 December 1986 first line ಅದೆಲ್ಲ.
First one.
So 86 is gone, 89 and 89, the 289s are gone.
Yes, sir. Then 2002, Malak.
Your order refers to 86.
The order said refers, it is followed in 2000. 86 is 2.5 lakhs. Now we have increased it to 8 lakhs. The income. Now, Malak, we'll have to look into this. We'll also file the statement of opinion.
None of you knows what is the law applicable. How do we decide?
27th.
You issue it subject to the outcome of this petition. You can file your objection. We'll have to decide that.
27th.
27th.
27th. Only one day we get.
Counsel for the petitioner has filed IA-3 of 26 seeking for certain amendments by including additional ground and additional prayer. Accepting the reasons stated in support of the said application, being of the considered opinion that the additional grounds and the additional relief which have been sought for would be required to be considered for the purpose of effectively deciding the list between the parties. IA-3 of 26 is allowed. Counsel for the petitioner to carry out necessary amendment. IA-4 of 26 has been filed to implead the state of Karnataka represented by its Secretary Department of Personal Affairs by DPR, Secretary DPR and Secretary Department of DPR and DPRA Department, Secretary DPAR and Secretary Backward Classes Welfare Department, Vikas Department. Being of the considered opinion that they are necessary parties to these proceedings, since they are in charge of the implementation of the various government orders passed in respect of identification of the creamy layer, IA-4 of 26 is allowed. They are brought on record as respond number 5 and 6 respectively. Learned AG accepts notice for respond number 5 and 6. Registry is that print his name as such. Counsel for the petitioner to file the amended petition including as per the orders on both IA number 3 and 4 of 26 by 27th August. And AGA seeks for a day's time to file his objections. Relist on 27th August. We don't even, you are asking for a relief. You are producing one more document saying that then you are asking for quashing of it. What subject you have to be clear on what relief you want. We can't be saying outcome of what. Please apply your mind properly, verify what is the applicable law, and then make your submissions. If you don't want to say anything more. You can't come to this court without being sure of what you want. We can't pass orders on assumption. Please verify.
Dear Rajshekarappa.
Counsel for the petitioner seeks for his grant 2 weeks time, relist on 16th September.
18th, Shravan S. Lokre.
Respond number 5.
Mr. Lokre.
Not been appearing, my lords are directed in the last week of hearing. If the business for default is not appearing in the next week of hearing.
Today also none. Despite the order dated 7/7/26, none appears for the petitioner today also. In that view of the matter, it appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
19th, S.N. Channabasappa.
Shri B.L. Sanjeev has entered appearance for the respondent. Delete the name of Shri K. Krishna as that appearing for the respondent. Yes. Where is the order sheet?
Page 22, my lord. There's a type copy of the order. Starts from 21, my lord. 22 is the order which is under challenge.
You have produced only from 28-1, not prior to that. On 28-1, it was further examined. Hmm. And see, you have to come clean on producing the order sheet. When there is a reference here, the case is pending from 2020 and order sheet reveals that respondent counsel for respondent are not attending regularly, which has caused the delay. ನೀವು ಆರ್ಡರ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಲ್ಲಪ್ಪ ನಾವು ನೋಡಕ್ಕೆ. Again, you filed an application, you did not cross-examine. 26-2. Rejected because you said you want more time. Application act, but you are not ready to cross-examine. Where is it? PW1 is a depot manager. Every time she has to come to this case, planning to absence in the depot, which is a very important workplace. He'll put them on terms. When will your witness be present?
Any day, my lord. Any day, my lord.
She has to come from
Dodballapur, my lord.
Dodballapur, Pakadalle.
She'll have to come. So any day next week, my lord, if my lord grants a date, my lord.
Without seeking any adjournment. You will continue and complete the cross-examination without any adjournment. If you seek for an adjournment, we will say cancel. Petitioner is before this court seeking for the following reliefs. Proceedings have been initiated under the Karnataka Public Premises Eviction of Unauthorized Occupants Act 1974. 74, huh? Which year? Check mark 74. The respondent complainant had examined his witnesses, marked the documents, and the matter was posted for cross-examination. The respondent, therein who is the petitioner herein, sought for time. The competent authority, taking note of the fact that the order sheet revealed that respondent's counsels and counsel for respondent were not attending regularly, had rejected the said request and posted the matter for evidence of the respondent. An application having been filed on 26/2/26, seeking for reopening the stage of cross-examination. On inquiry, if the respondent was ready to cross-examine, the respondent again sought for time, stating that the application could be allowed and cross-examination could be conducted subsequently. Then the said application also came to be rejected. The matter having been posted for respondent evidence, That was also not led and matter was sought to be, a request for adjournment was sought for on 5/3/26. It is challenging the aforesaid orders. The petitioner is before this court by way of the above writ petition. Considering that the matter involves eviction of the petitioner under the Public Premises Act, which is summary, where summary proceedings are to be followed, and taking into consideration the express undertaking of the learned counsel for the petitioner, that the petitioner would cross-examine the complainant's witness on the very next date that it is posted, and would complete the cross-examination on all, and continue to cross-examine the said witnesses, witnesses, until completion of cross-examination without seeking for any adjournment. This court is of the opinion that an opportunity is required to be granted to the petitioner to complete the cross-examination, so as to have his say in the matter on record. Hence, this court passes the following order. Writ petition is allowed. The impugned order dated 26/2/26. You have not challenged the March order. 26/2/26 passed in KPP case number 1 of 2020 at Annexure A is set aside. Though no relief has been sought for in respect of the order dated 5/3/26 as regard posting the matter for arguments, considering that the stage of the cross-examination of the complainant witness is being reopened, it would also be necessary to enable, it's also necessary to permit the petitioner to lead his evidence in the matter. As such, the order dated 5/3/26 posting the matter for arguments is also set aside. The petitioner shall appear. When will your witness be there?
Next day, 2nd September is the date.
2nd September. The matter now being posted on 2nd September for arguments. ಇದು ನೀವು 10 ತಿಂಗಳಾಯ್ತು, 8 ತಿಂಗಳಾಯ್ತು. The matter now being posted on 2nd. If you are not going to do 2nd September, we'll dismiss it. Like how your other application have been. The matter now being posted before the competent authority on 2nd September 2026. The respondent shall keep the witness present on that date. The petitioner would be entitled to cross-examine the said witness on 2nd September 26. In the event of the petitioner seeking for any adjournment before completion of the cross-examination or any of the dates that the matter is posted for, the benefit which has been extended by this court in the present order will stand automatically rescinded, and the competent authority would be entitled to post the matter for the next stage. 8 ತಿಂಗಳಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? You are delaying the matter, it is very clear. From January you are sitting on it.
Proceedings have been filed for recovery of the rentals. Recovery of the rentals, it says eviction.
4 crore.
No, only for recovery.
Recovery and eviction ಆಯ್ತಾ?
Eviction is already done.
Recovery.
Much.
Serial number 20, Kumar.
Hearing for respondent. Let's see, the last date of hearing, petitioner is directed to produce.
Made by the petitioner to respond number 5. Yes. Where is it? Not acceptable. When they say that you are not paying. Last time. From the beginning. Interim order vacate ಮಾಡೋಣ 5 months ಇಂದ ಕೊಡಲ್ಲ ಇಲ್ವಾ?
When I went there near the home, I am a cancer patient. They are not even paying for the medicine also. After all these things, I approached.
Okay, you argue on the merits. We'll set aside the gift deed, then you will know. ಆಯ್ತಪ್ಪ, ನಿಮ್ಗೇನು ಗೊತ್ತಿಲ್ಲ, ನಿಮ್ ತಾಯಿ ಎಲ್ಲಿದ್ದಾರೆ ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ತಂದೆ ಎಲ್ಲಿದ್ದಾನೆ ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಒಳ್ಳೇದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. Please argue on the merits, since you are not anyway paid the maintenance. Argue the matter. We have already told you, argue the matter. We'll dismiss it today. You're not paying the maintenance, you are not arguing the matter. Where's the money? ಎಲ್ಲಿ ತೋರಿಸಿ ದುಡ್ಡು ಕೊಡಿ. ಎಷ್ಟು ಕೊಡ್ಬೇಕಪ್ಪ? 10,000 ಅಲ್ಲ, 5 ತಿಂಗಳಿಂದ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನೀವೇ ಹೇಳಿದ್ರಿ. You know your brother counsel? You know your brother counsel? Or phone number?
One submission, my lord. After this order, my lord, I went near the house, my lord. When he was thrown out, my lord, I have filed a police protection, my lord. The writ petition is also pending, my lord. Notice has also been ordered in this, my lord.
What is that?
The WP number 8777 of 26, my lord. That is also pending, my lord.
Connect with WP 8777 of 2026. Relist on 27th. It is made clear that no further adjournment would be granted. By that date, all the pending maintenance amount would have to be paid by the petitioner to the respondent number. Five. If the pending maintenance amount is not paid by then, the petitioner would not have any right to audience, requiring the petition to be dismissed.
21, Shruti C.
This connected matter.
This is that pipeline matter, my lord, where we.
So that it has been reserved for orders, my lord. Not yet, not been pronounced. So that will have a direct hearing on this petition, my lord.
Let counsel for respondent 5 submit that the matter involving a similar list having been reserved by the coordinate bench, orders are judgment is yet to be pronounced. Relist on 21st September.
22, R. Vijay Prakash.
Is so and so. Is so and so. Accepts notice for respond number 2. Registry is direct print his name as such. And AGA accepts notice for respond number 1. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the counsel for respond number 2. Yes. Both the petitioner and respond number 2 are restrained from any manner alienating, dealing with, encumbering or changing the character of the subject property till the next date of hearing.
So far as the rents are concerned, she is taking away the rent. It should be deposited.
The amounts payable by the tenants as rent shall be deposited with this court, which deposit shall be subject to.
From the date of petition before the extent.
Ivatinda noda, which shall be subject to the result of the present petition. When will you file your objections?
2 weeks.
That counsel for respond number 2 seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, by 18th, relist on 23rd.
Serial number 23, L. Narasimhamurthy.
Wait 2 weeks time, mainly I have done September 2nd week for the objection.
Preliminary notification under section 4. ಎಲ್ಲ ನೀವೇ ಅಲ್ಲ ಗವರ್ಮೆಂಟ್ ಆಫೀಸರ್ಸ್ 1, 2 and 12. And AG accepts notice for
Yes.
respond number 1 to 12. Registry is direct print his name as sir. He seeks for and is granted 2 weeks time to file a statement of objection, relist on 23rd September. Interim order earlier granted is extended to next day.
24, Sandeep Lahiri.
Mahesh, you will be appearing. Mahesh Arkalgod Srikanth has filed Wakalatnama prior to issuance of notice. He accepts notice for respondent number 1 and 2, register his direct print his name as such, and delete the name of Shri Kumar MN as that appearing for respondent number 1 and 2. Yes.
Had some confidence that I think about some in this because the Tuesday is
Ah.
central PSC, but I could not. The request of the minister was quite steep. And, these are all defense lines, not we cannot. There was a all.
You don't. You don't. Like now, the state government is in the litigation policy. Any intra-department conflict under Chapter 5, there's a ad hoc committee constituted for those conflicts, headed by Additional Chief Secretary.
I understand. But
And so then
before
it
the
was-
matter goes to court. Now this, there is a concurrent matter. The EO has already passed an order that was challenged before the district court. The district court has.
Even after it goes to court, if there's any this one, then it should go before that committee who will resolve it, because it is not good for you to be fighting.
But please have look at this memo. But, the lease do not have ended on 31/12/2023.
Now, what do you want to do? You want to argue the matter? What do you want to do? Yes, please. Hmm. 75. February 13th, 2003. Yes.
For a period of 21 years, as if the extension clause. These expired not, although the agreement says 31/12/24, 21 years expires on 23. I'm not getting to that. 96 clause 2C at page 82.
To see why there's so many clauses getting repeated like this. There's 1, 2 on page 80, then 82 again clause 2. This is
One A, B, C, D, E, F, B there, that is page 81. And 82 is 2 A, B, C. It's just before clause 3.
if you come to page 80,
Yes, sir.
there's already clause 1 is 21 years. So how do we refer to a clause if there's repetitions like this?
This clause 4, clause 2, clause.
Ms. Surya, we'll have to refer to both these clause 2s. First clause 1 is 21 years. The first clause 2 is giving you what is the rental payable. So we have to refer to that clause. Then again, if we say clause 2, so okay, then it goes to 5 amela illa. So that goes as ABCD. Okay. So clause 2 is rental. Just 1 minute. Clause 1, 21 years. 7,400 per month. 15% after 3 years. Now you are referring to 4, 2C. Yes.
This is the renewal clause that the lessor shall, and missing emphasis on the word shall, on the written request of the lessee made before the expiry of the term hereby created, and there shall not at the time of such request be any existing
Legal.
the demised premises for the further term from the expiration of the said term at the same rent and containing the like components and the provisos as therein contained. This is the renewal clause. So if I opt for renewal before the expiration of the lease of 21 years, there is a mandatory renewal on the right terms.
Yes.
This is what I invoked before the expiration. Multiple vendors were given that please renew the lease. There is also one more clause for it which I must point out, Your Lordship. Kindly see page 83. This is 4(3)(f).
4(3)(f).
After the expiry of the lease period, the lessor and the lessee may renew this agreement of lease on mutually agreed terms and conditions by executing a fresh lease agreement. So there is a clause 4(2)(c) which says mandatory lease. There is a clause 4(3)(f) which says on mutually agreed terms.
Made before expiry is mandatory.
Yes. Now, my interpretation of this is if I opt for renewal before expiration of the lease by in writing and there is no breach, the renewal is mandatory. 4(3)(f) will kick in only if I do not opt for renewal before the expiration and after expiration the parties can mutually agree on and they have a discretion whether to renew or not. This is my. Now, once this is the version, I cannot, and unless this point is determined, because I have filed a suit for specific purpose. That suit is pending. Unless this point is determined, whether I am entitled for a renewal as per the agreement, the registered agreement, I am not under unauthorized occupation. Once I am not under unauthorized occupation, the Public Premises Act itself doesn't apply. That's what this honorable court has said. If I may just point out one decision of this and the decision of the honorable. This renewal clause has to be decided by the civil court. I just pass on this decision.
What happened in your specific performance suit?
It's pending.
Interim order staying disposition.
Yes.
Good. Now the estate officer has taken up the proceedings.
He has passed an order against this point has not been considered. They are only referring to 4(3)(f) and saying it is I have a decision can be extended. Now, can you see this decision of this honorable court? Paragraph identical facts. Paragraph 4 not first at page 2.
Yes.
When the matter stood there, the court respondent had initiated proceedings under the Karnataka Public Premises Section Unauthorized Documents Act 1934. The order passed under the second act is under challenge in number 1. Notified before the resident judge Bangalore City and made a request for renewal of the license for cinema since it was to expire on 31/12/2008. The respondent passed an order dated so and so, stating that the license would not be renewed, but the petitioner would earn the greater bill 31/12/2008 as they had a valid license till that said date. The said order is in respect of the earning arbiter. A similar order was passed in respect of the earning arbiter also on so and so. He agreed with the said order. The petitioner filed appeal before second respondent and by order stated so and so. He agreed with the said order. The petitioner has filed these petitions by continuing that petitioner is not an unauthorized occupant, but on the other hand is in lawful possession of the premises by virtue of section 58 of the Transfer of Property Act, and that the petitioner has the right to get the lease renewed since they have invested huge sums of money on construction of cinema. There is also a vacating paragraph. Verse number so has already been filed by the petitioner seeking specific performance of the contract of lease. In as much as the petitioner has sought for execution of the renewal of lease deed in favor of the petitioner, which is pending consideration before the civil at Bangalore, that according to the petitioner, the reasons assigned by the respondent for rejecting the renewal as stated. Now, if you are not kindly turn to page 4, paragraph 14.
Yes.
Having heard the learned counsel on both sides and on the of the materials on the court, it is observed that pursuant to the order dated June, so registered is executive for consent respondent and the petitioner on 1974. While its the lease in respect of the scheduled land was initially for a period of 30 years and clause 16 of the agreement said agreement has provided for renewal of the lease for a further period of 10 years. However, it is not in dispute that there is no renewal of the lease by entering into a registered lease agreement till date. In fact, the petitioner has filed OS number so seeking performance as against the court correspondent to enter into the renewal lease agreement. It is also not in dispute that the court correspondent has passed an order under the PP Act, which is subject matter, in which there is an entry order of stay of eviction. When the matter stood thus, I speak the renewal part, and would your lordships kindly turn to paragraph 18. It is also not in dispute that there has been no agreement renewing the lease which has been entered into between the parties subsequent to the expiry of the initial lease period. However, it is not in dispute that since the expiry of the initial period of lease, the petitioner has been making payment of rental payment to the court correspondent and the same have been received. Same is the case here, that they have been paying rent and they have been receiving. In fact, there have been a correspondence between the parties in this regard, and since there has been no finalization of the renewal, the petitioner has also filed first number so and so, which is a suit for specific performance for the execution of the lease. And I'll skip the rest of it. Kindly come to paragraph 22, page 7. Learned counsel for the petitioner, Maharaj Sagar.
Yes.
Learned counsel for the petitioner has referred to each of these decisions and had contended that reliance raised by the counsel for the court not to have finished resistance having regard to the facts on the basis of which the decisions have been rendered in those cases and having regard to the facts of the present case. In support of this contention, we have stated that the transfer of the will have to be applied in the present case having regard to the fact that on the basis of the lease agreement dated close to the petitioner has been put that they continue to be in possession of the said property pursuant to the said agreement and having been granted a right of renewal of the lease, the clause 16 of the said agreement, the continuation of the petitioner's possession of the said property is lawful and protected by virtue of section 153 of the Transfer Property Act. Therefore, in support of this submission, we have relied upon certain decisions to contend that this aspect of the matter has not been taken into consideration by the respondent. Therefore, it has to be held that having regard to the fact that the lease deed itself provides for renewal of the lease and the fact that the petitioner has filed a suit for specific performance for execution of the lease agreement and that subsequent to the expiry of the lease, the petitioner, as the lessee, has paid rent to the court correspondent and therefore his possession must be considered as lawful. In this context, it would be necessary to take into consideration two situations. One, where the lease deed does not provide for a renewal clause, and the second, where the lease deed provides for a renewal clause and steps have been initiated for getting the lease renewed. And the lease deed does not provide for a renewal clause and the lease period expires, any continuation of possession of the possession of the lessee or the tenant would be in the nature of the tenant holding over and would in my consideration be unlawful possession. However, when the lease deed prescribes a renewal clause and if the lessee continues to be in possession despite the expiry of the lease and has also taken steps for renewal of a civil renewal agreement to be executed, in such a case, the continuation of the lease pursuant to the expiry of the lease cannot be held to be unlawful in the nature. In this context, it would also be relevant to note that if the lease deed has a renewal clause, the tenant to continue to be in possession, of course, subject to the terms and conditions of the renewal clause. Moreover, in the instant case, it is not known whether the terms and conditions have been complied with by the respective parties in addition, as much as what is clear is the fact that there has been no renewal of the agreement entered into between the parties. In fact, the petitioner is seeking such a renewal agreement in OS number so which has been filed by the petitioner. Therefore, the status of the petitioner, who is in the nature of tenant holding over in the face of the renewal clause in the lease deed, has to be distinguished from that of a tenant who is holding over in the context of the lease deed, not having a renewal clause on the expiry of the lease deed. Moreover, in the instant case, the petitioner has been paying the rents to the court correspondent and the same has also been accepted and no steps have been taken by the court to seek eviction of the so from the property in question in accordance with law. It is also relevant to note that the petitioner has been in possession of property in question pursuant to initial lease agreement dated so that agreement is writing and signed by all the parties and registered and pursuant to the said fact that it is continuing to be portion pursuant to the said agreement has to be considered as part performance of the contract in as much as the present possession of the petitioner subsequent to the expiry of the lease deed is only in the right of clause 16 of the renewal of the lease agreement is provided for. As already been stated, concurrence of the terms of conditions of clause 16 in the instant case is a matter of adjudication between the parties, and the original suit is filed by the petitioner against the court respondent in the absence of there being any steps taken under the terms of the lease agreement by the court respondent after the expiry of the initial period of lease. Under the circumstances, it cannot be held that the position of the petitioner is unlawful. Of course, in this context, it is also relevant to note court respondent has initiated steps under PP Act on the premise that the petitioner is an unauthorized occupation of the said premises. The initiation of the proceedings under the PP Act is quite distinct from taking steps under the general law in terms of the provisions of the lease agreement. The fact that there have been several correspondence exchanged between the parties and the fact that the court respondent has collected the rents from the petitioner and also the fact that the agreement of lease itself provides for renewal of the lease, which is subject to certain terms and conditions, would entitle the petitioner to continue to be in possession of the properties in terms of the agreement dated also. The right of the petitioner for renewal of the lease is not a matter to be taken into consideration by this court in this proceeding. It is a matter to be adjudicated upon in OS number so also. But having regard to the facts and circumstances of the present case and keeping in mind the renewal clause mentioned in the lease deed, in my considered view, the continuation of the possession of the property in question by the petitioner despite the initial expiry of the lease deed in the face of the renewal clause cannot be held to be unlawful. There has been no application of mind by the authorities on this aspect of the matter. In this context, it is to be noted that though the apex court has said in the decision referred to Supra that any continuation of the possession of the lease or a tenant subsequent to expiry of the lease is a judicial possession, the fact remains that in the said case, both the lessor as well as the lessee have applied for grant of license in their favor. There was no renewal clause in the contract of the lease entered into between the parties. The facts of the present case are distinct from the facts in the said case, therefore the same is not. In the case of so and so, though there was a renewal clause in the agreement of lease entered into between the lessor and the lessee, but under the renewal clause, no right was given to the lessee as of right. Also, if the lessor decided to give the premises and equipment on lease after so and so, that is after termination of the lease. So that is distinguishing that those cases that were cited now. And I can see paragraph 32. Various decisions were cited which were distinguished. Paragraph 32, my lord, sir.
Yes.
Therefore, in the instant case, clause 16 of the agreement of lease deed, the lease dated so and so, is the foundation for renewal to be entered into between the parties, and so long as the parties do not enter into any registered agreement for a further renewal of 10 years, the continuation of for a further renewal period of 10 years, the continuation of the portion of the property in question by the petitioner cannot be held to be unlawful. In fact, clause 16 is the foundation on the basis of which fresh rights renewal to the lessor as well as to the lessee, and particularly to the lessee in the instant case, since the lessee only has an option to seek renewal of lease for a further period of 10 years. Therefore, so long as there is no determination of rights between the parties arising under clause 16 of the agreement, despite initial expiry of the lease period, the continuation in possession of the property in question by the petitioner has to be held to be unlawful. The fact that the rents have been paid by the lessee in the instant case would mean that the tenancy is a month-to-month tenancy, and the petitioner's right to seek specific performance of the contract is subject to terms of clause 16. As already observed, the same is the subject matter of OS number 1, and it is not for this court to make any observations on rights of the parties. In fact, this court went ahead and renewed these in the final paragraph. They said that these has to be renewed in paragraph 5. In any case, my lord, this is one. Supreme Court also had an occasion
To seek renewal, they did not renew.
They directed.
To seek renewal.
Therefore,
That is then a specific performance suit. Yes.
In fact, Supreme Court also had an occasion to deal with this issue, not decision in the comparison. My lord, kindly turn to paragraph 85. It's a lengthy section and not paragraph 85, running page 59. That was, of course, a case of perpetual lease, which was central government. Paragraph 86, Your Lordship.
Yes.
For the sake of completeness, I wish to clear the grounds of the possible misconception. Learned counsel, appearing for respondent number 1, the Union of India, while contending that the improved notice also was of an exploratory nature, fairly considered that the lessor, that is the Union of India, must enforce its rights of re-entry upon forfeiture of lease under clause 5 of the lease deed by recourse to due process of law, and wanted to assure us that there was no question of marching the army or making use of demolition squad of the Delhi Development Authority or the Municipal Corporation of Delhi in demolishing the express buildings. As we felt that there was some ambiguity in the expression due process of law, we wanted a categorical answer whether by this we meant by a properly constituted suit. Without meaning any disrespect, the learned counsel adopted an ambivalent attitude, saying that the due process may not only consist in the filing of a suit by the lessor or re-entry upon forfeiture of the
Please.
lease, but that in the case of lease of government lands, the authorities may also take recourse to the Public Premises Eviction of Unauthorized Occupants Act 1971. I have no doubt in my mind that the learned counsel is not right in its suggestion that the lessor, that is the Union of India Ministry of Works and Housing, can in the facts and circumstances of the case take recourse to the summary procedure under that act. The Express Newspapers Private Limited, having acted upon the grant of permission by the lessor, that is the Union of India Ministry of Works and Housing, to construct the new express building with an increased area of so the double basement and so clearly not an unauthorized document within the meaning of section 2G of the Act, which runs as under SC can be seen paragraph 86. The express buildings constructed by Express Newspapers Private Limited with the sanction of the lessor, that is the Government of India Ministry of so on plot number so defined on perpetual lease by registered lease deed so can by no process of reasoning be regarded as public premises belonging to the central government under section 2E. That being so, there is no question of the lessor applying for eviction of the Express Newspapers Private Limited under 2(1) of the Public Premises Eviction of Unauthorized Act, nor has the estate officer any authority or jurisdiction to direct their eviction under subsection 2 of the thereof by summary process. Due process of law in a case like the present necessarily implies the filing of the suit by the lessor, that is the Union of India, for the enforcement of the alleged right of re-entry, if any, upon forfeiture of the lease due to the breach of the terms of the lease. Both the courts do things they say, we are not under unauthorized occupation, and the only remedy for even if they want eviction is to file a suit for eviction. And then in any case, my suit for special performance is pending. My rents are being accepted even as of date. Directly not when negotiations were going on, they issued show cause notice and asked me to vacate by the estate office.
According to you, there is no negotiation required. If you are relying on 42C, no negotiation, 7,400 into 15%.
I said renew it. They said we will not renew it because they cited some defense guidelines, which according to me is not applicable to this premises. But anyway, they cited some defense guidelines, but we also didn't want to fight with Ministry of Defense, we are Ministry of Petroleum. We didn't want to fight. We said give us some time, let us allow us to.
But you are still fighting. But you are still fighting.
They have dragged us to court. They have. Even now, we said give us 3 years time. Let them come and say we'll give you 1 year, 2 years, whatever reasonable time. We have to find an alternate place. We have to shift. It is a petrol.
So what is your term now? What do you want? 3 years time.
We have given 3 years now. Better come. I think at least 18 months, 20 years is what we require.
Say you don't want the term now. You don't want the term.
The full term.
You don't want the full term.
We don't want to fight with them because they say they require it for their purpose. I don't know what process. Anyway, they say.
So what will satisfy your requirement?
2 years.
2 years. Yes, Mr. Kamath.
And almost one more point. Estate officer has levied damages without issuing a show cause notice under section. First of all, if your lordships agree with me that the estate officer doesn't have jurisdiction, then those damages have to go. We are agreeable to, if they agree for continuation of our operation for 2 more years, we are agreed to, we are paying only a rent of 70,000 now. Our bank has agreed to pay a monthly rent of 2 lakhs per month from the date of expiration of the lease. The initial, and also we have put it in the email that was sent. The damages, they should not ask us, no determination of that, no show cause notice, no determination of damages, some 34 lakhs or 25 lakhs has been by that, if you not.
What is the extent of property demised?
$8,000. Yeah, yeah. It's in that DRDO residential, employees residential complex, outside on the boundary. And employees want the petrol pump to continue because it's very convenient. 200 families live there. They want the petrol pump to continue.
Yes, anything else?
That's all I have to subject to what my other.
Yes, Mr. Kamath.
Please have a look at the two clauses not which my amendment were. The duration of the use, it has commenced on 1/1/2003 was 21 years. The lessor respondent is the Defense Research Development Organization, which functions under the Ministry of Defense, carries out very, very important strategic research for defense, particularly having got the geopolitical developments, it plays a greater role. Right? Admittedly, this is a defense land. This was given for the purpose of defense. And at that point of time, because there was a residential layout nearby, it was given for 21 years. And the two clauses, if they are read together, the one at page 82, 82 refers to a written request being made for the purpose of renewal after 21 years, and more particularly 3F at page number 83 on next page. My respective submission that these two clauses must be read together, the agreement as a whole. If read together, this 3F as well as that 2C, 42C, would indicate that the understanding between the lessor and lessee was that the renewal will take place only upon mutually agreed terms and conditions. It is very different from clause 16 in the Supreme Court judgment. There was no mutual agreement. One person asked the other. It had to be done. So that way, these two clauses read together will clearly be very distinct from what was read in the cinema theatre judgment. There it was a cinema theatre, very different from a defense establishment's line. So
When was the renewal request made? That letter you did not point out. That was important.
Make sure. At 10, first request was way back in 21, 30th October 21, 9 January 23, 10 April 23, and 11 August 23 was the last.
You have produced those letters?
We have annexed it to the request and I'm just passing it.
Para 10.
Para 10 of the page 9. They were produced before the estate officer and the district.
Yes. Yes, Mr. Solomon. Good. So the distinction is what is trying to make out at clause C is made before the expiry and F is after the expiry.
That is, if you ask to read the agreement as a whole, the intention was never to have two different clauses, one prior to one after. That was never the intention. If you ask to see both the clauses. And anyway, prior to the expiry, even though a request is made, it was not renewed. If you were to give strict interpretation to clause,
That is why specific performance has been filed.
yes, I come to that. No, but these clauses will have to interpret in the light of the defense line policy, which the petitioner has produced at page 89 and
Because how much time are you willing to give?
they want to set up a very critical defense law.
How much time?
The requirement,
He has come down to 2 years.
6 months, 6 months time. What we now please have a opinion. Please have a opinion.
I filed a memo.
Which I filed this month. To answer your lordship's present question, this would be relevant. Now, please have a look at this letter issued by the petitioner on 31st March 2025. And if I may read, this is with reference to the lease agreement executed of Budapest on 9th July 2003.
31st March, page number?
Along with the memo, there is only one letter.
No, this is a petitioner memo. Where is the respondent memo? Yes.
So there is last to find a letter dated 31st March.
31st March, yes.
Written by the petitioner to the respondent.
Yes.
This is with reference to the lease agreement executed at Budapest on 9th July 2003. Our organization has had a long-standing and mutually beneficial relationship with Budapest for the past 50 years. For this time, we established a sense of trust and cooperation, and we have greatly valued it. Initially, we obtained approval from management for lease renewal for the subject site for a period of 2 years, as advised in our letter dated 23/1/2024. Subsequently, it was intimated to us that the request for lease renewal can't be accommodated as the lease of defense and the public sector order lease has been discontinued as per the policy issued by Ministry of Defense. We are in receipt of a letter dated 12th March 2025 advising us to vacate and hand over the subject to us. In this regard, we would like to communicate that we have initiated the proposal for approval from management for vacating the site. As you know, being a public sector enterprise, a government arbitration, we need to obtain approvals from the concerned authorities for handing over the site. However, we would like to inform you that we have invested huge amount in crores, approximately 3.5 for infrastructure in the canopy, driveway, tank, building, etc. We have also extended huge credit amount to customers in the market. In view of the same, we require some time to shift our assets and recover our money in the market. If we abruptly close the outlet, the corporation will be incurring huge loss in view of our investment and the money spent in the market. Keeping in view of these factors, we request you to kindly allow us a time of 6 months to vacate the site in order to obtain all approvals, to vacate and surrender all licenses like explosive, DC, NOC, etc. We also need to remove all infrastructure provided at the site and hand over the vacant site. Given the length of our search and effort required for condition, we would greatly appreciate if you could provide us additional 6 months to ensure smooth and orderly execution. This would allow us to manage the process in a way that respects both our needs and the relationships we are going to open here. In this regard, we also request you to control the damage charges in Swenson and allow us to pay the license fee that we are paying presently. We are committed to making it. So from March 2025, it will add 6 months.
Can you give them 6 months from now?
The instruction to me was immediate, but I on a reasonable basis.
Because then Ms. Surya cannot say no to that.
Because from then now, we are 18 months.
Kindly see this. This was all before they initiated the proceedings under public reference.
Now,
Kindly see this letter of theirs.
Ms. Surya,
886. 886. 886.
we'll see that.
They themselves agree.
We'll see that. We are not saying no. We are not saying no. They said 2 years, then you were agreeable for 6 months when they said they gave the policy. You only asked for 6 months. After that 6 months, now.
After that, if they had agreed, given us some time, we would have made efforts and got something at that time. But the proceedings were initiated, then I am kindness to now. Much water has flown after that. Now, if they had not dragged me to the court, we would have, that's what I said. Even now,
What we are trying to tell both of you is, it could go either way when we take it up. If it goes against you, it would be immediate surrender. If it goes against them, pending the suit decision. So now it's private individuals fighting, no issue, not.
Let me say, over the discussion that happened after the last day, they said 1 year, we have said 3 years. Kindly close it at 18 months. I don't think even.
In light of your letter, in light, that is subject to your settlement. Your settlement, you can agree for 21 years also again. Your letter says 6 months.
Our letter says 6 months before they initiated proceedings under public premises at the stage of negotiation. Negotiation is all without bill list. Now, they have initiated the proceedings, the matter is pending before your lordship in the district court and on merits.
Where is your defense
Suit has been issued.
policy issued by Ministry of Defense?
That policy your lordship it doesn't apply to this premises at all.
Since it is our policy, may.
Let him complete it. You argued.
Yes, page 89.
89.
Once it's asked if there is anything else, my learned friend, no. Let me make my submission. No, I have to reply, my learned friend.
Yes, you can reply, not interrupt.
Yes.
Hmm.
Page 89.
Yes.
But next we have got page 89. But this is issued by the Ministry of Finance.
Hmm.
Leasing of, when we have to get the subject, leasing of defense land to public oil companies for retail outlets or petrol pumps, gas agencies, kerosene oil agencies. Issue of policy on leasing of defense land to public oil companies for retail outlets for petrol pumps, gas agencies, kerosene oil agencies has been examined in the Ministry of Defense, and the following decisions have been taken with the approval of the competent authority. One, the policy for leasing of defense land to public sector oil companies for opening of petrol pumps or kerosene land has been discontinued. That is very strongly worded there. As regards taking over the lease site, sub judice cases may be governed on the basis of outcome of court proceeding, and suitable submission will be made before the court in terms of the government decision. Lordship will note that this is 17 February 2022, much before the matter went to court. Third, 3. Action may be initiated to take over other sites from the present lessee's occupant. In case the lessee occupant is not willing to hand over the site, action under PPA Act 1971 may be initiated by the estate officer concerned. One lease site which is still subsisting shall be taken over after the expiry of lease on 22/2022. In view of the above, the PDs are requested to issue direction to all concerned BOCOs to initiate action for taking over of sites where leases are expired following due process of law. In case the lessee occupants are not willing to hand over the sites under PPA, action under PPA Act may be initiated by the estate officer concerned. A list of 24 such cases wherein leases are expired and no litigation is involved is enclosed back on the schedule. In case where litigation is involved and matter is sub judice, such cases may be governed on the basis of the outcome of the court proceeding and efforts to defend government interest be taken by way of suitable sufficient before the court in terms of the government interest. A list of 11 such cases wherein leases have expired and litigation is reportedly involved in enclosed back on the schedule. There is one lease site where lease is still subsisting and it shall be taken over after the expiry of lease on 28/2/2022. CO concerned shall be directed to initiate proceedings for taking over of site dwelling land as per due process of law to protect government. List of subsidy lists also. PDDs are requested to issue necessary direction to all BOCO concerned to initiate proceedings for recovery of damages, pending arrears of lease rent payable, why till the date of taking over the lease. The PDD shall monitor the implementation of this order and submit report to this director general on monthly basis. The first report be sent by 7th of March 2022. Now, this may respect to submission a policy which falls under the Article 73 of the Constitution, and the interpretation of the lease agreement will have to be done in the light of this policy. Having regard to the criticality of defense lands and having regard to the need for defense lands in the present geopolitical developments in the world, the oil companies are merely carrying out for them.
But why this letter restricting it to annexure A, B, and C?
My respectful submission is, it is not an exhaustive list. So the policy, I am not complete yet, but the letter can wait for this. Please wait, sir, please wait. Lord, the policy is framed in the very first page. Policy says that henceforth, no defense lands shall be given to public sector oil companies. That is very clear. Not including of any particular lease or not does not make any difference. So those lists by respective submissions are not exhaustive. The policy is very clear, and the lease agreement and the present case will have to be interpreted in the light of this policy. That defense land must be used for defense purposes.
This is by the Ministry of Defense.
Yes. And my clear instructions are that there is a critical need for setting up certain important laboratories. We are short of space. We need for example, there is one need for setting up a cyber hub. There are a lot of in the world wars are fought not to on ground. So there are various needs for this particular organization, and we are short of land is a very critical resource for us. So we cannot use that for a profit-making oil company. I am representing the Ministry of Oil. They will not be intention to profit.
It's SPCL, it's not Ministry of Petroleum.
No, they are all 100% controlled by the Ministry.
But it's still a company.
They are a company. They are a company.
They don't get the benefit of the ministry like.
Yes, you fight the minister, this should not have happened, but anyway, that is not for
That's why we asked you, like, that was a problem that we saw in the state governments in 2021 and everything. Then they did, in 2021, we had a lot of the state government departments also fighting among themselves. So in one of the matters, we had suggested if a policy could be adopted on that. So if you look at the litigation policy that the state government has formulated, it covers everybody, even pending litigation. The ACS will be heading the panel, and two other members of those two departments.
The central government also has one.
So
Also has one report by an order number that said
it
a
should
committee
all,
dispute should be formed that was there for some time and then this.
it should clear it. In fact, you should have central government to central government, say central government to government also. They should not be coming up before the court. It's not.
No, here what I would simply say that national interest pitted against profit motive of a oil company. Say the national interest, national security must be there.
You're ready to give 6 months.
Yes, I mean, the Modi requires it immediately, but not, I want to follow your WhatsApp's.
Yes.
I just submit this on this policy by your lordships and the policy.
Hmm.
And you see, this policy is not applicable for this reason. Very clearly, your lordships kindly see page 89.
Hmm.
Clause 1 says the policy for leasing, clause 1, 2, 3, 4, according to me, deal with different kinds of situations. Clause 1 deals with a situation where new leases have to be granted according. The policy for leasing out defense land to public sector oil companies for opening of petrol pumps outside zones should be discontinued henceforth. As regards taking over lease sites where there are
Henceforth is not the word there.
some before, I'll come to that next paragraph, but I'll come to that. And kindly see 2. As regards taking over lease sites, the sub judice cases where cases are pending may be governed on the basis of the outcome of court proceedings, and suitable submissions may be made before the court in terms of the government decision. In 2022, this is a policy in 2022, there was no case pending on in this case. And third case is, action may be initiated to take over other sites from the present lessee's documents. In case the lessee occupant is not willing to hand over, action under BPD Act may be initiated. Those are cases where leases have expired and there is no renewal clause. Now, where there is renewal clause, clause 4 deals with one lease site which is still subsisting shall be taken over after the expiry of lease. In my case also, as on 2022, the date of the policy, my lease had not expired. If the intention was to say that after expiration of my lease, even the initial period, forget about the renewal, it should have been specifically separate. But they chose to name only one petrol. So clause 1 deals with a case where no further leases will be given. Clause 2 deals with a case where leases are subsisting that the matter is pending in the court. Clause 3 deals with a case where leases have expired, so take proceedings under the BPD Act. Clause 4 deals with a case where lease has not expired. They say there is one petrol pump where lease has
You
not
already, don't repeat it.
Yes.
Yes.
So therefore, my humble submission is that where they wanted, the policy is that policy that doesn't deal with a case where lease has not expired or where lease provides for a renewal. The policy doesn't deal. And the policy also doesn't say for what purpose this, what was the reason for this policy. Policy
You
doesn't
can
say
challenge
for what
the,
purpose.
have you challenged the policy?
I have not. We have not challenged the policy. But despite the policy, in 2024, they say they will lease it to you for 2 more years at a higher rent. Can you see that page number 86? Policy was already there. In 2024, if the policy was coming in the way, why did they agree for lease for a further period of 2 years? Page 86. The
Yes.
letter dated 23rd January 2020. Reference to your letter dated 18th December 23, the calculation sheet for extension of lease term for 2 years up to 31st also is enclosed here. You are requested to give your willingness at the earliest for the further processing of so and so. It demanded 2 lakhs per month and 48 months premium for 2 years. I was paying 20,000. I did not agree for these terms. I said, please consider, we will pay you 2 months or we will pay you the 48 months premium and allow us to continue. Page 88 is my proposal. It is then when they initiated proceedings under the PP Act. Page 88, what is my response? Where I said, allow me to continue at, I'll pay 2 months, 2 lakhs per month. Or I'll give you 48 lakhs for 2 years, but allow me to continue at the same.
Your last correspondence is 31st March 2025.
It says 6 months. That was
That's
before the
all.
proceedings were initiated.
Can you change it now? Can you change that correspondence now?
Now
Can
the
you
matter is
backtrack
about-
on it?
That is all without prejudice is what I would say. Whatever negotiations have taken place for it are obviously without prejudice. Now the matter
Yes.
is in the court, all your lordships have to decide is whether the estate officer's order and the district court's order, affirming that order is right or wrong in the light of the terms.
All that is gone. What is remaining is 6 months.
I leave it.
If you want it,
This, my learned friend handed over a bunch of letters.
Mm.
Manager also has a levy notice.
if you are agreeable, then we can speak to them on that. You are not agreeable on this, then all that will be decided there.
He said, allow us to give at least 1 year, 1.5 years for a back also, they are not after so many years.
If you are agreeable for 6 months,
Because I take instructions for because
then we can ask the ASG to use his good offices to waive your amounts. Now, it did not resolve. That's why you are arguing. So now, after all of it, you can continue to argue and we can reserve it, or if you want to, one more opportunity, we can give you that. What is it that you want? No, they're agreeable. Now the ball is in your court. 6 months, they are agreeable. So now,
I will not go back with any.
don't be avaricious.
No, I'm just saying we have to put it to our management, something in writing from them should be there. We have given our terms, our proposal in writing. Let them give something in writing. We will put it.
Yes, Surya, you are.
Something to him or you artists know how it works. Even their department works in the same way. They have what need something.
He accepted it in 10 seconds, and you are having all these things. Mr. Kamath accepted in 10 seconds when we asked him 6 months they are willing to give.
They said 1 year, just 2 years.
Okay. You are not agreeable, Bill. Reserved. Heard. Counsel for the petitioner, Counsel for the petitioner, Shri learned ASGA for respondent.
There is one last bunch of letters which was produced. There is one letter which we have written where we say for what purpose we want to use the land. There is a laboratory called LRB. We say we want to set up that unit.
Yes.
25.
My friends have taken some instructions. If damages, they are going to wait. Then 6 months, our clients will try to.
That is more reasonable. Yes. All right. Move it.
They'll wait all the damages.
They are not interested in getting money from you. The opening statement was that.
No, they were waiting, but the Lordship has seen that 48 lakhs premium levies.
File your joint terms. No damage. No damage. You will not press for it. So, your 6 months commencing from 1st September. So you will vacate by end of February, 1st March you will have it. If they are willing for that, you sort it. We are not going to get into those things. Basic thing is done. That 6 months, 7 months, whatever. No damages, clear. But you will not be functioning till that date. You will give the empty possession of the entire thing after removal of everything. That is what your letter says. You will go by the terms of that letter. Because that is what we,
Your lordships kindly, take it up in the afternoon or evening. I'll have to check whether all that can be done, removal of all those, your lordships no petrol from underground, all those tanks.
they will support your, whatever that delicensing.
You know, letter says it is 6 months, and to do that, let them stop at least refilling the tanks for them, so that they are sufficient.
They can probably do it for 3 months. 3 months.
6 months, right? No damages, but let them continue to pay the rent.
While join this one, then we'll pass that. Otherwise, if we have to make any observation, we have to make an observation against both of you, either of you. May not be, we have no problem in doing it, but there's not,
I am very clear. 6 months we are ready to go. I will not press for that.
so when will you have it? When will you file your joint number?
Joint number will file it in it.
After eyeing for some time, both the council seek for 2 days' time to explore the possibility of settlement. Relist on 27th. Since arguments have been already heard, if settlement is not reported on 27th, the matter would be reserved for orders without requirement for any further hearing.
Serial number 25.
This matter is coming up for admission. Lord, Lord, we have compiled the entire Lord, notification. Initially, the notification was not produced in its entirety. And the applicable rules, Lord, if your Lordship will permit me, can I just hand over?
The tender matter.
Tender matter, my Lord. Now, my Lord,
Yes. Yes.
kindly have page 10 of this.
Of this?
Yes.
Have you given copy?
Yes.
I just received, I'll have to take instructions.
Allah, this is the tender document. And the statutory rules. I'm not producing anything else.
Had you produced it along with your petition?
Lord, the part 2 was produced. Volume 2 was produced.
Then you will give them time.
Lord, tomorrow is the last day for.
You asked for 2 weeks' time on.
No, I asked for, I mean, in fact, I was asking for Friday. Then your Lordship pointed out Friday, no, but there's no sitting.
There's no sitting. So, tomorrow.
Tomorrow.
A compilation of documents has been filed today by the council for the petitioner. And council for respondent number 2 and 3 submitted. It has been served just now. He requires a day's time to go through the same and make a submission. Relist tomorrow, 25th. IA for amendment. There's some IA for amendment, Mr. Male?
Allah, the additional grounds are raised because it was not raised.
You served this application.
There's an application.
So these are not documents. This is an application and
There's an application.
This is not the compilation of documents as you orally submitted.
Allah, they have produced half of the notification.
We'll go by what you submitted.
Yes, I'm so sorry.
You said it is a compilation document. We recorded it as compilation. But when we see it, it's a application for amendment.
No, the prayer, my Lord, is not amended. It remains the same. Only some additional grounds are raised.
So we'll take it as memo of documents and ignore your application is what you want us to do. We'll do that.
All right. Your Lordship may issue notice.
We'll go by what you
Yes.
submit.
No, your Lordship may issue notice.
What is that? The counsel for the petitioner has today across the bar filed an application order 6/2/17 to amend the petition by including certain additional facts, additional grounds, and additional prayers. All submissions wrong.
No.
Please don't do this.
Where is prayers? No,
Additional prayers. That counsel for respondent seeks for and is granted 2 days' time to file his statement of objection. Relist on 27th.
27. Very well.
My lord, Serial number 108, my lord,
Hmm.
is listed for the 10th time, but again 108. At least tomorrow, if it may be listed at the top of the list.
It will come in the sequence that it will come, at the stage that it will come, we will not make any changes in any matter.
Serial number 55, list number, serial number 51, list number 1. Only have it.
Adjournment ಬೇಕಾ? List one serial number
55. I'm for
55. You're for the petitioner. 55, the request of counsel for the petitioner relist on 22nd September.
It's in serial number 111, Malats, in
Ah.
this one. I am for the petitioner. I filed my memo of withdrawal, Malats. It may be considered.
Memo of withdrawal.
Please, Malats.
111 memo of withdrawal, dismissed as withdrawn.
Serial number 32, my lords.
ಯಾವ್ದು serial ಇವಾಗ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? You are moving the memo now. Relist list tomorrow.
My lords, serial number 32, my lords.
32.
32, my lords, serial number adjournment, my lords. I have informed the state, my lords.
You have informed all the respondents?
Yes, my lords.
32 at the request of counsel for the petitioner, 22nd September.
29, serial number 29. Settle ಮಾಡ್ತಾರಂತೆ 30th September withdraw ಮಾಡ್ತಾರೆ.
Settlement ಮಾಡ್ತಾರೆ. 29.
Propose ಮಾಡಿದ್ದಾರೆ. 28th September ಅಷ್ಟಕ್ಕೆ
Counsel for the petition submit that if the matter is taken up on 31st August,
ಅಲ್ಲೇ ಸರ್ 30th September.
30th September. 30th September, endeavor would be made to report settlement, relist on 30th September.
108 at least, because the matter will not reach at all.
Serial number 58, my lord, the writ of mandamus not preserved.
Serial number 49, my lords. My lords, serial number 49, my lords.
ನೋಡಿದ್ರೆ ಓಕೆ ಅಂತ.
ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 1 ಕಂಟಿನ್ಯೂ
ಇಲ್ಲ ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಅದೇ ಮಾಡಿಸ್ಬೇಕಿತ್ತು. 42 ಇದೆ
ಮೇಡಮ್ ಈಗ 108 ಯಾವಾಗ ಬರುತ್ತೆ?
ರೀಚ್ ಆದಾಗ
ರೀಚ್ ಆಗದೇ ಇಲ್ಲ. ಅದು ಏನ್ ಮಾಡೋಣ? ಎವ್ರಿ ಡೇ ಮೇಡಮ್ ಅಟ್ ಲೀಸ್ಟ್ ಸಿಂಗ್ ಅವ್ರ ಹತ್ರ ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು?
ಅದೇನ್ ಗೊತ್ತಾ ಇವರು ಎಲ್ಲಾ ಕೇಸ್ನು ಸಿಸ್ಟಮ್ಗೆ ಹಾಕ್ತಾ ಹೋಗ್ತಾರೆ, ಫೈಲ್ ತಗೊಂತಾರೆ, ಸಿಸ್ಟಮ್ಗೆ ಹಾಕ್ತಾರೆ. ಅದೇನಾಗುತ್ತೆ ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಜನರೇಟ್ ಆಗುತ್ತೆ ಲಿಸ್ಟ್, ಇಯರ್ ವೈಸ್ ಸೀರಿಯಲ್ ವೈಸ್. ಹಂಗಾಗಿ ಲಾಸ್ಟ್ ನಿಮ್ದು ಹೊಸ ಕೇಸ್ ಅಲ್ವಾ 26 ನಂಬರ್ ಕೂಡ ಸ್ವಲ್ಪ ಲೇಟೆಸ್ಟ್ ನಂಬರ್, ಹಂಗಾಗಿ ಲಾಸ್ಟ್ ಅಲ್ಲೇ ಬರೋದು.
ಮತ್ತೆ ಹೇಗೆ ಕೇಳೋದು ಇದನ್ನ ಮ್ಯಾಟರ್? ಇದು ಬರಲ್ಲ ಇವಾಗ.
33 ಇದೆ ಸರ್.
ಮೇಡಮ್ ಅಟ್ ಲೀಸ್ಟ್ ನಾಳೆ ಕಳಿಸ್ತೀರಾ?
ಡೌಟ್ ಸರ್. 4 ಗಂಟೆ ಆದ್ಮೇಲೆ ಹಂಗೇನೋ ಚಾನ್ಸಸ್ ಇದ್ರೆ 4 ಗಂಟೆ ಆಮೇಲೆ ಸಂಜೆ ಡೇಟ್ಸ್ ಎಲ್ಲ ಸಂಜೆ ಕೊಡೋದು. ಇಲ್ಲ ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಆಮೇಲೆ ಡೇಟ್ಸ್ ಎಲ್ಲ ಆಮೇಲೆ ಸಂಜೆ. ಏನಪ್ಪ ಇವತ್ತಿದ್ಯಾ? 1 ಧಾರವಾಡ 3 ಕಲಬುರ್ಗಿ. ಅದರಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಯಾವುದು ಇಲ್ಲ. ಇಲ್ಲ ಎಲ್ಲರಿಗೂ ಇಲ್ಲ. ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ನೋ ಐಡಿಯಾ. ಆಫ್ಟರ್ 4 o'clock. ಅದೇ ಗೊತ್ತಿಲ್ಲ ರೀಚ್ ಆದಾಗ. ಅದ ಅಯ್ಯ ನಂಬರ್ ಆಗ್ಬೇಕಾಗಿದೆ. ಆಮೇಲೆ ಇವಾಗ ಕೊಡಲ್ಲ ಡೇಟ್ಸ್ ಎಲ್ಲ, ಅಕಸ್ಮಾತ್ ರೀಚ್ ಆಗ್ಬಿಟ್ರೆ ಇವಾಗ ಅದಕ್ಕೆ ಇವಾಗ ಕೊಡಲ್ಲ ಡೇಟ್ಸ್. ಇವತ್ತಿಂದ 16 ಏನ್ ಗೊತ್ತಾ, ಫೈಲ್ ಎಲ್ಲ ಸೈನ್ ಆಗ್ಬೇಕು. ಇವಾಗ ಇವ್ರೇನೋ ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡು ಆರ್ಡರ್ ಸೈನ್ ಆಗ್ಬೇಕು, ಆಮೇಲೆ ಬ್ರಾಂಚ್ ಹೋಗುತ್ತೆ. ಅದೇ ಬರುತ್ತೆ ಅಲ್ಲ. ಏನಂದ್ರೆ ಇವಾಗ ನಾನ್ ಸ್ಟೆನೋಗ್ರಾಫರ್ ಕೊಟ್ಟಿದೀನಿ, ಅವ್ರು ಟೈಪ್ ಮಾಡಿದ್ಮೇಲೆ ಸೈನ್ ಹೋಗುತ್ತೆ, ಸೈನ್ ಹೋದ್ಮೇಲೆ ಬ್ರಾಂಚ್ ಹೋಗುತ್ತೆ, ಅವಾಗ ಮಾಡ್ಬೇಕು. ಇವಾಗ ಫೈಲ್ ಅಲ್ಲಿ ಇಲ್ಲ, ನನ್ನ ಕೈಯಲ್ಲಿ ಇಲ್ಲ. ಮಾಡಿ.
ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಮಾಡ್ಬೋದಾ? ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಕ್ಯಾರಿಡ್ ಔಟ್ ಮಾಡ್ಬೋದಲ್ಲ?
ಮೇಡಮ್ 2:30ಗೆ ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಥವಾ ಧಾರವಾಡ ಬೆಂಚ್
ಮೇಡಮ್ 50 ಏನಾದ್ರು ಇದೆಯಾ? ನೀವು ಬನ್ನಿ, ನೀವು ಬರ್ಬೋದು.
ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಈಗ ಮೊನ್ನೆ ಸರ್ 16 ಸೆಪ್ಟೆಂಬರ್ ನಿನ್ನೆ 15 ಕೊಟ್ಟಿತ್ತು, ಇವತ್ತು 16. ಹೇಳಿ ಸರ್. ನಂಬರ್ 29. ಅದು ಸ್ಟೆನೋಗ್ರಾಫರ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅವಾಗ್ಲೇ ಕೇಳ್ಬಿಡ್ಬೇಕಾಗಿತ್ತು ಕೇಸ್ ಆಗಿದ ತಕ್ಷಣ. ಇಲ್ಲ, ನಾನು ಎಲ್ರಿಗೂ ಆನ್ಸರ್ ಮಾಡ್ತೀನಿ. ಕೇಳ್ಬೇಕು, ನಾನು ಏನಿಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ರು ಅವ್ರು ನನ್ನ ಕೇಳ್ತಾರೆ, ಕೊಡ್ತೀನಿ. ನಾನು ಎಲ್ರಿಗೂ ಕೊಡ್ತೀನಿ, ಎಲ್ರಿಗೂ ಒಬ್ಲೈಸ್ ಮಾಡ್ತೀನಿ. ಕೇಳ್ಬೇಕಷ್ಟೇ ನನ್ನ. 29 ತೆಗೆದ್ರ ಆ ನಂಬರು 35 ಸರಿನಾ? 35 ಆಮೇಲೆ 32 ಇವೆಲ್ಲ ಅಲ್ಲೇ ಬರುತ್ತೆ ನೋಡಿ. 25-006 ಇಲ್ಲಿ ಸಿಕ್ಕಿದ್ರೆ ಇಲ್ಲೇ ಮಾಡಿ, ಸೈನ್ ಆಗಿ ಬಂದ್ಮೇಲೆ. ಇಲ್ಲಾಂದ್ರೆ ಬ್ರಾಂಚ್ ಕಳಿಸ್ತೀನಿ. ನಾನು ಕೊಡ್ತೀನಿ, ಯಾರಿಗೂ ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. 55 ಅಲ್ಲ, ಸೈನ್ ಆಗಿ ಬಂದ್ರೆ ಕೊಡ್ತೀನಿ. ಎಷ್ಟು ಜನ ಬಂದಲ್ಲ ನಂಗೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾನೆ ಇರ್ತಾರಪ್ಪ. ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತೀನಿ, ಮಾಡೋದು ಮಾಡ್ತಾ ಇರ್ತೀನಿ. ಹೇಳ್ತೀನಿ, ನಾನು ಕೊಟ್ಟೆ ಕೊಡ್ತೀನಿ. ಬಂದ ತಕ್ಷಣ ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇದೆ, ಅದಾದ್ಮೇಲೆ ಅಲ್ಲಿ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಕೇಳಿ, ಅವರು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ತಗೋಬೇಕಲ್ಲ. ನಮ್ಮಿಂದ ಈ ಆರ್ಡರ್ ಸೈನ್ ಆಗಿ ಹೋಗಿರುತ್ತೆ, ಬ್ರಾಂಚ್ ಅವ್ರು ತಗೊಂಡೋಗಿ ಬೋರ್ಡ್ ಕೊಡ್ತಾರೆ, ಬೋರ್ಡ್ ಅವರು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಮಾಡಿಸ್ತಾರೆ. ಹೇಳಿ ಹೇಳಿ. ಇಲ್ಲ ಹೇಳಿ. ಎಷ್ಟನೇ ಸೀರಿಯಲ್? ಕೆಲವು 4 ಗಿದೆ, 430 ಗಿದೆ, 230 ಇದೆಯಾ ನಿಮ್ದು? ಸೀರಿಯಲ್ ನಂಬರ್ ಗೊತ್ತಿಲ್ವಾ? 2 ಆದ್ರೆ 230 ಗೆ ಫಸ್ಟ್ ಧಾರವಾಡದ್ದು 1 ಮ್ಯಾಟ್ರ್ ಇದೆ, ಕಲಬುರ್ಗಿದ್ 3 ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇದೆ, ಅದಾದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಈಗಷ್ಟೇ ಫೈಲ್ ತಗೊಂಡು ಹೋಗ್ಬಿಡಿ. ಇಷ್ಟೊತ್ತಿತ್ತು ಫೈಲ್ ತಗೊಂಡೋಗಿ. ಫೈಲ್ ಇದ್ದಿದ್ರೆ ನೋಡಿ ಹೇಳ್ಬೋದು, ಫೈಲ್ ಇಲ್ವಲ್ಲ, ಜಸ್ಟ್ ಕೊಟ್ಬಿಟ್ಟೆ. ಪೆಂಡಿಂಗ್ಗೆ ಹೋಗಿ. ಯಾರ ಅಡ್ವೊಕೇಟ್ ಅದು? ಅಲ್ಲಿ ಅಸೋಸಿಯೇಷನ್ ಸಿಗುತ್ತೆ. ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಹಾಕಿಟ್ಟಿದಾರಲ್ಲ, ಎಲ್ರ ನಂಬರು ಇದೆ. ಅದು ಇದೆ, ಅದ್ರಲ್ಲೂ ಇದೆ. ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿರ್ತಾರೆ, ಯಾರ್ಯಾರು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿದ್ದಾರೆ ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲಿ ಸಿಸ್ಟಮ್ಗೋಸ್ಕರ ಮೆಸೇಜ್ ಬರುತ್ತೆ, ಅದಕ್ಕೆ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋರ್ದು ಮಾತ್ರ ಸಿಗುತ್ತೆ ನಿಮಗೆ. ನೀವು ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಟ್ರೈನ್ ಮಾಡಿ, ರಿಜಿಸ್ಟರ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಬರಲ್ಲ.
ಇದ್ರದ್ದು ಇದು ಒಂದು ಚೆಕ್.
Court officer, sir. Court officer, sir. ಕೇಳಿಸುತ್ತೆ ಸರ್.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ IGP PCW ಆಫೀಸಿಂದ ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್.
ಹಾ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
Court officer.
ಹೇಳಿ ಮೇಡಮ್.
ಮೇಡಮ್ ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಇಂದ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನಲ್ಲಿ ಕಂಪ್ಲೈಂಟ್ಸ್ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲ ಅಂಡರ್ ಸೆಕ್ರೆಟರಿ
ಮೇಡಮ್ ಕೊಡ್ತಾರೆ ಇಲ್ಲಿ.
ಕೊಡ್ತಾರಾ? ಸರಿ ಆಯ್ತು.
ಲಿಸ್ಟು ಅದಾದ್ಮೇಲೆ ಲಿಸ್ಟು ಆಮೇಲೆ ಫಾಸ್ಟ್ ಆಮೇಲೆ ಲಿಸ್ಟ್ ಇಲ್ಲ ಯಾವುದು ಇಲ್ಲ ಇವತ್ತು. ಇಲ್ಲ ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಅವರ್ಸ್ ಆಮೇಲೆ ಕಟ್ ಈಗಲ್ಲ ಸಂಜೆ ಡೇಟ್ ಇಲ್ಲ.
so fast that the aim for seva order, in that two mistakes that have happened.
My lord, one matter, I have challenged the tender notification, my lord. ಅದು serial number 90 ಆಗ್ಬಿಟ್ಟಿದೆ. ಅದು ಅಲ್ಲ, today is the last date for resubmission of the tender. ಅದಕ್ಕೆ
Serial number 19 and serial number 23 in this two.
Huh.
Both are based on relinquishment of cost and not challenge the respective regulations in the
See,
2.5 comprehensive.
19 and
19 and 23, this two.
this 219 petitioner is before this court seeking for the following leave. Memo has been filed which reads as under accepting the memo and the submission of the counsel for the petitioner, reserving liberty to the petitioner to challenge the zonal regulations of Vaskote, na?
My lords, in 19, it is the Anekal.
Anekal Planning Authority. Petition stands disposed. 23?
Lords, in 23, my lords, Bayappa. Bayappa.
Zonal regulation of Bayappa. Petition stands disposed. Yes, sir.
See number 17 and this one lordship. This is 55 order we have challenged. They are seeking withdrawal lordship.
Yeah, this?
KPI X section 55 order.
Serial number?
79 lordship.
79.
Liberty was granted to file appeal lordship.
Petitioner is before this court seeking for the following leaves. The counsel for the petitioner seeks to withdraw the above petition with liberty to challenge the order passed before the appellate authority. Reserving such liberty, petition stands disposed.
Sir, I'm 14%, sir. My serial number is 114. I have to come all the way from my native village every time. Can you please? 114.
ನೀವು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ, ನೀವು ಅದಕ್ಕೆ 114 ಬರ್ತಾ ಇದೆ.
Yes, sir. I have complied all the objections, but they're saying that one objection. I have made registry as the party.
ಕೋರ್ಸ್ ನೋಡಿ ಅವ್ರಿಗೆ. Yes. 110 memo for withdrawal.
Dharwad bench matter. Arvind Kulkarni.
Who has to comply? Oh, this is Urban Development Department. Anybody from Dharwad? Paso?
Kalburgi bench matters. Serial number 1. SP Patil.
May you speak on the mic so that.
The AG appeared in this matter, madam. He was supposed to produce documents, madam. Those documents apparently have not served on the other side. Now it has been served. The learned senior counsel is on the other side, but he has requested the matter be taken up on Friday, madam.
Mr. Baker? He is requested for Friday.
Yes, madam. He is free.
He has been served now.
It has been served.
And filed here or? It's been filed also in this?
It has been filed. It has been filed.
And AG has
He's here on the
submitted
line.
that certain additional
Senior
documents have been filed in the registry. Copy thereof has been served on the counsel for the petitioner. Released on 27, Friday, na?
Friday.
28th.
No, he is telling something.
Serial number 2.
He is on mute, madam.
Yeah. Mr. Jaikar?
He is on mute, madam.
We are on mute. No, it's not on mute. Mr. Jaikar? You. We are listing it on Friday. Something must be wrong with the mic. ಏನಪ್ಪ? There's no point in.
Serial number 2.
My lord, the further compliance report. The chief of PCW is also online.
ಆಗಿರೋದು ಡಿ ಸ್ಪೋಕನ್ ಬರೆದಿದ್ದಾರೆ ನೀವು ಡಿ ಸ್ಪೋಕನ್ ಕಳಿಸಿ.
Yes, Mr. Laburam.
Sir, good afternoon, sir. As instructed in the last hearing, we have again requested there are few points for most of our requests they have considered and updated, sir. But 2, 3 are still partially pending. One is district-wise percentage of DR forms and hit and run cases to be included. That is pending. They are working on it, sir. Second, DR form status and that stakeholder wise, yet it is not clear. So form wise, the pendency we are getting, but with which stakeholder these things are pending till some more further updates required from NIC, sir. Third point, we had a meeting on 13th of this month with all the stakeholders, and we requested them to expedite as per the Honorable High Court direction, and inform them whatever the further updates need are. Further, we requested Honorable Registrar Computerized in High Court also joined, and officials from City Civil Court also joined. So we requested if it can be started at the earliest as a pilot project. So it was agreed from 1st of September it would be started as a pilot in a small cause court. So if once it is started, this will be useful where we are having more further any problem we can rectify and take it to final logic line.
So you ready for the pilot project at the small causes court?
Yes, sir. We are ready from our side. We are ready, sir. We request Honorable Court to instruct the other.
We'll take it up on administrative side. What about the Greater Bangalore Authority?
Sir, BPMP, yes, the ZBA, we still have pendency on road plan, still it is pending. We have requested them, and the officer who came for that meeting that day also, we inform him that their maximum pendency percentage was from BPMP or ZBA only. So he told that he will inform the concerned all journal engineers and to update it. But till it is pending, we'll again take up with them.
Para 10 of the letter.
Any timelines that they have indicated?
So we requested them the earliest, and in fact we told them that this will come as a pilot project in a small cause court from 1st of September. Before that, it has to be completed.
Because if you want to do a pilot in small causes court, most of them would be from Bangalore area. So
yes, sir.
GBA done, it won't work.
Right now, sir, as per our dashboard, total 707 requests were sent to BBMP or GBA. All are pending, sir. We will again request them to complete before the 1st of September.
As we are saying, without GBA, a small causes court pilot project will not be successful. So that will have to be done before small causes court, because small causes court is jurisdiction of Bangalore.
Yes, sir.
A letter of the Office of the Inspector General of Police, Police Computer Wing, dated 21st August 2026, addressed to the Additional Advocate General, is placed on record. The same reads as under. Shri Laburam, Inspector General of Police, would submit that though certain of the dashboards requested for have been provided by NIC, there are certain minor modifications which are required, which have been brought to the notice of the NIC team, who are looking into the same and have indicated that needful would be done within 4 weeks' time. They being relating to one, insurance company-wise reports; two, district stroke unit-wise report; three, court-wise report; four, DAR form status, stakeholder-wise tendency details; five, district-wise percentage of DAR forms submitted. Hit and run cases are not displayed in the report and are not considered in the percentage calculation. Aadhaar e-sign integration is required to be made. Insofar as download of the records are concerned, at present only 50 records can be downloaded at any given point in time. A request has been made to increase it to 5,000 records so as to hasten the speed of uploading and downloading. The vehicle form, insofar as vehicle form is concerned, vehicle related information is being fetched from Vahan database. The said database does not contain the updated details which are available with the regional transport authorities. And as such, the details which are fetched, hence there would have to be integration of the data between the regional transport authorities with Vahan database, and from Vahan database to the EDAR database. If that is done, his submission is that all the details relating to the registration certificate, permits issued, permit number, permit validity, nature of permit, etc., would be available with the for assessment in MVC matters. As regards, he submit that most of the other details being available, a pilot project could be taken up at the Small Pulse Court, Bangalore. The Registrar General and Registrar Computers are expected to look into the said aspect, and if the same could be enabled after obtaining the directions in that regard. A statement has also been made that all the road owning agency of Bangalore, being the Greater Bangalore authorities and the 5 corporations which have been formed thereunder, have not uploaded all the details. In the considered opinion of this court, unless those details are uploaded with geotagging of all the roads, road register, and details relating thereto, could not be that productive as required. Hence, the Chief Commissioner, Greater Bangalore Authority, as also all the commissioners of the 5 regional authorities, corporations, are directed to all the details which are required to be uploaded by them onto the EDAR application. The court trusts and believes that the GBA will do the needful at the earliest, at any rate within 4 weeks from now.
Registry to communicate the order to the
Registry order to the Chief Commissioner GBA as also the individual commissioners of the individual corporation by way of email. Relist on 28th September to ascertain further progress in the matter. Thank you, Mr. Abraham.
Thank you, sir.
Serial number 3, Ravi B. Patil.
Yes, madam.
Serial number 3. I think the compliance report has been submitted. This is relating to land tribunal orders which is to be incorporated in the RTC. And all the district data has been collected. Total there are 2,75,242 and 2,65,074 entries have been made.
Very
The
good.
last
Only 10,000 are left.
10,000 are left. It is because of various reasons that has been stated in the last tabular column. So in some of the matters, cases are pending, and in some matters, Manoj, there is a land acquired by the government.
So
that
this
cannot
matter can be closed now.
It can be closed based on this.
A compliance report has been placed on record. A perusal thereof would indicate that total number of entries which are required to be made in the RTCs as regards the land tribunal orders were 2,75,242, out of which 2,65,074 entries have been made in the respective RTCs as regards any of the orders passed by land tribunals, including the grant of occupancy certificate, etc. The submission of learned AGA is that there are 10,168 entries to be pending to be made, which cannot be made as of now since proceedings are still pending before various courts. A submission is that any orders passed by a land tribunal going forward would be on attaining penalty would be entered in the respective RTCs. The said submission and the report which has been filed is in compliance with the various orders passed by this court. Accepting the compliance to be complete, the petition stands closed. This court places appreciation for IIT Rajendra and AGA for having corresponded with the concerned authorities and having got the other above entries made in the respective RTCs. Thank you, madam.
Grateful, madam.
2,65,000 is not a small number.
Yes. Yes.
List number 2, serial number 1, Manjunath VS.
This matter, on the last date of hearing, the petitioner council has submitted a notification where the union government has now fixed the qualifications for the drug inspectors. Now, my lord, the learned AG who appeared in the matter thought whether we'll seek instructions regarding the implementation of the said order here in the state of Karnataka. My lord, a week's time is requested, my lord, for the implementation. In fact, my lord, this comes under the Commissioner for Food and Safety. You know, food and safety people are all busy with certain
raids
and other things
at all the hotels.
All of a sudden, no, that thing. The Lordship, I kindly have it and requested on Tuesday, my lord, next.
And AG submits that the manner and methodology of implementation of the directions issued by the central government is being considered and necessary action being taken. He seeks for a week's time. Relist on
Tuesday, Monday. He
relist on 1st September.
Serial number 2, Kumar NJ, connected matter.
For the petitioner's counsel. On the last date of hearing, I was directed to produce a copy of the application and the order on that, sought by the petitioner, filed by the petitioner, seeking redeposit of the sale consideration. One is I am yet to get that, and secondly, the learned advocate appearing for response 4 and 5 had just now served at 2 o'clock a copy of about 40 pages, certain documents, which facts need to be made cross-checked. Some reasonable time.
Reply al madiran.
It's not a 40-page, you will ask you 2-page synopsis I have given.
Synopsis, documents.
3 documents which I have given, it is in there and only.
Mr. Kumar can complete his arguments.
Yes.
Then we'll come
for
to
their
Mr.
argument,
Shivaram.
I will comment.
In which one, my lord, may kindly permit
Reply
me to
only you can.
reply. Before that reply, I want to make 2 submissions with regard to the.
Now you want to make before he starts.
No, let him complete, madam. I'll then.
Whatever you want. You want to make it now, you can make it now. That way, that much submission of Kumar will reduce probably.
I may be permitted to place my synopsis, my lord, and along with.
ಅವ್ರು ಮುಗಿದ ಮೇಲೆ
ಆಗ್ಬೋದು ಸರ್.
ಹೇಳಿ.
My lord may kindly permit us to file this. We had short points, my lord, that are involved in this case. Sorry, madam. I'm sorry, madam. My humble apologies, madam. I'm extremely sorry. But the first point relates to court's power as parents patria in cases of minor's interest. I didn't observe that, madam. I'm sorry.
Yes.
Court's powers as parents patria in cases of minor's interest. And I'll be relying on a judgment. I'll be producing a copy of that. Second point is the non-compliance by the seventh respondent stroke deputy commissioner of the provisions of articles 141 and 144 of the Constitution of India. There is a citation. And then the third point is balkanization or compartmentalization of remedy and relief on the single and same cause of action would not be in consonance with the law laid down with Supreme Court regarding void transactions on account of the violation of court orders of injunction. Then, Lord, does the invidious act of response 4 and 5 in approaching the deputy commissioner instead of civil court not being lawful owners tantamount to an attempt to achieve indirectly instead of achieving directly through the civil court? The last point is respond number 4 and 5 having already approached respond number 7, the deputy commissioner Tumkur claiming the right title and interest through a void sale cannot be treated as pro bono complainants. But this is because pro bono. He has a personal interest in the sale deed. Based on which document he approaches the deputy commissioner. Now he can't be permitted to change his robes from a personal interested person to a pro bono publico or a person who can agitate the matter in terms of Rule 144, which prescribes the conditions of granting an NOC, because he stands on a different footing. Granting NOC, there are certain parameters which have to be considered by the deputy commissioner. That 144 may be open to general public also, like in the either Cinematographic Act or any other enactment where third parties also can challenge certain action. But here is a case where it is exclusively based on not respond number 4 and 5 being members of the public. Like supposing, though it may be a fit case for the BPCL to argue, but since the cause of action is one and the same, I may also be permitted to assist your lordship. That is, if they had to approach the DC only on the ground of being owner, as is the requirement under Rule 150, that any right includes a lawful right, and my continuance in the position must be lawful. That's what the Supreme Court has said, which is completely against me. But the distinction is in those cases where exercise of Rule 150 was held to be legal, the landlords were the very same landlords, not the landlords of this type. In this case,
who purchased it subsequently in violation of the order.
In violation of the order. That's the distinguishing factor in there. Therefore, once they have donned the robe of the purchasers, they cannot change their locus from being a personally interested persons in the property into the general public, where allegations can be made against the petrol pump, either for violating public safety or causing public nuisance or any other ground that's covered under Rule 144 of the 2002 petroleum rules.
Yes.
And the suit was filed in the year 2020. At that time, neither the BPCL nor the licensee of the petrol pump were parties to that suit. It was an out and out minor's interest sought to be protected by the mother, natural guardian. And subsequently, when the sale deed was executed, after the institution of the suit and after the order of injunction, she had to implead the BPCL as party plus the purchasers. So therefore, it is her, she is the dominant litigant. And all the challenges to her position or to her interest must be minor centric, not with reference to the BPCL or the licensee who works, who carries on the business under the BPCL. It is in that context, my lord may kindly permit me to read.
Shefali Chakraborty.
But the first citation is Shefali Chakraborty.
Copy.
Paragraph 2 in that on the left hand side. I'll read that para because that's the basis on which this judgment was rendered by the Honorable Supreme Court. Paragraph 2. May I read, Madam?
Yes.
Shefali Chakraborty, as the mother of Master Basab Chakraborty, sought permission from the concerned court in compliance with Section 8 of the Hindu Minority and Guardianships Act 1956 to dispose of the latter's share which she had inherited at the death of her husband stroke his father, late Mr. Basudev Chakraborty. Such application was rejected and affirmed by the High Court. Thus aggrieved, she has presented this appeal. Paragraph 4. In order to act upon the intention to transfer the property to the developer, or in order to act in pursuance of the development agreement, the appellant applied to the concerned court. The court, in rejecting the application, stated thus, the next para, unnumbered paragraph, it is specifically stated. That is irrelevant. It is specifically stated in the petition and in evidence affidavit that the development of property is essential for the future of the minor as well as the better utilization of the same. Except such bald statement, it's not described why and how it's essential for the future of the minor. That was the reasoning, and that was confirmed by the Honorable High Court. Then in paragraph 6, the last two lines, unnumbered para, the legal system employs. But this is essentially the role of the courts as parents patria in the interest, when the interest of the minor is involved. Paragraph 6, last two lines. Yes. It starts. The legal system employs both ex ante and ex post mechanisms in licensing regimes. Prior approvals and regulatory compliance requirements function ex facie
Ex ante controls.
And ex ante controls aimed at preventing foreseeable harm, particularly in sensitive domains such as the liberty of an individual once administrative action is taken. Courts exercise ex post judicial review to examine legality, procedural fairness, and reasonableness. Another next pyramid, another illustrative application of the ex ante stroke ex post distinction arises in family law. That in the other lines may be skipped. And now coming to paragraph 7. Having appreciated the distinction between ex post and ex ante, we delve into section 8 of the HMGA, which is an example of the latter. It governs the powers, limitations, and consequences of a guardian's actions in respect of a minor's property. It reads, that can be skipped, and now my lord may permit me to read paragraph 9 and 10. Only two paragraphs in that manner.
Yes.
Paragraph 9. The requirement of judicial oversight when it comes to the protection of the interests of a minor is an example of the doctrine of parents patria as embedded with section 8. Before going further, a brief detour of the origins of this doctrine and its manifestations in the Indian legal system would be, in our view, justified. The doctrine of parens patria translates to parent of the nation and emanates from the idea that the state bears a moral and legal responsibility toward those who are incapable of safeguarding their own interests. It emerges at the intersection of several strands of political and legal theory that challenge a purely formal conception of autonomy. In the liberal tradition, John Stuart Mill, in On Liberty, famously articulated the harm principle, arguing that state interference with individual liberty is generally unjustified, except to prevent harm to others. Crucially, however, Mill expressly excluded children and persons lacking full rational capacity from the scope of this principle, recognizing that autonomy presupposes capacity. This implicit exception opens normative space for protective intervention. More recently, Martha Alberton Feynman, through works such as The Autonomy Myth, A Theory of Dependency, and The Vulnerable Subject, has reframed the debate entirely by arguing that vulnerability is a universal and enduring feature of the human condition, and that the state has an affirmative obligation to design institutions that respond to this vulnerability. Here itself, we may take note of the fact that in Indian classical tradition, this doctrine was well established. We may only take one example as to what Kautilya has said. The king shall provide the orphans, the aged, the infirm, the afflicted, and the helpless with maintenance. He shall also provide subsistence to helpless women when they are carrying, and also to the children they give birth to. Elders among the villagers shall improve the property of bereaved minors till the latter attains their age, so also the property of gods. In the pages of history, it's found that this responsibility vested in the English crown, which was regarded as the ultimate guardian of infants and persons of unsound mind or mental incapacity. Eventually, I stress this sentence. Eventually, this function came to be in the domain of courts, where the modus operandi was not the usual adversarial method, and instead a continuing and supervisory jurisdiction informed by the considerations of welfare rather than strict legal entitlement. It is this equitable conception of judicial responsibility that traveled into colonial legal systems, including India, and continues to inform modern constitutional and statutory frameworks. In the next para, I want to read 1, 2, 3, 4, 5, 6. Seventh line, it starts from the words the decisive consideration.
Yes.
The decisive consideration, irrespective of committee or prior determinations, is the welfare and happiness of the child. These decisions illustrate the core parens patria feature. The court's obligation is independent, non-deferential, and welfare-centric. Post-independence, this doctrine has acquired constitutional significance. The expansive interpretation of Article 21, read with Article 15.3, are substantive instances of the commitment to protection of the dignity, development, and care. The court's authority to do so is not a creation of the statute, but emanates from its constitutional role in giving practical meaning to fundamental rights where vulnerability undermines autonomy. And Millard, next in para 11, about 4 instances where Millard, this principle is included, 4 enactments. After that, Millard, paragraph 12. Considering all the above examples, a clear pattern can be discernible. Authority held privately of whatever nature is never absolute. Welfare supersedes all else as the governing standard. Courts and statutory bodies do not merely adjudicate disputes, they assume responsibility. Philosophy, constitutional values, common law tradition, and statutory provisions show that parens patria is not a doctrine of narrow application, but an important tool to protect interests whenever vulnerability displaces agency. Then what in paragraph 30, the references are made to other jurisdictions, Germany and other countries. In paragraph 14, after the italics, where the judgment of the Privy Council is extracted, it starts from the words, it cannot replace the courts. May I read?
Yes.
It cannot replace the court's independent assessment of the minor's interests. The court concerned needs to meticulously examine whether any proposed arrangement could compromise the child's present or future rights, taking into account that the minor cannot fully comprehend or appreciate the consequences of such transactions. The best interest of the child is not passive consideration, but a vigorous principle that requires foresight, caution, and meticulous scrutiny in every matter affecting the minor's property for an evident advantage to the minor. In assessing the merits of any transaction, the court must evaluate the likely advantages against the risks. It must determine whether the minor will receive benefits that are secure, measurable, and enforceable. At the same time, it must remain vigilant to possible negative effects such as diminution of value, delay in realization of benefits, or exposure to ventures that could prejudice the minor's undivided share. This is what and after this merit, the judgment was the district court and the high court judgment were set aside, and a sort of a scheme was framed by the Supreme Court itself with regard to the minor's interest. But the next judgment is Court, sir. But this is with regard. But I'll read only paragraphs 1 and 2 in this because the facts are completely different. But they deal with the articles 141 and 144. Here precisely with in respect of the deputy commissioner's violation of article 144, I'll be reading these two paragraphs. It's at page 506, Millard.
Yes.
Paragraph 1. May I read, Millard?
Yes, please.
The judiciary draws its strength from discipline and not dominion. The Constitution of India creates courts of record that are independent in their spheres and yet binds them together through a coherent hierarchy. The high courts in India possess a wide jurisdiction, but the Supreme Court of India remains the final interpreter of law. Article 141 of the Constitution of India declares that the law laid down by this court binds every court in the country. Further, and this is important from the point of view of my case. Further, Article 144 of the Constitution obliges all authorities, civil and judicial, to act in aid of this court. These are not ceremonial recitals. They are the structural guarantee that convert disbursed adjudication into a single system that speaks with one voice and commands public confidence. Appellate jurisdiction, in this case it's writ jurisdiction, right? Appellate jurisdiction exists to correct errors and to settle the law so that like cases receive like outcomes. When a superior court reverses, modifies or remands, the court below must give full and faithful effect to that disposition. The authority to decide on appeal carries the authority to require compliance, for without obedience, the hierarchy would become an empty form, resistance or evasion, which is not necessary. I read these two paragraphs only, Millard, to make my humble submission that respondent number 7, Deputy Commissioner, when a citation of when the judgment of the Supreme Court was cited before that by that authority, it was given a go by, and from that point of view, to that extent, it affects the minor's right also, and therefore that's a case which requires to be set at naught by your lordship in exercise the jurisdiction under Article 226. This is my humble submission, because under Article 144, the Deputy Commissioner and all other authorities are bound to implement the order of the Supreme Court. But secondly, there is absolutely no reference to any. I did not make any submissions. I was only brought on record as third respondent, and the order sheet does not disclose that an opportunity was given to me to present my case before the Deputy Commissioner. To that extent, it suffers from complete non-application of mine, except stating in the cause title that respondent number 3 is on record. Nothing else is stated about the third respondent being a minor before the Deputy Commissioner. Therefore, it was the duty of the Deputy Commissioner also to at least consider the case of the minor, as since the suit was filed much prior to the sale deed, and they were not into the picture. BPCL and others, even including response 5 and 6, they were not in the picture when the suit was filed and when the injunction order was granted. Rest in response to Mr. Shivram's submissions later on. And I also produced a document.
Yes, Kumar.
Most of the ground searched by me is already covered.
That is why it will reduce ಅಂತ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
My lord, leaving aside all the facts stated, my lord, my grounds before this, whether the deputy commissioner was right in passing this order was the only point, my lord, because my limited question, I am the lessee here. So I have taken the license from the authority and my license has been cancelled. So whether the deputy commissioner was right in passing that order is the only question which I will be hesitating before this other court. My lord, kindly see the page number 19 of my writ petition. 23178.
2317. Yes. What do you want us to see?
Page number 19.
19.
19.
Yes.
The provision is extracted, section 150. I may be permitted to read. There are two things in it. One, the licensee has ceased to have any right to use the site for storing petroleum, is the one part of it. Second one is there shall be reasonable opportunity and shall record in writing the reason for such cancellation and shall immediately furnish to the licensee. There are two things, my lord. One, whether the question is whether the licensee has ceased to have any right to use the site for storing petroleum. My lord, here it is true that the lease expired on 2023, my lord. So during the substance of the lease, there was a civil suit instituted by the interested parties and there was an order and I was also made party.
Does your lease have a renewal clause?
My lord, subject to agreement, but it is always subject to
mutual agreement.
Mutual agreement. So since there was a pending litigation and in that litigation, I was also made a party to the proceedings and there was an interim order when the suit was pending, whether DC could have passed this order is the point. Because in that suit, I was asked to deposit the rental and I have been depositing the rental to the court. Whether my possession can be called as illegal possession, whether I being in possession of the property, whether it can be called as licensee has ceased to have any right to use the site.
Yes.
Therefore, the applicant before the deputy commissioner, who was a penitentiary purchaser, whether DC was right in accepting his application as the owner, because he has been considered as the owner. DC has considered his application, considering him as the owner of the property, even though it was brought to his knowledge that he was the penitentiary purchaser of the suit schedule property.
Yes.
And kindly see the reasoning, my lord. Reasoning provided by the deputy commissioner, which is at last page after the provision. ಮೇಲ್ಕಂಡ 150/1 ರೆಡಿ ಎದುರುದಾರಿಗೆ ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ನೀಡಿ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಲಾಗಿದ್ದು ಎದುರು ತಮ್ಮ ಲಿಖಿತ ತಕರಾರು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಎದುರು ಲೀಸ್ ಅವಧಿ ದಿನಾಂಕ 31/8/20 ಮುಗಿದಿದ್ದು ಅದನ್ನು ವಿಸ್ತರಣೆ ಮಾಡಿಕೊಂಡಿರುವ ಬಗ್ಗೆ ಎದುರು ಯಾವುದೇ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಜರುಪಡಿಸಿಲ್ಲ. ವಿವಾದಿತ ಸ್ವತ್ತು ಇದರಲ್ಲಿ ಎಲ್ಲೂ ಅವರು they don't talk about the pending litigation and the interim order passed by them, because not even consider, though it has been recorded, but while giving the reasoning completely ignores about the pending litigation.
ಇದರ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ವಿವಾದಿತ ಸ್ವತ್ತು ಅರ್ಜಿದಾರರಿಗೆ ಕ್ರಯವಾಗಿದ್ದು ಸದರಿ ಕ್ರಯದಂತೆ ಅರ್ಜಿದಾರರಿಗೆ ಹಕ್ಕು ವರ್ಗಾವಣೆ ಆಗಿರುವುದು ದಾಖಲೆಗಳಿಂದ ಕಂಡುಬಂದಿದೆ. ಅರ್ಜಿದಾರರು ಮತ್ತು ಹಿಂದಿನ ಮಾಲೀಕರು ಎದುರರಿಗೆ ಸ್ವತ್ತು ವರ್ಗಾವಣೆಯಾಗಿರುವ ಕುರಿತು ಮತ್ತು ಲೀಸ್ ಅವಧಿ ಪೂರ್ಣಗೊಳ್ಳುತ್ತಿದ್ದು ಸ್ವಾಧೀನ ಸಹ ಬಿಟ್ಟುಕೊಡುವಂತೆ ಅನೇಕ ಕಾನೂನು ತಿಳುವಳಿಕೆ ಪತ್ರಗಳನ್ನು ನೀಡಿದ್ದರೂ ಸಹ ಅದಕ್ಕೆ ಎದುರುದಾರರು ತೆಗೆದುಕೊಂಡಿರುವ ಕ್ರಮದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳು. ಇಲ್ಲಿ ಲೀಸ್ ಅವಧಿ ಮುಗ್ದಿದೆ, ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಪ್ರಕಾರವಾಗಿ ನಾವು ಕಾನೂನು ಪ್ರಕಾರ ತಗೋಬೇಕಿತ್ತು. The reasoning is that I should have taken some action instead of saying that whether he has initiated any proceedings to evict me or not. That has not done as on date. But DC here says that I have not done anything. So that is the reasoning.
Have you filed any specific performance suit?
I have not filed any specific performance. Neither he has filed any suit for eviction suit against me.
You have no license, you have no automatic renewal.
There is no
clauses
automatic.
by mutual.
Very mutual. There is no automatic.
And you are not initiated even as regards that any specific performance?
No. I have also not initiated. He also has not initiated. But the reasoning given by the DC is that I should have done something instead of saying that
licensee has ceased to have any right to use the site. Ashte iradu. Has been evicted antalla.
cease to have any right.
Right.
Because here, in this case, the right is, because it is important to keep in mind the pending litigation, my lord. Because the case was there, the pending litigation was, it was purchased during the pendental act, and there was an interim order.
Your right which is required to be assessed as to what you have done. Even if you have right and if you sleep over it, no right.
I have limited scope.
You cannot say,
I was
they
the
have
one
not
last
done,
one.
therefore my right is there. You can't say that. That if they initiate anything, that is for eviction.
There is no eviction. There is no eviction suit initiated against.
Yes.
So therefore, the fact regarding the pending litigation has not been considered by the Deputy Commissioner at all. And based on the registered documents, without looking into how it was acquired, he has passed an order.
Yes.
So since my possession of the property is not illegal, because I have been directed to deposit the rental before the court, and I have been doing it. I have been recognized by the court as the.
Where is that order?
That has not been produced.
Up to all of you to produce whatever you want to produce. We have asked you twice. We won't ask you again. It's not there. It is not there. Whatever you want to rely upon, please place it on record.
I'll place it. No, I don't think I will point out, my lord, while replying to the argument. Considering all this, my lord, I would request this honorable to allow my petition.
Yes.
Is the synopsis and documents. I'm placing.
ಯಾವ petition ನೋಡ್ಬೇಕು?
First one, my lord, can be 25,697. My lord may take it up.
5,697.
Yes. Can I pass on the
yes,
brief note and the synopsis in another petition?
Yes. Really.
The first. Before that, my lord, if interested, and we are ready to mediate and for a settlement, if.
But the two main people are not here. The husband and mother-in-law are not here.
My lord, during the pendency of that civil suit, because even for a moment, if let us assume that he gets an order, the DC's order is confirmed.
See, all three of you allegation is against the husband and mother-in-law.
Yes, my lord.
They are not here.
No.
Then if you have to negotiate with Mr. Ramu, you will have to recognize his right. Because they are
Because
not there.
That can be discussed, my lord, if he is ready, then only. Because it will be win-win situation. Now, my lord, if there is an interim order, not to alienate, even if he gets a property, he will not be able to utilize it. Considering
That is the first question we asked you when it was said that you can't speak to them. So it did not. But
we
again,
are ready
who
to-
is firing from
because
whose shoulder
what I
is a
want is
different
business.
thing.
I'm not interested in the litigation among them.
At least somebody has come forward to talk to you.
My lord, with great respect to my learned friends and the court, my lord, since 1963, over a period of more than 66 years, neither the original landlord nor myself, subsequent purchaser,
They're not there.
did not enjoy the property, did not allow us to enjoy the property. We were driven to file a HRC petition for recovery of rent.
Mr.
And
Ramu,
to-
you are not holding the brief for the original landlord.
That's correct, Your Lordship.
If you are holding the brief, then
That's
you
correct.
can
I understand.
negotiate with
No,
all
I
of
am
them.
only bringing it to Your Lordship's notice, the tyranny of this case, I am saying, Your Lordship.
You cannot cry for them.
That's correct.
You can cry for
By-
yourself.
When they came to know that I purchased the property, when the case was filed before the civil court, when they were made as a party, they did not make any attempt to come and talk to me at all. That is one thing. That is one thing. Secondly, my lord, all that they are arguing, all these citations quoted, my lord, in respect of the case which are not concerned to the issue in question.
You want to discuss with them, will
No,
you?
my
You don't
yesterday,
want to
day before
discuss them?
yesterday, the last week, my lord said that, my lord. In fact, to discuss with issue for settlement, this, that. They did not come forward. Therefore, the matter came up before the court next day. Then my lord said that you go on with the matter. That is how things have been taken place, your lordship. Things have been taken place, your lordship. They did not come forward, my lord. That is one thing.
Do you want now, Mr.
No, my
Kumar is
lord,
saying-
my parties, my lord, my parties, my lord. Because of the conduct of the petitions before this honorable court, I will satisfy your lordship to the extent, my lord, saying that the injunction order was obtained during pendentalite.
If no, Andre will record no and go ahead with the matter.
No,
Amel matte we'll
it
go
is
on.
not possible, my lord, is my respectful
You
submission,
go
with
ahead
great
with-
respect to your lordship.
You go ahead with
Because
the,
they suffered a lot, my lord, over a period of 3 years, after having paid the amount of 10 crore 50,000 rupees, 50 lakhs rupees, your lordship. They are neither here nor there, your lordship, because of the litigation.
argument ಮಾಡಿ.
Yes, I will.
Lot of people are waiting.
Definitely, my lord.
Without repeating, just ask.
My lord, may kindly, the issue in question before this honorable court, my lord, whether there was a lease extended or not after the expiry of the period, my lord, on 29/1/2023 is the question, your lord. It cannot go beyond the scope of the writ petition, your lord. My respectful submission. The petition filed by the petitioner before this honorable court, my lord, in this writ petition, has no locus standi to challenge the order of the deputy commissioner. For the reason, my lord, the property in question has been purchased by me. This property, my lord, does not belong to the father of the petitioner before this honorable court. Therefore, I have produced the document to show before this honorable court in the partition deed, my lord, this is the exclusive property of my vendor, who is Srimati Krishnameni, grandmother of the petitioner before this honorable court. Kindly take, my lord, the document which I have now produced, my lord.
Yes. Yes, ಹೇಳಿ.
Yes, page. This is the partition deed your lordship entered into during my, in the family member, along with the family members, my lord. The partition deed, my lord, wherein page 26, my lord, may kindly come to. Page 26, it is a partition deed.
Yes.
Who received what, my lord, in respect of the property belonged to P. Narayan Rao and his wife. Schedule B property. This is the property which I have purchased, your lordship, which they say there is an injunct order. all that piece and parcel of so-and-so municipal cost so-and-so fall into the share of Krishnaveni. Old 21/2, old number 21, Batawadi village, Kasabavali, Tumkur Taluk, so-and-so. This is the property 20,000 to 80 square feet which I have purchased, my lord, in 2023, my lord. This is the exclusive property. Next, my lord, may kindly come to Schedule C property, my lord. This is different property, my lord. This is shared by the mother, grandmother of the petitioner and the father of the petitioner. C schedule property. Exclusive property which I have purchased, your lordship. Bharat, father of the petitioner, has got some other property along with his mother. This property, so far as petrol pump where petitioner respondent is carrying on, my lord, is the exclusive property of Krishnaveni, not belong to the petitioner father. The partition deed starts from, my lord.
Partition was executed after the suit was filed.
My lord?
This partition was executed after the suit was filed.
Yes, your lordship. There is no doubt. When the suit was filed, the child was of the year 2.5 years, your lordship. That's one thing.
Subsequent to Section 6 amendment.
That's, yes, that's why. Then, my lord, the subject matter of this property was not the subject matter of the suit at all, your lordship, is my respectful submission. I filed, they filed application after.
Where the plaint?
Plaint, my lord, they themselves are filed, your lordship. Kindly come to page 33, my lord. Page 33 of the petition, my lord, of Tanvi. Page 33. I think it is 41. There are two numbers, your lordship.
Yes, 33.
There are 5 items of the property, my lord. This property which I have purchased, my lord, which exclusively belong to Krishnaveni, grandmother of the petitioner, my lord, he is not a part of the scheduled property. This was
Someshwara extension, SS Puram, Tumkur town.
Yes. I will come to that, my lord. Now it is not a property, my lord. Scheduled
What
property.
about CL number, item number 3?
Item number 3 also, my lord. That is 54/2 is different, your lord. It is 21/2. I will come to that, your lord.
Out of which 15 gunta in which the Bharat Petroleum.
15 ಅಮೆಂಡ್ ಆಯ್ತು ಸ್ವಾಮಿ ಅದು
ಅಲ್ಲ ಈಗ ಅದಕ್ಕೆ ಬರ್ತಾ ಇದ್ದೀನಿ ನಾನು. Please don't interfere. I will now, my lord, kindly take up, my lord, the page 31 of my memo document, my lord, which is now filed, my lord. Therefore, as on the date of grant of
Site number 1540, old site number 1.
Yes.
Of municipal number 237.
Yes.
Is it part of
No.
survey number 54/2?
No, man. No.
If it is part of survey number 54/2?
No, it is not. Therefore, my lord, I would like to go, bring it to your lordship's notice. Page 31, my lord, may kindly see of my memo, my lord. To substantiate what your lordship put, my lord.
Yes.
Page 31, my lord, may kindly see. Page 31.
Yes.
Application filed, my lord, after I pointing out, in 2020, the injunction order came to be passed in respect of all the scheduled properties which is found in plaintiff, your lordship. I filed a written statement saying that if at all, if the petitioner is entitled to any property, that property can be adjusted to any other property owned by me. That is the objection filed by me. And at that time,
owned by me, Andre?
Owned by the father of the petitioner. Owned by father.
ಯಾರಿಗೆ ನೀವು?
ನಾವು ಪರ್ಚೇಸರ್ಗೆ.
ಎಲ್ಲ ಐಡೆಂಟಿಟಿ ಆಫ್ ಪಾರ್ಟೀಸ್ got mixed up.
ನಾನು ಪರ್ಚೇಸರ್ಗೆ.
All three of them think they are the same.
ಇಲ್ಲ ಪರ್ಚೇಸರ್.
You are thinking you are the
me
same.
means, my lord, purchaser. I may take it, my lord. Me means purchaser. Kindly see page 31, your lord. Page 31. The property which now purchased by me, my lord, has been sought to be amended by filing an impeding application in 2024. In 2024, kindly see, my lord, the property number given, item number 1, 2, 3, 4, 5, my lord, which is the property which I have purchased, your lordship. Now, affidavit, your lordship, may kindly see, filed by them, my lord. Then, my lord, kindly come to the order passed by the amendment application.
Which according to you is your property in this?
The property, these are the properties, your lordship, which I own, which I purchased, your lordship.
All these properties?
All these property.
You
All these
purchased all 6 properties?
Not all 6 properties, my lord, some of the property, my lord.
So which properties did you purchase?
That I will point out to your lordship. Now, these properties are not the subject matter of the suit, is my full submission. My principal argument, my lord, there is an injunction order, I would not have purchased the property pendentality. That is the, therefore, they have cited the decisions, your lordship. Those decisions, my lord, they filed a suit for declaration of sale deed as null and void and all those things, my lord. Those decisions is not applicable to the facts of this case, is my full submission. This amendment came to be allowed, my lord, sought for by the petitioner before this honorable court. Page 42, my lord, may kindly see, my lord. Page 42, my lord. Sorry, page 44, your lordship. Page 44. That further the properties are not described properties, it will be a riddle for the plaintiff and also the court in respect of the identification and also demarcation of the properties in case of success. Page 44, my lord.
Yes.
My lord got it. On the contrary, it is necessary for determination of real controversy between the parties. Hence, if the application not allowed, much hardship will be caused to the plaintiff as she will be restrained from pleading the facts at the earliest. On the other hand, if the application is allowed, no hardship will be caused to the defendant number 2 as she will have opportunity of filing additional written statement and also contest the matter. The hardship that will be caused to the defendant number 2 may be compensated accordingly, and in the light of the above discussion, this court is of the considered opinion that the plaintiff has made out grounds to allow the application. Accordingly, the answered affirmative. Application filed, my lord, under Order 6, Rule 17 came to be allowed only on, my lord, on 15/10/2025. I purchased the property in the year 2023. Pendentality will not come into picture.
Pendentality will come.
It may come, but injunction order, no, I have not violated.
Property was not
Property,
subject.
when I purchased, there was no violation of injunction order, is my full submission.
That property was
Because
not
this property was not the subject matter of the suit. One thing. Secondly, while purchasing the property, my lord, the petitioner father, unfortunately, kindly see, that's why I produced the genealogical tree also. He said that avivahita ant helidare. Idralli. Kindly see page 6, your lordship. In the genealogical tree, I am a bona fide purchaser now. I don't know. And page 6, Vamsharukshadali, P. Narayan Rao, grandfather, Bharat anta PR anta tav nodi, kelgade, petitioner father, your lordship. That Tanmi minor father, avivahita anta heli namge heli marata madidare.
Arjidararu.
Oh, Arjidararu. That's why I produced the document also, my lord. We do not know, my lord. This entire property put together, my lord, it comes to 22,880 square feet, which was not the subject matter in the suit, is my full submission, my lord. It is survey number 21/2, my lord, old survey number 21. That's the document which they have produced, my lord, is in respect of survey number 54/8, your lord. 54/2, which is totally different, my lord. What is purchased by me is this, my lord. In this survey number, whatever property is available, I have purchased, your lord. And now kindly come to the order passed, injunction order passed by the trial court, my lord, in the beginning. While injunction order, after passing the injunction order, my lord, while directing consideration of application filed under IAF under section 151, my lord, directing deposit of amount. Page 9, para 19, my lord. Page 118. 118 page, para 19, my lord, of the petition in Tanvi's case, your lordship. So according to those documents, my lord, injunction order was not there in respect to the property in question. The property in question is a complete exclusive property of the Krishnaveni, not the petitioner father. Thirdly, I am a bona fide purchaser and I do not know.
118.
118 ಅಂತ ಇಲ್ಲಿ ಅವ್ರ ಪೇಜ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಪ್ಯಾರಾ 19 ಮಾಡಿ ಅವ್ರದೇ ರಿಟ್ ಪಿಟಿಷನ್.
18 is an application under rule 150. Last prayer portion is at 118.
ಅವ್ರು ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇದು
ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಅವ್ರ ಕೊಟ್ಟಿರೋ ಪಿಟಿಷನ್ ಲೈನ್. ಇಟ್ ಇಸ್ ದೇರ್ ಪಿಟಿಷನ್.
ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್?
Tanvi case 25,697, my lord, I am saying.
ಇದು ಬೇರೆ.
I am arguing that case, your lordship.
ಅದೇ, that is what you have been
ಅದರಲ್ಲಿ
saying, but
or else your lordship may
annexure
E, my lord, annexure E ನನ್ನಲ್ಲಿ ಪೇಜ್ 105 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
annexure E starts at 97.
ಇಲ್ಲಿ ತಪ್ಪಾಗಿ ಏನೋ ಇದೆ ಇಲ್ಲಿ. Kindly take it, my lord, 110, your lordship. Then 110, two numbers are there, your lordship. Therefore there is a confusion. 110 para 19, my lord. This application was filed by the petitioner plaintiff, my lord, before the court below. Para 19. Of course, defendant number 1 and 2 have contended in their written statement, that is myself and my mother, petitioner father and his mother, statement that there are other properties and share of minor plaintiff can be compensated in any other item if she succeeds in the suit. Both at this juncture, same cannot be adjudicated, and furthermore, defendants have entered for the partition deed during the pendency of the suit, as well as they got mutation and kata, etc., etc. Therefore, father has agreed here. In the event if she succeed in the suit filed by her, it will be compensated in any other property which he is having. It is not as if this is the only property available, and more so, she is not a owner of the property. That is, the Krishnaveni is the owner of the property, exclusive property. My son is also not having any right over that property. Mother petitioner is only having a property in the property owned by her father only. Is my response. Therefore, my lord, the order, my lord, the deputy commissioner order is restricted to whether there is an existence of lease or not. If there is no existence of lease under the law, you cannot continue to run the show. Is the legal presumption, legal issue, my lord. Under section 154, my lord, if there is no lease extended, then there cannot be NOC, no NOC can be issued. There cannot be explosive license cannot be issued. Fire license cannot be issued. Labor license cannot be issued. Trade license cannot be issued. These are all lacking, my lord, in this case. Of course, by virtue of the interim order, my lord, they are running the show in the absence of NOC, in the absence of fire license, in the absence of fire license, in the absence of trade license, in the absence of labor license. They are running the show. Then, my lord, kindly see, my lord, page 21 of the order of the learned deputy commissioner. Since I purchased the property, my lord, I stepped into the shoes of my vendor. I filed the application. There is no bar that I should not file application seeking relief before the competent authority. The district officer, district commissioner is the competent authority under section 144. He is the controlling authority who has to issue NOC or to reject or renew or suspend or cancel. Therefore, I went before him. Look here, there is no lease extended. Therefore, stop the business. What is wrong in it is the question. What is the error of law that the deputy commissioner has committed is not pointed out is my responsible submission. Kindly see, my lord, page 21, last para, page 21 ಅಲ್ಲಿ ಅರ್ಜಿದಾರರು ವಿವಾದಿತ ಬಟವಾಡಿ, there also they claim that the opportunity was given. They said that 142 case is there, injunction order is there, etc. They pleaded. ಅರ್ಜಿದಾರರು ವಿವಾದಿತ ಬಟವಾಡಿ ಗ್ರಾಮದ PID ಸಂಖ್ಯೆ 5720 so and so, RCC building so and so, so and so. My lord, may excuse me saying these words and other things, my lord. ಅದರ ಪೂರ್ವದ ಮಾಲೀಕರಿಂದ ನೋಂದಾಯಿತ ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುವುದು 23/1/23 ತಿಳಿಸಿರುತ್ತಾರೆ. ತಮ್ಮ ವಾದ ಸಮರ್ಥಿಸಲು ರಿಜಿಸ್ಟರ್ ನಂಬರ್ ಸೋ 23 ಕ್ರಯಪತ್ರದ ನಕಲನ್ನು ಹಾಜರುಪಡಿಸುತ್ತಾರೆ. ಕ್ರಯಪತ್ರ ಪರಿಶೀಲಿಸಲಾಗಿ ಶ್ರೀಮತಿ ಕೃಷ್ಣವೇಣಿ ಮತ್ತು ಅವರ ಮಗ ಭರತ್ ಎಂಬುವರು ತಮಗೆ ಒಟ್ಟು ಕುಟುಂಬದ ಆಸ್ತಿಯಲ್ಲಿ ವಿಭಾಗದಂತೆ ಬಂದಂತಹ ವಿವಾದಿತ ಸ್ವತ್ತನ್ನು ಅರ್ಜಿದಾರರಿಗೆ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ನೀಡಿದ್ದು, ಸದರಿ ಪತ್ರದಲ್ಲಿ ತುಮಕೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಯವರಿಂದ ROCR ನಂಬರ್ ಸೋ ನಂಬರ್ಸ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಮೂಲಕ ಕೃಷ್ಣವೇಣಿಯಾದ ನಾನು ನನ್ನ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಪಡೆದಿರುವ ಸದರಿ ಸ್ವತ್ತನ್ನು ಈ ಹಿಂದೆ ಕೃಷ್ಣವೇಣಿಯಾದ ನನ್ನ ಮಾವನವರಾದ ಹಾಗೂ ನನ್ನ ಮಗನಾದ ಭರತ್ PR ಅವರಿಗೆ ತಾತನವರಾದ P. Narayan Rao. It is an individual property of a P. Narayan Rao. He has given the property to son also. He has given the property to the Krishnaveni also, but daughter also. Daughter has sold the property, Your Lordship. ನಾರಾಯಣ ರಾವರು 1/10/63ರಲ್ಲಿ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನು ಬರೆಸಿ ಸದರಿ ಪತ್ರವನ್ನು ತುಮಕೂರು ತಾಲೂಕು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರ ಕಚೇರಿಯಲ್ಲಿ 1ನೇ ಪುಸ್ತಕದ ಸೋ ನಂಬರ್ ಆಗಿ 8/11/63ರಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಆದ ನಂತರ ಭಾರತ್ ಪೆಟ್ರೋಲಿಯಂ ಕಾರ್ಪೊರೇಷನ್ ಕಂಪನಿಯವರು ಸದರಿ ಲೀಸ್ ಡೀಡ್ ಅನ್ನು ಮುಂದುವರೆಸಿದ್ದು, ಸದರಿ ಕಂಪನಿಯವರು ತಿಂಗಳಿಗೆ 71,777,100 ರೂಪಾಯಿಗಳ ಬಾಡಿಗೆಯನ್ನು ನೀಡುತ್ತಿದ್ದು, ಸದರಿ ಲೀಸ್ ಬಾಡಿಗೆಯನ್ನು ಮೇಲ್ಕಂಡ ಕೃಷ್ಣವೇಣಿಯಾದ ನಾನೇ ಪಡೆಯುತ್ತಾ ಬಂದಿರುತ್ತೇನೆ. ಸದರಿ ಲೀಸ್ ಡೀಡ್ ವಾಯಿದೆ 10/19/23 ಮುಕ್ತಾಯವಾಗುತ್ತದೆ. ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತನ್ನು ಈಚೆಗೆ 4/11/2022ರಲ್ಲಿ 22-23 ಸಾಲಿನವರೆಗೂ ಕಂದಾಯ ವಗೈರೆ ಪಾವತಿ ಮಾಡಿಕೊಂಡು ಅನುಭವಿಸಿಕೊಂಡು ಬಂದಿರುತ್ತೇನೆ ಎಂದು ಉಲ್ಲೇಖಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಲೀಸ್ ಡೀಡ್ 1/9/23ಕ್ಕೆ ಮುಕ್ತಾಯವಾಗುವುದು ದೃಢಪಡುತ್ತದೆ. After 1923, when the registered lease deed expired, what is their locus standi to continue in the premises is the question, Your Lordship. And what is the locus standi of the petitioner to call in question the apart from the filing of the partition suit, Your Lordship? The declaration suit is not sought saying that the sale deed executed is illegal, this, that, my lord, they did not say, my lord. The only partition deed, the partition suit has been filed. In the event in the petitioner succeeds, my lord, she can get a property from her father share, my lord. That is her look after, Your Lordship. Because there are other properties standing in the name of the father of the petitioner is my sole submission, as I pointed out through the lease deed, Your Lordship. That is the submission made before the court also, in the civil court. Therefore, what is our right to file a writ petition in this challenging the order of the deputy commissioner? He does not amount to joining hands with the dealer and the company is the question. The petitioner before this honorable court did not approach this court with clean hands. Is my sole submission, my lord. She has no locus standi for the reasons stated now, my lord. Then, my lord, thereafterwards, my lord, the order came to be passed by the learned deputy commissioner, my lord. He did not ask him to evict. He stopped at stage. NOC is there is no NOC. Lease deed period expired. Therefore, it is understood that you should not run the show. That is all he said. He did not exceed his limit. Kindly see, my lord, page 154. 144, my lord, is the no objection certificate who should issue. 144.
Rules put together, separately.
Petroleum rules, 2002.
Print out together. Which rule do you want us to see?
144, my lord, no objection, deals with no objection certificate.
Yes.
To file a writ petition before this honorable court, he should have a locus standi. The company should have a locus standi that he should have no objection certificate from the hands of the competent authority. You should have an extended lease period from the landlord. That is the law of the land also, my lord. I will bring it to your lordship's notice. Where the licensing authority is the chief controller or the controller, as the case may be, an applicant for a new license other than the license in file number so and so shall apply to the district authority with 2 copies of the site plan showing the location premises proposed to be licensed for a certificate to the effect that there is no objection to the applicant receiving license for the site proposed, and district authority shall, if he sees no objection, grant such certificate pro forma specified in sub rule 7 to the applicant, who shall forward it to the licensing authority with his application in file number 9. In 2063, my lord, they followed this rule. When the 30 years lease was over, they did not follow this rule at all, because they filed a suit against me, against the owner of the property. I will then, my lord, after this I will bring it to your lordship's notice. They filed a suit against the owner of the land. In the said suit, there is an order passed by the trial court, my lord, in the suit filed by them, my lord, saying that as per since the Burma Shell Oil Company has taken over by the Bharat Petroleum Corporation in 1976, therefore, as a matter of right, one term lease has to be extended for another 30 years. Based on that, the lease came to be extended for 30 years from 1993 to 2023. That I have extracted, my lord, in the order. Even that order was also not followed by this company. Therefore, I said that they did not approach this with clean hand. They did not follow they have no courtesy to follow the direction issued by the trial court, where they said that you get a extension order from me, from the original owner, or else if the owner does not come forward to execute the extension of lease as directed, as decreed in the suit, you can get the lease deed executed through the court. This is the decree passed by the trial court in OS 584 of 1996. They did not follow that also. I have extracted, I will come to that also, my lord. Why these people should be showed any concession is my respectful submission. When they do not have courtesy to follow the direction, and they enjoyed the status without getting an extension from the original owner, and without taking the court order also in regard to that. Both angle, my lord, they failed to get the extension of lease after 1993 till 23. However, they enjoyed the status, my lord, for 30 years in the absence of extension of lease deed by the owner or by the court on the basis of the strength of the decree. Therefore, I said that they did not approach this court with clean hand. They do not deserve any sympathy by this honorable court under Article 226. 150, my lord, may kindly see, my lord, now. 150 of the petroleum rules. A no objection certificate granted under Rule 144 shall be liable to become cancelled by the district authority or the state government. My lord, got it, my lord?
Yes.
If the district authority or the state government is satisfied that the licensee has ceased to have any right to use the site for storing petroleum. Here is a case where his lease come to an end in 2023. He ceased to operate. Law is very clear on the point. It is not unlike other lease. This lease is not like another better lease. This law is very specific. Provided that before cancelling a no objection certificate, the licensee shall be given reasonable opportunity of being heard. That has been given. He has not shown the extension of lease period before this deputy commissioner. Therefore, deputy commissioner has rightly passed the order. What is the error of law committed by the deputy commissioner? He has passed the order in accordance with section 150 of the petroleum rules because they did not produce any document. That's what the deputy commissioner says. As on the date of filing the appeal by purchaser of the property, they would have produced. Look here, I have got the extended the lease deed by the owner of the property. Therefore, you cannot stop running of the point. They would have said there is no extension of lease deed executed by the original owner or by the subsequent owner. The rightly order has been passed by the deputy commissioner. What is the error of law? They do not point out any error of law committed, except saying, my lord, there is an injunction suit filed by the petitioner. They have set up the suit filed by the petitioner because there is a divorce case pending between the mother of the petitioner and the father. The last 10 days back, my lord, even the divorce was also granted to the father. That is also granted. I could not get the copy, your lordship. That's why, my lord, I could not place it. Otherwise, I would have placed it. Because of their internal dispute, these people are taking advantage by setting up one another. After raising an objection before this honorable court, these two writ petition as not maintainable in the law because he is only a dealer. She is only claiming a right over the property belong to her father. What is their right? I called it. I argued, my lord. Thereafter, my lord, these person, my lord, company went out taking time. Then, my lord, they joined together and filed the writ petition. I can say this, my lord. What prompted him to file not to file a writ petition before they file a writ petition is the responsible submission if you are denying. Therefore, he was just looking to see, picture what is going to happen in these two. He want to grind his axe in between these two. Therefore, after thought, he filed this writ petition. Therefore, the petition filed by the company is also not maintainable. They have no locus standi to challenge the order of the deputy commissioner as full submission. One minute, madam. ಇನ್ನೂ ಆಗಿಲ್ಲ ನಾನು. 3 ಜನ ಟೈಮ್ ನಾನು ಒಬ್ಬ ಮಾಡಬೇಕು. Now this is in respect of that Thanvi minor daughter case, your lord. Next, my lord, this BG Shivprakash Mirji, petitioner who is a petitioner, my lord, who is none other than the elder brother of the then police commissioner, my Bangalore police commissioner, my lord. Kindly see, my lord, the objection filed by me, my lord, for a moment. In that, my lord, I have highlighted. Kindly take, my lord, my objections, my lord. Filed on 12th November 2025 in WP 25,525 of 2025, my lord.
25,520.
Yes, your lord. Filed by the dealer. He allowed the dealers to file a writ petition. He allowed a minor daughter to file a writ petition, minor girl to file a writ petition. And he did, company do not wish to come forward to file a writ petition. Please note the objection filed by me, my lord, for a moment. Wherein I said that, my lord, they filed a suit. Bharat Petroleum itself has filed a suit after the expiry of the, when we initiated the proceedings, my lord, under the HRC Act.
I have for vacating a statement of objection.
A statement of objection of vacating, my lord. Vacating, I am sorry. When I initiated proceedings, my lord, HRC Act alla initiate ಮಾಡಿದಾಗ rent ಗೆ ಎಲ್ಲ ₹900 63ನೇ ಇಸ್ವಿಯಿಂದ ರೆಂಟ್ ತಗೊಳ್ಳೋದಕ್ಕೂ ಇನಿಷಿಯೇಟ್ ಮಾಡಬೇಕಾಗಿ ಬಂತು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನ. ದಟ್ ಈಸ್ ದಿ ಟಾರ್ಚರ್ ದೇ ಹ್ಯಾವ್ ಗಿವನ್ ಟು ದಿ annexure R1 is a suit filed by the Bharat Petroleum. The petitioner in writ petition number 21,587 alla nimdu Bharat Petroleum Company. Yes. Kindly come to the prayer, my lord. Page 18. Declaring, page 17 is the prayer, my lords, sought by them. Declaring that under the provisions of the Act of 1976, this Barmasel Oil Company Act, your lords, the plaintiff is entitled to renewal of the lease of the suit premises for 30 years from 1/9/1993 to 31/8/2023, directing the defendants by a mandatory injunction to execute a renewed lease deed in favor of the plaintiff in terms of the draft lease being annexed so and so, so and so. Accordingly, my lord, this suit came to be allowed. Then, my lord, a direction was issued, my lord, to us. Para 7 of my objections, my lord, may kindly see. Para 7, my lord. No. Sorry.
Para 7, no?
Para, I'm sorry. Not para 7, my lord. Yes. Para 4, my lord. Para 4. Para 4 of the application, my lord. Para 4 of the application, which I just now your lordship seen, my lord. Para 4 in the same document, my lord.
Is amended plain.
Amended ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ 4 ತಾವು ನೋಡಬಹುದು ಇವಾಗ ವಿತ್ ರೆಫರೆನ್ಸ್ ಟು ವಾಟ್ ಐ ರೆಡ್ ನೌ ಮೈ ಲಾರ್ಡ್.
ಯಾವ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ?
ಪೇಜ್ ನಂಬರ್ 2 ಪ್ಯಾರಾ ಪೇಜ್ 2 ಪ್ಯಾರಾ 4 ಮೈ ಲಾರ್ಡ್.
ಪೇಜ್ ನಂಬರ್
ಇದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ನಲ್ಲಿ ಅದೇ ತಾವು ಈಗ ನೋಡ್ತಾ ಇರೋದೇನೆ ಸರ್.
ಪೇಜ್ 2
ನಲ್ಲಿ
ಅಪ್ಲಿಕೇಶನ್. Yes.
Before that, para 3, I will start, my lord. It will have a connection, my lord. It is submitted that Padmavatama, wife of late B. Narayan Rao, had issued a legal notice dated 36/1983 on behalf of all her children, terminating the lease deed dated 20/10/1963, executed by her husband because he died, my lord, in 1970. P. Narayan Rao, andre lease deed execute ಮುಗಿದ ಮೇಲೆನೆ terminate ಮಾಡಿದ್ರು ಅವರು, which comes to an end by 31/8/1983. The respondent number 2 to 4 replied to the said notice of termination and stated as follows. We note that you are not inclined to extend the lease period further due to certain domestic problem. My lord may kindly note this also. In continuation of our letter dated 28/4/1983, we wish to reiterate that we are bound to renew the license on the same terms and conditions from 1/9/1983 for a further period of 30 years in view of the statutory right. They exercise this statutory right which I have just now read over, my lord. Statutory right, 30 years in view of the statutory right conferred on us under Burma Cell Acquisition of Undertaking in India Act 1976. The reason given by you regarding your inability to extend the lease is not acceptable. Further states that there are statutory conditions that law and therefore lease cannot unilaterally terminate it. Therefore, they filed under the situation, they filed a suit, my lord, 584/96. Then, my lord, that is the relief which I have extracted, which I have just now read over. Annexure R1, my lord. Therefore, your lordship may, in that, my lord, the declaration was given is extracted, your lordship may kindly see. It is declared, orderly, 1/4/14 it is declared that under the provisions of Burma Shell Acquisition of Undertaking India Act 1976, my lord got it, my lord.
Page number?
ಅದರಲ್ಲಿ ಕಂಟಿನ್ಯೂಸ್ ಸ್ವಾಮಿ, ಪೇಜ್ 3 ಪ್ಯಾರಾ 4 ಆದ್ಮೇಲೆ ಆಲ್ಟರ್ನೇಟಿವ್ಲಿ then, my lord, R1 is the plaint in OS number 584 of so and so. The said suit came to be decreed partly ಅಂತ ಹೇಳಿದ್ಮೇಲೆ what is the order ಅಂತ ಬರೆದಿದ್ದೀನಿ. It is declared that under the provisions of Burma Shell within bracket Acquisition of Undertakings in India Act 1976, plaintiff is entitled to continue in the possession and enjoyment of the suit schedule property as a lessee for a period of 30 years from 1/9/1993 on payment of quarterly rent of rupees 900 to the defendant, 20,000 square feet ಗೆ 900 rupees to the defendant on the same terms and conditions contained in the lease deed dated 1/8/10/1963, which exhibits so and so. Defendants are directed to, this is relevant, my lord, which I have just argued. Defendants are directed to exercise the registered renewed lease deed in favor of plaintiff on the same terms and conditions as those contained in the registered lease deed dated 8/10/1963. Whether they have exercised the power is the question. Next, if the defendant fails to execute the same within the period of 3 months from today, the plaintiff is entitled to get it executed through process of court. These two did not carry it out. Therefore, illegally they continued even from the date of decree, that is 2014 also is my Rasul submission, not today. 2014, then the said order is being
That is attained finality.
Attained finality, my lord. The said order is being conditional order which was not acted upon by partition to the suit, parties to the suit. Hence, the same was not binding on these respondent number 6 and 7, nor binding on vendors of the respondent number 6 and 7. After the decree obtained by the respondent number 2, the petitioner did not approach these respondents for getting the lease deed renewed from 1/9/1983 as per the judgment of the decree, nor these respondents have executed any extension of lease deed in favor of petitioners, nor in power in favor of the respondent number 2 to 3, as the petitioner himself was not interested to get the lease deed renewed for not the same through the court, but allowed it to spend itself. Therefore, as on the date of obtaining the decree in OS number 584 of 1986, and as on today, there is no existence of the lease deed extended by the respondent number 6 and 7 or by the erstwhile owner Srimati Padmavathamma and family. Therefore, in the absence of the same, the petitioner cannot be called as a tenant and holding over in as much as after 1/9/1983 or after the decree dated 1/4/2014, my lord, this is 14, till 31/8/2023, which expires 31/8/2023.
One nimisha, cannot be called as tenant holding over in as much as after 1/9/93 or after the decree dated 1/4/24.
1/4/2014, my lord. 1/4/2014 ಅದು ಮಿಸ್ ಆಗಿ ಟೈಪ್ ಆಗಿದೆ. 1/4/2014, my lord.
Yes.
Till 31/8/2023.
It is because.
Yes, the correction now. And subsequent to 31/8/2023. Whether these persons can be shown any concession.
31/8/23 is your purchase.
Yes, my lord.
Yes.
Whether they under the circumstances, my lord, when they do not have respect for the court order, when they did not come forward to extend the lease agreement by my erstwhile owner. nor by the
after
court.
1993, there's no.
ಇಲ್ವೇ
release,
ಇಲ್ಲ.
But they're continued.
Continued. ಇದೆ ಹೀಗೆ.
Yes.
Suppose tomorrow, if fire accident takes place in the premises, there is no NOC, there is no fire permission, there is no trade license. He will be carrying on the business. Petrol bunk burst ಆಗುತ್ತೆ. Thousands of people in the city, they will be moving on around. What is the fate of that? Who is going to decide is the question? Their fate. We should think of the public issue, my lord, not the individual. He may shift his business premises from this place to another premises. But once life is taken away, it will not be given by either by me or by him.
Yes.
Therefore, my lord, there is no lease existing from 1993 till date. Therefore, the right.
Their submission was after 1993, 30-year lease was extended.
Extended by the court by virtue of operation of law, subject to the condition that they should get extended lease deed by the erstwhile owner. That is the direction issued clearly.
Where is that portion of the order?
Yes, my lord, I will read. Page annexure R1 ಅಂತ para 4, page 4, para 4, page 3, last para, my lord. Alternatively ಅಂತ ಆದ್ಮೇಲೆ ಇದೆ ನೋಡಿ ಸರ್. Alternatively ಅಂತ page 3 ನಲ್ಲಿನೇ.
ಅಲ್ಲ ಅದು ನಿಮ್ಮ ಅವರ್ಮೆಂಟ್ ಆಯ್ತು. Where is that order?
Order, my lord, ಅದು ನನಗೂ ಸಿಗ್ಲಿಲ್ಲ ಅದು, ಬಟ್ ನನಗೆ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿಕೊಟ್ರು, ಅದನ್ನ ನಾನು ಹಾಕಿದ್ದೀನಿ ಸರ್. They are not disputed at all. It has reached the finality. I also know under the rules, my lord, Burma Shell Oil Company rules, my lord, one term.
There is no lease deed executed post 1993.
No. Except the court decree, they did not get the lease deed extended by my owner, erstwhile owner, nor through the court. It is not their case. I did not come forward to execute the lease deed as directed by the court in the civil court in OS number 584 of 1996 in the year 1994. Or it is not their case that we filed an application before the court. Since I did not come forward to execute the extension of lease deed, I requested the court to execute the sale deed.
That execution court they had to go, that also they have not gone, is what you say.
That is final, my lord. When that being the situation, what is their right to challenge the order of the deputy commissioner before this honorable court is my respectful submission, your lordship. Should I not enjoy my property? Right to property, no, though not a fundamental right. It is a legal right under Article 300A of the Constitution of India.
Next year.
Yes, your lord. Therefore, my lord, the other aspects, my lord. Therefore, the decree was also not followed, your lordship, is my respectful submission. Then the sale deed, my lord, my sale deeds 23/1/2023, my lord, the next document, annexure R3, that is not in dispute, your lordship. 10 crore 50 lakhs rupees paid, my lord, on 29/1/2023, but I am not enjoying any benefit, my lord, out of it. And this property was exclusively standing in the name of my vendor, Krishnaveni. It was not standing in anybody's name, my lord. There is no partner or share in the property. Annexure R4.
Yes.
Annexure R4. Next, my lord, may kindly come to assessment extract, my lord, which is standing in the name of after purchase, my lord, it has come to my share, my name, the purchaser's name, my lord. Now, my lord, may kindly come to annexure R6, my lord. All license, all authorities changed the name in my favor, your lordship, by the Mysore Mahanagara Palike, Tumkur Nagara Palike, and other authorities, your lordship. Annexure R6, page 59, my lord. A notice issued by the health officer to the company, to the petitioner company, my lord, my kindly dealers company. ಅನಧಿಕೃತವಾಗಿ ನಡೆಸುತ್ತಿರುವ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಅನ್ನು ಸ್ಥಗಿತಗೊಳಿಸುವ ಕುರಿತು, ಮೈ ಲಾರ್ಡ್ ಗಾಟ್ ಇಟ್, ಮೈ ಲಾರ್ಡ್, ಪೇಜ್ 59. ಎಸ್ ಮೇಡಮ್. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತುಮಕೂರು ಗ್ರಾಮದ ಬಟವಾಡಿ ಗ್ರಾಮದ ಸರ್ಕಲ್ನಲ್ಲಿ ತಾವು ನಡೆಸುತ್ತಿರುವ ಪೆಟ್ರೋಲಿಯಂ ಎಂಬ ಬಂಕ್ ನಡೆಸಲು ಬಾಡಿಗೆ ಕರಾರು ಪತ್ರ ಹಾಗೂ ಪರವಾನಗಿ ಇಲ್ಲದ ಕಾರಣ ಭಾರತ್ ಪೆಟ್ರೋಲಿಯಂ ಉದ್ದಿಮೆಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸಿ ಸದರಿ ಜಾಗವನ್ನು ತೆರವುಗೊಳಿಸಬೇಕು. ತುಳಸಿದೇವಿ ಪಾರಿಕ್, ಅನಿತಾ ಪಾರಿಕ್, ಗ್ರೌಂಡ್ ಫ್ಲೋರ್, ಸೋ ಅಂತ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸುವುದು ಸರಿಯಷ್ಟೇ, ಮನವಿ ಸಲ್ಲಿಸುವುದು ಸರಿಯಷ್ಟೇ. ಅದರಂತೆ ತಮ್ಮ ಉದ್ದಿಮೆಗೆ ಸಂಬಂಧಿಸಿದ ಬಾಡಿಗೆ ಕರಾರು ಪತ್ರದ ಅವಧಿ ಕೂಡ ಮುಗಿದಿದ್ದು, ಈ ಸಂಬಂಧ ಉದ್ದಿಮೆದಾರರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಬಹುದೆಂದು ಉಲ್ಲೇಖ 2ರ ರೀತಿಯ ಸಂಬಂಧಪಟ್ಟ ವಾರ್ಡನ್ ಆರೋಗ್ಯ ನಿರೀಕ್ಷಕರ ವರದಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಆದುದರಿಂದ ಈ ನೋಟಿಸ್ ತಲುಪಿದ 15 ದಿನಗಳೊಳಗೆ ತಮ್ಮ ಉದ್ದಿಮೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಸ್ತುತ ಸಾಲಿನ ಬಾಡಿಗೆ ಕರಾರು ಪತ್ರದ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ಲಿಖಿತ ಸಮಜಾಯಿಷಿಯನ್ನು ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸತಕ್ಕದ್ದು, ತಪ್ಪಿದಲ್ಲಿ ನಿಮ್ಮ ಮೇಲೆ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುವುದು. For this, no answer. Kindly see this is relevant, my lord, for Annexure R7 page, PESCO has issued, page 60, petroleum, territory manager, my lord, petroleum retail outlet, Bharat Petroleum Limited at so and so district. This office is in receipt of email Sri Ramesh Parikh that we have sent it to your lordship, forwarding the copy of the order of the district magistrate, Tumkur district, Tumkur bearing number so and so. The aforesaid order is on cancellation of NOC number so and so dated 25/10/1999, issued by the district authority, Tumkur district, Tumkur, Karnataka, covering your petroleum outlet mentioned in the subject. In consequence to the above, the subject license stand cancelled as required under Rule 152(2) of the Petroleum Rules 2002. 2000, they themselves cancelled my lord, license. Suppressing all the serial facts, my lord, they filed a writ petition. Then, my lord, may kindly come to Annexure R8, please.
In pursuit of the impugned order.
No, my lord, no.
18/7/25 is the impugned
No,
order.
impugned order, my lord, is dated 18/7/2025, your lordship.
The 18/7/27, you.
Yes, your
forwarded
lordship.
to
Subsequent to that, your lordship.
The government of India.
True, my
Ministry of
lord.
Commerce,
True.
and they have done that.
Yes, true, my lord. Then, my lord, Annexure R8, my lord, may kindly, Annexure R7. R7, I read it, your lordship. Annexure R8, page 62.
This is also again
13 June 2025, my lord. This is 13 June 2025, my lord.
13/6.
13 June, 17/6, 2025. This is also to any action which may be taken against you. You are advised to respond on the subject matter, explaining your corrective measures if you prefer to do so within 21 days, so and so. This is the notice given to
Yes.
them, my lord. Then kindly come to notice issued by the labor officer, my lord, page 63. ಅದರಂತೆ ಪೆಟ್ರೋಲಿಯಂ ನಗರದ ಪಟವಾಡಿ ವೃತ್ತದಲ್ಲಿರುವ ಬಿಜಿ ಶಿವಪ್ರಕಾಶ್ ಮಿರ್ಜಿ ಹೆಸರಿನ ಭಾರತ್ ಪೆಟ್ರೋಲಿಯಂ ಬಂಕ್ ಸಂಸ್ಥೆ ಹೆಸರಿನಲ್ಲಿ ಪ್ರಸ್ತುತ ನಮ್ಮ ಇಲಾಖೆ ಕಚೇರಿಯಲ್ಲಿ ಅಂಗಡಿ ಮತ್ತು ವಾಣಿಜ್ಯ ಸಂಸ್ಥೆ ಕಾಯ್ದೆ 61 ಯಾವುದೇ ನೋಂದಣಿ ಪತ್ರವು ಚಾಲನೆಯಲ್ಲಿ ಇರುವುದಿಲ್ಲ. So they have not registered at all, my lord. Therefore, there is no notice, there is no NOC, there is no extension of lease, there is no fire license was not issued, trade license was not obtained, and labor license was also not obtained. They did not intimate anything to the authority in spite of notice. Why these people should be shown a mercy is the irresponsible submission. Law, as the Deputy Commissioner has rightly exercised his power under Section 152 of the Act, your lordship. There is no error committed, is my respectful submission. In view of the previous orders of various courts, my lord. In at any stretch of imagination, the suit filed by the Tanvi, who is a minor daughter, my lord, in 2020, in any way it will not attract me, because I have not purchased the property. When there is an injunction order, they say for 39(2)(a) filed, let them file at 39(2)(a), no problem at all. Property itself was included. When I pointed out it by written statement, they incorporated in 2025. How can an injunction order can be made applicable to me is the question. They went on arguing the matter like in that line only. There is an injunction order, pendentality, etc., etc. If there is any property owned by my father as admitted by him, he is always entitled to take the property. Neither the petroleum corporation, nor the dealer, nor the daughter, that minor daughter cannot come in our way, because we are a bona fide purchaser, is my respectful submission, lordship. In regard to this, my lord, 3 judgments are there, my lord. More than that, I don't trouble your lordship.
Good.
Yes, I have recorded. Take it. In a identical situation, when there is no NOC, when there is no extension of lease, what is the position of law? What is the law decided, my lord, is the Lord, kindly come to para 9, my lord. Para. Before that, my lord, I hope, my lord, para 4.1 ಇಂದ ಹೋದ್ರೆ ಒಳ್ಳೇದು ಅಂತ ಕಾಣಿಸ್ತದೆ. ಒಂದ್ ಎರಡು ಮೂರು ಪ್ಯಾರ ಶಾರ್ಟ್
4.1 ಇಂದ 9 ವರೆಗೂ ಓದ್ತೀರಾ?
ಇಲ್ಲ ಅಲ್ಲಿ ಗಂಟೆ ಬೇಕಾಗಿಲ್ಲ. ಅಲ್ಲಿ ಬರ್ತಿದಂಗೆನೆ ತಾವೇ ನಾನು ಸ್ಟಾಪ್ ಮಾಡು ಅಂತ ಹೇಳ್ತಿರ್ತೀನಿ. Para 4.1, submission of behalf petitioner. Learned counsel for the petitioner R.M. Sharma heavily relies on the decision of the apex court in C. Albert Morris versus K. Chandrasekhar and others versus others reported in so and so, which considers Rule 152(1)(1) of the Petroleum Rules 2002, as in the present case, Petroleum Rules, to buttress the submission that in view of the irreportable position on record that the lease expired on 29/10/2015, respondents ceased to have right to the right site, and in view of unambiguous statutory provisions, the respondent 3 was obligated to issue order of suspension or cancellation. Mr. R.M. Sharma would submit that even if it is assumed and argued that respondent number 1 and 2 are in possession, the litigious possession cannot be equated with right to site within the meaning of 152(1) of the Petroleum Rules. Stand of respondent 1 and 2. Respondent 1 and 2 do not dispute that the license tenure expired on 29/10/2005. Respondents 1 and 2 submits that during the course of the negotiations, the petitioner expressly agreed to extend the lease for a period of 30 years, as it is evident from the affidavit dated 21/1/2004. In this case, there was an expressly agreed to extend the period. That was relief.
93.
Was there. Here, court extended the period in view of the Petroleum Burma Shell Oil Company rules, that they did not take the benefit. Respondent 1 and 2 submits that relying on the assurance extended that the lease tenure shall be renewed, respondent 1 incurred substantial expenditure for setting up a petroleum retail so and so. Then, my lord, kindly come to in this also there was suit and other things. Respondent 1 and 2 further state that notice dated 21/1/2005 is issued calling upon the petitioner to renew the license for a period of 30 years. Some negotiations ensured whereafter petitioner instituted regular civil suit the 30th of 2016 for eviction, during the pendency of which respondent 1 filed special leave suits 664 of 2017 seeking decree of specific performance. In this case, there was no decree of performance. Now, my lord, may kindly directly come to now, my lord, para 8, your lordship, of the same judgment. Para 8.
Yes.
A.V. Khare would submit that since the civil suit seeking decree for eviction which is instituted by the petitioner and the civil suit seeking decree of specific performance of conditions of renewal are pending, the rights of the parties are not established, and therefore the decision of Apex Court in C. Albert Morris does not take the case of the petitioner in any other. We are not persuaded to accept the submission canvassed by A.V. Khare that in view of the pendency of the litigation, respondent 1 and 2 do have any existing right to the subject plot for storing the petroleum. This is the main issue as is in this case also. 152 of Petroleum Rules so and so, suspension or cancellation stands cancelled. So if licensee ceases to have any right to the site for storing petroleum. My lord, may kindly say, law is very clear on this. They can't go by virtue of the interim order. They can't run the show, my lord. Yes. Then, my lord, stand cancelled if no objection certificate is cancelled by the district authority, the state government in accordance with subsection 1 of so and so 150 he is liable to be suspended or cancelled by an order of licensing authority for any contravention of the act, or if any so and so. First point itself, my lord, stand cancelled if licensee ceases to have any right to the site for storing petroleum. Then, my lord, all follows, your lord. Then kindly come to, my lord, while dealing with that, next page, your lordship. This section extracted, your lordship. Rule 152 supra is considered by Apex Court. This is 11th. Apex Court in C. Albert Morris. It was argued on behalf of the licensee that the right mentioned in Rule 152(1)(1) of the Petroleum Rules will have to be interpreted with widest manner possible, and it's synonymous to the mere right of possession. It was further submitted that the licensee is a tenant holding over and has an existing right to the site. The licensee further argued that no mandamus could have been issued by the High Court not to renew the license. The plea that the licensee is a statutory tenant was also canvassed on the touchstone of the lease deed. The apex court held that mere acceptance of rent by a landlord from the tenant in possession after the lease has been determined, either by efflux of time or by notice to the quit, would not create tenancy so as to confer on the erstwhile tenant the status of tenant or a right to be in possession. I stop at this stage, my lord. It is their contention. We are depositing the amount in the trial court as directed by the court. You are bound to deposit, either you have to pay to the landlord or you should pay to the court, deposit to the court. Therefore, that contention, my lord, will take away this law laid down by the Honorable Apex Court. Merely because you have paid the rent, it will not take away the provisions of strength of the provision of law under 152 or 1 is the full submission. The apex court then held that the licensee is not a statutory tenant inasmuch as what was leased out was a vacant land and the provisions of the Pondicherry Buildings Lease So-and-so Act 1969 are not applicable. The apex court rejected the submission canvassed on behalf of the licensee that the word right used to rule 152 of the petroleum rules only means legal right to continue on the land. It is further held that the term judicial possession or litigious possession does not connote a valid legal right to continue in possession within the meaning of the said rules, and occupation without consent is wrongful occupation. Considering the submission canvassed on behalf of the licensee that the word right to site must be given liberal interpretation having regard to the public interest subserved by the petroleum outlets, in the apex court observes thus, the argument of ML Rao, learned senior counsel appearing for the appellant, is that the words right to site appearing in Rule 153(1) of the petroleum rules must be given liberal interpretation having regard to the public interest subserved by the petrol bunks, which are essential for the smooth flow of goods service as also for the movement of persons. Rule 153(1) petroleum rules is right to the site for storing petroleum. It is not the right for storing petroleum on the site. My lord, may kindly note this, your lordship. It is not the right for storing petroleum on the site. That is so because the aspect is dealt with specifically in subclass 2 of Rule 153(1), which refers to a no objection certificate, which the district authority or the state government is required to give. No objection certificate which is granted under Rule 144 is the one given by the authority concerned, stating that it has no objection for storage of petroleum on the site. After examining the site plan and other relevant factors, the word right to the site have therefore to be understood as referring to the right to the site on which the petroleum is stored. A person can be said to have a right to something when it is possible to find a lawful origin for that right. A wrong cannot be a right of a person who trespasses onto another's land. The trespass cannot be said to have a right to the land vis-a-vis the owner because he happens to be in possession of the land. Mere presence on the land by itself does not result in right to the land. Such presence on the premises may ripen into the right by person by reason of possession having become adverse to the true owner by reason of the passage of time and possession being open, uninterrupted, continuous, and in one's own right. Apex court held that when the lease expired and the landlord declined to renew the same and called upon the erstwhile tenant to surrender possession, the erstwhile tenant did not have any right to the site. The continued occupation of the land, which had the erstwhile tenant had no right to occupy, cannot be equated with lawful possession, and litigious possession cannot be regarded as lawful possession. Therefore, there are so many things has been said, your lordship. And in considered view, it is a litigious possession, not a lawful possession. It has been held, your lordship. Para 13, my lord, summarize, my
You
lord.
mentioned the para numbers, we'll go through.
Yes,
it.
that's all, my lord. Yeah, that's only, my lord. Therefore, my lord, I'm sorry, my lord. The next judgment, my lord.
Submission is
Para 10, my lord. I don't. Para 10, next judgment, my lord. Following the judgment, para 10 and para 11, my lord, can be looked into, my lord.
So your
I
basic
need not.
submission is from 93, there's no lease.
93, there is no lease. Even after the decree passed by the court, in the suit filed by themselves, they did not get the lease deed extended. through the erstwhile owner or did not get the extended the lease deed through the court. These two not happened in their own suit.
ಅದೇ ಹೇಳಿದ ಅಷ್ಟೇ
Yes.
basic submission.
That's all the submission. Will you
Yes,
oblige?
three-
Thank you.
3 to 5 or 4 minutes, I'll take your lordship.
Yes, please.
Kindly take this 25, 525 of 25, my lords.
25, 525 ಅಲ್ಲಿ ಏನ್ ತಗೊಳ್ಬೇಕು?
Please, my lords.
What do you want us to see in 25, 525?
Page 155, my lords.
The
that is
writ petition.
Writ petition, my writ petition, my lords. Page 155. The first objection is with regard to continuation of lease, my lords.
155.
Please, my lords.
Yes.
Para 3 may kindly be seen, my lords. It is their
155 is not, is the order sheet.
145, sorry, I'm sorry, extremely.
45.
This is the application given by them before the DC, based on which the impugned order was passed. Kindly come to para 3, my lords. It's at page 145.
Yes.
The petitioners, by virtue of the Burma Shell Act and its provisions, all the lessees including Bharat Petroleum, respond become statutory tenant for further period of 30 years from the date of expiry of earlier lease, from 1993 to 31/8/23. It is by operation of law, my lords. Though the court had passed, if the court has passed that we have to seek some,
You'll have to show us because the order is saying different.
it is the provision in the act itself. my lords.
Show us the provision.
Burma
Which
Shell
provision
Act-
are you referring to?
Burma Shell Act is there, my lords. Yes,
So
madam.
whichever act, whichever provision, whichever judgment, whichever, whatever you want to rely on, show it to us. If not shown, it is not seen.
Please, my lords. May I read, my lords? Maybe this
ಯಾವುದು?
court ಅವ್ರ ಹತ್ರ ಇದೆಯೋ ಇಲ್ವೋ ಗೊತ್ತಲ್ಲ. ಬರ್ಮಾ ಶೆಲ್ ಆಕ್ಟ್ ಇದೆಯಾ ಮೇಡಮ್? ಇಲ್ಲಿ. My lords, by operation of law, what happened was originally Burma Shell, with Burma Shell, we had some.
You give us the act. Anyway, the other documents are also to be produced. Day after 27th, you'll produce it, Andrala. 27th, we'll have it. You produce that this 30th.
Because two things are very, very important. So
May
far
pass on
as I'm
this.
concerned. One is that the petitioner's father is stated to be the bachelor in that, I have to count over. Second is, if it is a fact that only in 2025, that is 2 years after the sale deed was executed in his favor, if this property was brought on record, then I have no case at all. I will certainly concede.
There are 4 items. Number 1, the property was never subject matter of the suit, so the injunction order will not apply. Number 2, when the property was purchased, there was no injunction order as regard that property. 3, the fact that there was a amendment application filed would itself indicate that you yourself knew that the property was not there. That is as regard that. Number 4 is as regard this particular lease. 93, it is expired, 30 years statutory is there, but the court order said that you have to get executed a sale deed, a extension of lease or through execution court. What is the statutory applicability there to, and whether there is a presumption of extension to it? That is number 4. Number 5 is as regards the 10 crore 50 lakhs which has been deposited.
I'll fail with the memo.
And what are the terms of,
And the order. Please.
what are the terms of?
And Bernard, right from day one, when the suit was filed, if this property were a part of the suit settled property, then his contention would be falsified. Otherwise, I'll have no case.
ಅದು ಫಸ್ಟ್ ಅಲ್ಲೇ ಹೋಗ್ಬಿಡತ್ತೆ. ಫಸ್ಟ್ ಆದ್ಮೇಲೆ ಇವೆಲ್ಲ ಬರುತ್ತೆ.
ಆ ಪ್ರಾಪರ್ಟಿನ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ರು, ಬಟ್ ಏನಂದ್ರೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆ ಸರ್ವೆ ನಂಬರ್ ನ ಚೇಂಜ್ ಮಾಡಿಸಿದ್ರು ಅಷ್ಟೇ. ದಟ್ ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಆಲ್ವೇಸ್ ದೇರ್. We will answer all those 5 questions.
Petroleum rules are given that active Burma Shell Oil Company.
Burma Shell ಇರ್ಲಿ. Heard further argument to the third senior counsel for the petitioner in WP 25697 of 2025. Submission of learned counsel for the petitioner in WP 23178 of 26. Reply argument of the S.C. Shuramu, that counsel for respond number 5 and 6 in WP number 25525 of 2024 for rejoinder arguments released on 30th.
31st.
31st, sorry,
Sunday
31st. 31st.
2:30 na sir?
2:30.
Grateful.
38 you will ask.
ಬೇಗ ಮುಗಿಸ್ಬಿಡಿ ಅದು.
ಸಂಡೇ ಬರ್ತೀನಿ.
Serial number 3, 18 DM.
Mr. Chanchuda?
This is a matter, your lordship had directed me to,
Plaint in the pending
Yes,
suit
ma'am.
as also written statement.
the lordship wanted to know which is that civil suit number, my lord. But I've just produced the original plaint at ink page number 8, wherein Kempanna, the deceased husband of the petitioner, was the original plaintiff. And page number 2 is the amended plaint, where the LRs are brought on record, and petitioner number 1 is 1A, my lord. She is not a third party or any other person, only to defend this particular suit instituted by her husband.
So there were 468. This was filed by Kemparna.
Yes, my lord.
Suit for?
Specific performance.
You had sought for specific. So now you have to establish your source of funds.
Yes, my lord.
Petitioner, third. Petitioner, the wife of deceased D.K. Kemparna is before this court seeking for the following reliefs. The said D.K. Kemparna was working as a Group D employee with the government of Karnataka and retired after attaining superannuation. During lifetime of expired on superannuation on 15/2/2020, leaving behind his wife and the petitioner herein, the petitioner herein, and other children. During the lifetime of D.K. Kemparna, he had filed a suit in OS number 468 of 2019 against
file of the
Srimati
civil
Jayamma
judge.
and others, seeking for specific performance of agreement dated 8/5/2006. On the expiry of D.K. Kemparna, the petitioner and her children and the children of the petitioner and D.K. Kemparna were brought on record as plaintiff 1A to 1D. The suit being one for specific performance in order to establish the source of funds for the purpose of source and availability of funds to establish the readiness and willingness of D.K. Kemparna and the family in respect of the relief of specific performance which had been sought for. The petitioner had made an application with the respondents for issuance of copies of the salary slip to be produced in the said suit. The said request was rejected on the ground that the salary slip was personal in nature to Sri D.K. Kemparna and could not be furnished to the petitioner. It is this endorsement which is challenged in these proceedings. The submission of Sri H.N. and counsel for the petitioner is that the salary slip is not required for any adversarial proceedings within the family or against Sri D.K. Kemparna. It is required in order to support the case filed by D.K. Kemparna, where the petitioner has come on record as a legal heir. And as such, the petitioner not having access to the salary slip otherwise than from the defendant, from the respondents, the salary slip ought to have been furnished to the petitioner. Sri Mohammad Jafar Shah and AGA would submit that a salary slip is personal to the employee and in terms of the right to privacy, and as also though the application not filed on the Right to Information Act in terms of Section 8 exception, the said salary slip was not being provided.
It was not an RTI application.
Though not, and the argument. heard so-and-so peruse papers. The short question that would arise for consideration is whether on the expiry of the husband, if the wife were to seek for certain details, including the salary slip of her deceased husband from the employer, would that be covered under the right to privacy, requiring the respondents, official respondents, not to furnish the document? There are various nuances to this question. If the wife were to seek for those details in order to claim maintenance or the like, which is adversarial to the interest of the deceased employee, then obviously the same cannot be furnished, since that would be covered under right to privacy. However, if the application has been filed and documents are sought for in order to safeguard the estate of the deceased husband, then the respondent cannot have any excuse not to furnish such document. In the present case, in order to ascertain the veracity and the requirement of the petitioner had been called upon to place on record the details of the suit which had been filed, in persons of which suit invoice number 468, the plaintiff invoice number 468 of 2019 has been placed on record, which had been filed by the deceased husband of the petitioner for specific performance. A perusal of the written statement indicates that there's a denial made as regards the financial ability of the plaintiff, the deceased husband of the petitioner. The matter being posted for evidence, it is also clear that there is a requirement for the petitioner, who is one of the plaintiffs now, to establish the readiness and willingness, which includes the financial ability. In that view of the matter, being satisfied with the requirement of the petitioner in this particular case, that the salary slip is required to safeguard the estate of the petitioner, of the deceased employee, inasmuch as if a specific performance is granted in the said suit filed by the deceased employee during his lifetime, the benefits of the said decree of specific performance will accrue to the estate of the deceased employee. And this court is of the considered opinion that the endorsement could not have been so issued without examining these aspects. Hence, this court passes the following order. Writ petition is allowed, a certiorari is issued, the endorsement dated 12/6/26, issued by respondent number 3 at annexure A is quashed. A mandamus is issued directing respondent number 2 to consider the representation dated 5/6/26 at annexure F by the petitioner and issue the copies, certified copies of the payslips from the time the agreement of sale was entered into till the expiry of DK Kempanna, within a period of 15 days from the date of receipt of a copy of this order.
23rd is my date, ma'am.
23rd
is my date.
23rd of September.
Yes, ma'am.
15 days.
Deeply obliged.
Serial number 4, Ravindranath K, corrected matter.
Not applicable. No, it's take require sufficient time.
440. ಅದು ಎಷ್ಟೊಂದು ಆಯ್ತು.
That's why, my lord, I want to, again, I am a partner.
4 relist on.
Manoj, it's just,
ನೀವು ಒಬ್ರು ಕನೆಕ್ಟ್ ಅಂತೀರ, ಒಬ್ರು ಕನೆಕ್ಟ್ ಬೇಡ ಅಂತಾರೆ, ಅದೆರಡೂ ಬರುತ್ತೆ. It'll come on the same day. 4 and 6 relist on. ಎಷ್ಟೊತ್ತು ಬೇಕು ನಿಮ್ಗೆ?
Citations citations
ಎಷ್ಟೊತ್ತು ಬೇಕು?
minimum half an hour to 45 minutes is required. All citations very important.
45 minutes ಎಲ್ಲ ಎಲ್ಲಿಂದ ತರದ್ರು?
Important.
Be concise.
The matter has to be considered by your lordship on point.
Like, give us the para numbers, we'll read it.
That everything I've given.
In court only to read.
Served as per your lordship directions, not even
Serve it
para
or
wise,
not?
but everything served. All the copies have been.
ಸಾಕು ಅಷ್ಟು ನಾವು ನೋಡ್ತೀವಿ.
I can take for half an hour at least.
5 minutes. What about your reply, madam?
Manoj, I'm ready, Manoj.
How long will you take?
Manoj, I've just prepared a synopsis also, Manoj.
Good, but how long will you take for
Just
need?
15 minutes.
15 minutes.
10 to 15.
31st. Relist on 31st.
Interim order.
6 ಯಾವುದು 7 4 6 and 7 released on 31st interim orders granted separate order ಮಾಡಿ interim order in 4 6 ಅಲ್ಲಿ ಇದೆಯಾ
Interim order
ಇಲ್ಲ 4 ಅಲ್ಲಿ interim order 6 ಅಲ್ಲಿ 31st 7 ಅಲ್ಲಿ
7 ಅಲ್ಲಿ entry ಮಾಡ್ರಿ ಇಲ್ಲ. Entry ಮಾಡ್ರಿ may be granted my lord in this case my lord.
7 ಅಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ
ಅಲ್ಲ notice ಆಗಿಲ್ಲ.
7 ಕೊಡಿ
Because my lord, 7 is my lord covered by your lordship decision my lord. 7 my lord.
Well, then 6, my lords, I just state.
My lord, so far as 7 is concerned my lord, 7 is that my lord is like.
ಏನು
Well, I filed my wakalatnama, my lords. in
6
the-
ಅಲ್ಲಿ since Swamini Ganesh Mohanambal has appeared for respond number 2 delete the name of Sri H-10 as that are paying for respond number 2 and print the name of Swamini Ganesh Mohanambal as that are paying for respond number 2 6 and 6.3 yes 7 ಏನಿದು
7 my lord, it is covered my lord, 7 is my lord
and
covered by your lordship decision my
HGP
lord.
for respond
Kind-
number 1
My lord, I'm so
you will accept madam
7.
My lords, I'll just
Oh,
accept
so it's
notice,
not
my
the
lords,
union.
let the copies be served.
it is retired WO of Hiriyur town Chitradurga
My lord,
My lords, we just, the present AW will just file the wakalatnama, my lords, on that aspect.
Ms. Swamini Ganesh Mohanambal
7
accepts
is
notice
concerned
for
by
respond number 2
7 is concerned my lord, your lordship decision my lord. Because my lord, in this case my lord, there are 2 FRs registered my lord. Kindly see that my lord, page number 1.
We're hearing all these matters, we'll hear it if it's connected.
Short date my.
31st is a long date for you?
My lord, interim order is not there my lord.
31st is a long date for you? Illa, we'll give you a very short date of 31st December.
That's a 6 I have a small submission. The earlier occasion, your lordships were pleased to mention that so far as the other council sites are concerned, they have not filed their statement of objections. my lords. Within 31st, they would be directed to do so because
Oral submission.
then
Serial number 5, K. Ram Singh.
Charge application filed by the petitioner. Specific sessions. Hence is
Respond number 2, my lord.
page number 26, page number 22 is the
Yes, ready?
Yes, my lord. Yes.
Ready.
page number 22 is the rejected order.
Huh?
22, page number 22 is the dismissed order. Session.
22 ಏನು?
Rejected order of this.
Discharge application.
So far against this accused, this petitioners are concerned 504, 506. The allegation against accused number 1 is 376. In the crime stage, not there were 4 accused. Now the name of the accused number 4 has been deleted from the charge sheet. There is an inordinate delay in filing complaint. So far, the allegation in this petition is that one month before the incident.
You're asking for quashing of the proceedings in a 376 matter.
It is 504, 506 against it, not against accused number 1 is 376.
Accused ನಿಮ್ದು 504.
2 and 3. The mother and son of the accused.
Accused 2 and 3. Where is the charge sheet?
They are the own wife and the own son of the.
52.
They are one.
Where the allegation against accused 2 and 3?
Page number 52.
52 is not.
The bottom below 14/8 14/8/2019 ಸಂಜೆ 6:30 ಗಂಟೆಯಲ್ಲಿ 1ನೇ ಆರೋಪಿ 2 ಮತ್ತು 3ನೇ ಆರೋಪಿಯಿಂದ ಸೇರಿ ಸಾಕ್ಷಿ ಒಂದರ ಮನೆಗೆ ಹೋಗಿ ಸಾಕ್ಷಿ ಒಂದರ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡಿ ಅವಾಚ್ಯದಿಂದ ಬೈದು ಪೈಕಿ ಆರೋಪಿ 2 ಮತ್ತು 3 ರವರೆಗೂ ಸಾಕ್ಷಿರವರೆಗೆ ರಾತ್ರಿ ಮನೆಯನ್ನು ಖಾಲಿ ಮಾಡಲು ಹೋಗು ಸರಿ ಇಲ್ಲವಾದ್ರೆ ನಿನ್ನನ್ನು ಸಾಯಿಸಿಬಿಟ್ಟು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿತ್ತು. This is the allegation against. That is, after the lapse of 1 month, the complaint came to be filed. The complaint came to be filed, Lord, on 15/9/2019. So there is an allegation against accused number 1. It is a consensual act between this the victim and also this accused number 1.
There is a 376 which is there.
Against accused number 1. The wife of this accused number 1 and the son has been implicated here.
So for the allegation is that the incident took place on 24/7/2019. So it is the allegation that on 14/8/2019, they threatened and they sir. On 15/9/2019, complaint came to be filed. So nothing is recovered. 504, 506 against accused number 2 and 3. No, yeah, the lady is aged about 56 years. 56 years. Third marriage it is.
Who is 56 years?
The victim is aged about 56 years. The complainant.
That's all. Yes, madam. So there is even that there is proof. It has to go for trial. There are statements which are there.
No.
And this is in connection with the 376 offense.
That is considered.
Even if it has been committed by your son.
Yes.
It is the accused against accused number 1, my lord.
But you are the one who has threatened the victim.
No, it is after.
It's even worse.
After 1 month back, my lord, a complaint came to be filed.
That is
There are
subject to
eyewitness
trial.
also there, my lord.
Subject to trial. There are witnesses who have spoken against you.
I'm here with relying upon the judgment of
In a 370 offense, you go and threaten the victim.
not
And you think it's only 506, 504.
not kindly. There is 1 month delay in filing complaint.
That doesn't matter. The 376 offense, people get scared of it.
Not this is
The witnesses who have spoken.
Not kindly peruse the judgment. my lord. Wherein
Padi
23
Adhiyan
is
judgment. Yes.
recent judgment, my lord. Is consensual act. This is very accused number 1 has been acquitted.
The offenses under what provision?
376. 376. And also kindly say the page number 5, my lord.
This is about marriage. Promise to marry.
This is also promise to marry. This is the case, my lord. Where complaint the Ali makes allegation against accused number 1 is that she wanted to marry him. She roamed with him for 1 year. Now kindly see the complaint, my lord. It is not the case of.
ಅದು ಹೇಳಿಲ್ಲ ನೀವು ಇವಾಗ ಹೇಳ್ತಾ
Please,
ಇದ್ದೀರಾ.
please, please. Kindly see.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಸರಿಯಾಗಿ ಮಾಡಬೇಕು.
Please, kindly see the page number 39.
Yes.
She Shakila B. Muslim 56 ವರ್ಷ ಶಿಕ್ಷಕಿ. So on so on. ವಿಜಯಪುರ ಜಾಮಿಯಾ ಮಸೀದ್ ಸದಸ್ಯರ ಸಾದಾಕತ್ಲಿ ಎಂಬುದನ್ನು ಮದುವೆಯಾಗಿ ನಂಬಿಸಿ ನನ್ನನ್ನು ಕಾರಲ್ಲಿ ಕರೆದುಕೊಂಡು ಸೋನ್ಸಾಗಿ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳದೆ ಮೋಸ ಮಾಡಿದ ಆತನ ಮಗ ಸಕ್ಲಿನ್ ಮತ್ತು ನಸರಿನವರು ಮಚ್ಚನ್ನು ತೆಗೆದು ನನಗೆ ಬಂದು ಬೈದು ಕೊಲೆ ಮಾಡಲು ಬೆದರಿಕೆ ಹಾಕಿದ ಬಗ್ಗೆ ದೂರು. ನೋ ಮಚ್ ಈಸ್ ಬಿನ್ ಸೀಸ್. ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಈ ಮೇಲ್ಕಂಡ ವಾಸಿಯಾದ ಶಕಿಲವಿ ನಾನು ಶಾಲಾ ಶಿಕ್ಷೆಗೆ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ನಾನು ವಿವಾಹ ವಿಚ್ಛೇದ ಮಹಿಳೆಯಾಗಿದ್ದ ಮತ್ತೊಂದು ಮದುವೆಯ ಸಲುವಾಗಿ ಮ್ಯಾರೇಜ್ ಬ್ಯೂರೋಗಳಿಗೆ ನನ್ನ ಪರಿಚಿತರ ಬಳಿ ಗಂಡಿನ ಬಗ್ಗೆ ಹುಡುಕಾಡುತ್ತಿದ್ದರು. ಹೀಗಿರುವಾಗ 2018 ಇಸವಿ ಡಿಸೆಂಬರ್ ತಿಂಗಳಲ್ಲಿ ನನಗೆ ಪರಿಚಿತರಾದ ಮೆಹಬೂಬ್ ನಗರದ ಶ್ರೀಮತಿ ನಸೀಮರವರು ವಿಜಯಪುರ ಟೌನ್ 14ನೇ ವಾರ್ಡ್ ದರ್ಗಾ ಮೊಹಲ್ಲಾ 2ನೇ ಕ್ರಾಸ್ ವಾಸಿಯಾದ ವಿಜಯಪುರ ಜಾಮಿಯಾ ಮಸೀದಿ ಸದಸ್ಯ ಸದಾಕತ್ ಅಲಿಯವರು ನನಗೆ ಪರಿಚಯ ಮಾಡಿಸಿದರು. ಸದಾಕತ್ ಅಲಿಯವರು ನನಗೆ ಜೊತೆಗೆ ಮಾತನಾಡಿ ನನಗೆ ಮದುವೆಯಾಗಿ ಬೇಡಿಕೆ ಇಟ್ಟನು. ಆತನೇ ಈಗಾಗಲೇ ಮದುವೆಯಾಗಿ ಮಕ್ಕಳಿರೋ ವಿಚಾರ ನನಗೆ ತಿಳಿದ. ನಾನು ಬೇಡ ಎಂದು ಎಷ್ಟೇ ಹೇಳಿದ್ರು ಆತನು ಪದೇ ಪದೇ ನನಗೆ ಫೋನ್ ಮಾಡಿ ನನಗೆ ಟ್ವೀಟ್ ಮಾಡಿ ಇಸ್ಲಾಂ ಧರ್ಮದ ಶರೀಯತ್ ಪ್ರಕಾರ ನಾನು ನಿನ್ನ ಮದುವೆ ಆಗುತ್ತೇನೆ, ನೀನು ನನ್ನ ತುಂಬಾ ಇಷ್ಟವಾಗಿದೆ, ನೀನು ಬಿಡುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿ ನಂಬಿಸಿದವನು. ಅದಕ್ಕೆ ನಾನು ಇನ್ನೋವಾಗಲೇ ಸುತ್ತಾಡಿಸುತ್ತಿದ್ದೆ. ನಾನು ವಿಜಯಪುರ ಸುಮಾರು ಜನರಿಗೆ ತಿಳಿದಿದ್ದು ಜಾಮಿಯಾ ಮಸೀದಿ ಅಧ್ಯಕ್ಷರು ಸಹ ವಿಚಾರ ಗೊತ್ತಿದ್ದು ಸದಾಕತೆಯನ್ನು ಕರೆದು ನಿನ್ನ ಮತ್ತು ಶಕೀಲ ಬಗ್ಗೆ ಸಾರ್ವಜನಿಕರು ಮತ್ತು ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರು ಹಲವಾರು ರೀತಿ ಮಾತನಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದಾರೆ. ಇದು ನಿನಗೆ ಮತ್ತು ಮಸೀದಿಯ ಮಂಡಳಿಗೆ ಶೋಭೆ ತರುವಂತದ್ದನ್ನು ಆತನಿಗೆ ಬುದ್ಧವಾಗಿ ಹೇಳಿದ್ದಾಗಿ, ಏನೇ ಆದರೂ ನಾನು ಶಕೀಲ ಮದುವೆ ಆಗಿದೆ ಹೇಳಿ ತಿಳಿಸುವುದಾಗಿ ನಾನು ಅವ್ರ ಬಳಿ ಏನೇ ಹೇಳಿದ್ರು ನಾನು ಬಿಡುವುದಿಲ್ಲ, ನಾನು ನಿಖಾ ಮಾಡಿಕೊಳ್ಳುತ್ತೇನೆ ಎಂದು ನಂಬಿಸಿ ನಾನು ಸಹ ಆ ಮಾತನ್ನು ನಂಬಿದ್ದೇನೆ. ಕಾಲಕ್ರಮೇಣ ನನ್ನನ್ನು ಇನ್ನೋ ಕಾರಣ ಕರೆದುಕೊಂಡು ವಿಜಯಪುರ ಸುತ್ತಮುತ್ತ ಇರೋ ಕರ್ಕೊಂಡೋಗಿ ಯಾರು ಲೈಂಗಿಕ ಕ್ರಿಯೆ ನಡೆಸಿದ್ದಾನೆ. She was in with him for 1 year. So at last she filed the complaint in the page number 14 against this petition. She made allegation. Accused number 4 is that he has videographed this one, but he's been deleted from the charge sheet. Accused number 4. So there are several notices have been given to produce the document concerned to this. She has not produced any documents before the police, and she has not appeared before the police. which is a consensual act between accused number one and this victim. Lord. So after the lapse of 1 month, Lord, she filed, she is also implicated the mother and son of.
Why did you go and threaten her?
Lord,
As
she
per the
voluntarily came to the house, nearly house, shop of the accused number one. They never been to the house of throne.
So anybody comes, you'll threaten.
No, Lord. They have it is alleged after the lapse of 1 month. She implicated this one because.
But they have witness statements.
Before that itself, my lord, she filed complaint against this first husband. He's been convicted. The another son is involved in the 395 offense. She filed a habeas corpus against him. I have also produced. I have also document from this. You know what is law? How to implicate a person. Right? You see, this is wherein this Shakila B, the first husband was convicted for 307. In the second judgment, Lord, where she filed a habeas corpus petition, wherein the son has been implicated in 395. There may be allegation against accused number one, my lord, not against this accused number 2 and 3. The wife and the son has been implicated. He is a student, my lord.
Why are you relying on this?
Lord, because she know how to implicate a person, because the first husband was been convicted. She filed complaint 307 against him. The another son who has been implicated in 395, she filed a habeas corpus petition. So after that, so this is the third marriage she wanted to marry. This accused number one here. Now, after that, Lord, she implicated this accused number 2 and 3, who is the wife and the son of the accused number 1.
How is this proceeding related to accused number 2 and 3?
Because I wanted to show, Lord, just one thing is that she know what the legal proceeding, everything. She know how to implicate a person. And she filed a complaint against accused number 4, who says that who videographed the entire incident. So he's been deleted from the charge sheet. Accused number 4, he was very much present in the spot who videographed the incident regarding the act of accused number 1 and 2, and he was pressurizing her. He was supposed to broadcast in the media. So these are the allegations against accused number 4. He's been deleted from the charge sheet because no document was been secured by the police, and even she has not produced any documents, and she has not appeared before the police station also. They have given several notices to this victim. Even I have produced several notices. Kindly.
Madam, have you seen all the papers properly? But why is accused number 4 deleted?
Serious allegation accused number 4, Miller.
And what about these earlier other proceedings that were there? You'll have to make your submission on all of these. The offense is 376. And even threatening is also important. You need to be clear on things. We list on 28th, 31st. New Mondays ಬರ್ತೀರಾ? Relist on 31st.
2:30.
2:30.
Serial number 8, Manjunatha LS.
I'm appear for petitioner. Did petition number 26, 743 of 25.
Yeah, who will start? ಎಷ್ಟೊತ್ತಾಗತ್ತೆ?
Date.
ಎಷ್ಟೊತ್ತಾಗತ್ತೆ ನಿಮ್ದೆಲ್ಲ? ಎಷ್ಟೊತ್ತಾಗತ್ತೆ? ನಿಮ್ದು ಇಲ್ಲ ಎಲ್ಲ ಸೇರ? ನಿಮ್ದು ಎಷ್ಟೊತ್ತಾಗತ್ತೆ?
ನಮ್ದೊಂದು 20 minutes.
ಜನಪ್ಪ ನಿಮ್ದು?
ಏನಿಲ್ಲ ಸ್ವಾಮಿ 5 ನಿಮಿಷ ಅಷ್ಟ
ಐದು.
ಮಾತ್ರ 5 ನಿಮಿಷ ಸರ್ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಒಂದು 10 minutes ಅಲ್ಲಿ
ದಾನಪ್ಪ ಅವ್ರದ್ದು only the
resolution.
resolution they have
Include
done.
resolution.
It is all, now it is very important
Resolution.
is
ಈ ಕಡೆ ಯಾರಿದ್ದಾರೆ?
Suspending the members resolutions.
So 1 hour ಬೇಕಾಗತ್ತಾ? ಎಲ್ಲ ಸೇರಿ.
TRCS ದು ಒಂದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು only remaining.
ಟೈಮ್ ಎಲ್ಲಿಂದ ಕೊಡೋದು?
Next week ಅಲ್ಲಿ
ಅದು ಇಲ್ಲ 26/7/43 ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ ಬೆಸ್ಟ್ ಇದೆ ಸರ್. ಅದಕ್ಕೆ ಒಂದೇ ಅಸೋಸಿಯೇಷನ್ ಮಾಡಿ
ಯಾವ್ದು ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ನೀವು ಬೇಗ ಮುಗಿಸಿದ್ರೆ ಸಾಕು. ಒಂದೊಂದು ಗಂಟೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಕಷ್ಟ ಆಗತ್ತೆ ಅದಕ್ಕೆ.
ಅನೇಕ ಸರ್ ಹೆಚ್ಚು ಒಂದು ಓದಿದ್ರೆ ಒಂದು 5 ನಿಮಿಷದಲ್ಲಿ ಡಿಲೀಟ್ ಮಾಡ್ಬೋದು ಸರ್. ಅದೇನೋ ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಆಗಿದೆ ಸರ್.
8 realized on
743 ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಸಮಯ.
second
ಅದು
ನೀವು ಏನ್ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ರೆ ಏನ್ ಬೇಗ ಮುಗಿಸಿದ್ರೆ ಆಗುತ್ತೆ. All of you can do that. 8 due to positive time matter cannot be taken. Today released on 11th. 11th ಬಹಳ ಮ್ಯಾಟರ್ಸ್ ಇದಾವೆ. ಫ್ರೈಡೆ ಏನಕ್ಕೆ ಬೇಕು? 10th 10/9.
Lordship may just make a mention. Lordship may just make a mention. Seal number 15, it's at Kyarpuram railway station matter. There's some urgency. Your Lordships have extensively heard it. May request for some day for further hearing. 15. I appear in the matters for the respondent.
15.
List 215.
1st August.
Your Lordship, seal number 30.
Serial number 22. But the committee was not that. Committee report.
20?
22.
List 2.
Second list.
19727.
Please.
ಯಾವ್ದು ಇದು?
ಚಾಮುಂಡಿ ಬೆಟ್ಟ.
ಚಾಮುಂಡಿ ಬೆಟ್ಟ ಹೆಂಗಾಯ್ತು ಪೂಜೆ ಎಲ್ಲ?
ಅಲ್ಲ ಇದು ಮಾಡ್ತಾ ಇದಾರೆ. ಓನ್ಲಿ ಲಿಟಲ್ ಈಗೋ ಪ್ರಾಬ್ಲಮ್, ಈಗೋಯಿಸ್ಟಿಕ್ ಅಷ್ಟೇ, ಬೇರೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಅಲ್ಲಿ. ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. ಅಂಡ್ ಐ ಹ್ಯಾವ್ ಟಾಕ್ ಟು ಎವ್ರಿಬಡಿ.
ಯಾರಿಗೆ ಈಗೋ ಪ್ರಾಬ್ಲಮ್?
ಅಲ್ಲಿ ಏನಂದ್ರೆ in a year 2 months are allowed to this petitioner. In these 2 months 2 shifts are being worked out, and in his place somebody else is being appointed also on his request. Whenever he is in absentia he should work out anta. This person was claiming that both will work anta. Naan helade you can't eat the cake and have to madak baradillappa ee tara idella ide anta. Then he was satisfied with all the things which is given. That same thing I have produced before my Lord.
22 commissioner's report has been filed by Mr. Shivrudra, released on 27th.
Next matter,
Totally.
120, my lord.
Next matter, serial number 14.
Serial number
33, it's number 2.
33.
I want to carry out the amendment on IA because file was not available because the order was passed on 18th.
ಮಾಡಿ.
I will permit to one line that survey number.
ಇವಾಗ ಎಲ್ಲಿ ಕೊಡಕ್ಕಾಗಲ್ಲ.
Serial number 120, my lord.
Some date maybe.
My lord,
My lord, may I make a mention, my lord? This is the matter regarding demands.
Everybody wants to mention.
My lord,
serial number 116.
My lord, serial number 118.
Can't take up anything if you.
Kindly have it tomorrow, my lord. This is the matter regarding demands.
ಲಿಸ್ಟ್ 1 ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ 16 ಸೆಪ್ಟೆಂಬರ್ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಫಾಸ್ಟ್ ಓವರ್ ನಾಳೆ. ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 9 to 22 27 8 24 to 38 20 28 8 14 27 8 21 27 8
ಲಿಸ್ಟ್ 1 ಯಾವ ಡೇಟ್ ಅಂದ್ರೆ?
ಲಿಸ್ಟ್ 1 16th ಸೆಪ್ಟೆಂಬರ್.
ಮೇಡಮ್
ಲಿಸ್ಟ್ 1 16 ಸೆಪ್ಟೆಂಬರ್.
Madam, 21 is
16/9.
ಒಂದ್ ನಿಮಿಷ ಅವ್ರನ್ನೆಲ್ಲ ಕಳಿಸ್ಬಿಟ್ಟು ಕೊಡ್ತೀನಿ, ಕಾಯ್ತೀರಾ? ಇವ್ರನ್ನೆಲ್ಲ ಕಳಿಸ್ಬಿಟ್ಟು ಒಂದ್ 5 ನಿಮಿಷ ಇದೆಲ್ಲ ಆಗ್ಬಿಡ್ಲಿ ಕೊಡ್ತೀನಿ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಅಲ್ಲಿ ಫೈಲ್ ಹೋದ್ರೆ ಇವ್ರನ್ನ
ಸೀರಿಯಲ್ ನಂಬರ್ 12
ಕೊಡ್ತೀನಿ. 15/27/8.
Madam, serial number 12, second list.
ಅದು ಫಸ್ಟ್ ಸೆಪ್ಟೆಂಬರ್. ಆರ್ಡರ್ ಆಗಿರೋದು ಬಿಟ್ಬಿಡಿ. ಆಗುತ್ತೆ, ಇದ್ರೆ ಆಗುತ್ತೆ. 16 ಲಿಸ್ಟು. 16/27/8.
12, list 2.
28/8.
List 2, serial number 12.
30/28/8. 28/8.
80.
List 2. 27/8. ಇಲ್ಲ ಇಲ್ಲಿ ಹೇಳಿರೋದು ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ.
List 180, madam, 80.
16 ಸೆಪ್ಟೆಂಬರ್. 18/27/8. 16 ಸೆಪ್ಟೆಂಬರ್. ಅದು ಅಷ್ಟೇ ಕರಿಬೇಕಿತ್ತು, ಆಗಲ್ವೇ? ಬರುತ್ತೆ, ಇನ್ನೊಂದು ಡೇಟ್ ಬರುತ್ತೆ. ಕಾಪಿ ಅಂದ್ರೆ ನಿಮ್ ಕೊಡ್ಲಿಲ್ವಾ, ಸರ್ವ್ ಮಾಡ್ಲಿಲ್ವಾ? ಆ ಫೈಲ್ ಮೇಲಿರೋದು ಮೇಲಿರೋದೇನೆ ಸರ್, ಇಲ್ಲಿ ಬಂದೇ ಇರೋದು. ಇಲ್ಲಿ ಕೋಡ್ ಕಾಪಿ ಅದು. ಇಲ್ಲ, ಇಲ್ಲಿ ಏನೂ ಇಲ್ಲ. ಲಿಸ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 17/27/8. 230ಗೆ ಬರುತ್ತೆ. 230ದೆಲ್ಲ 230. ಲಿಸ್ಟು 11/27/8. 20 ತೋರಿಸ್ತಾರೆ. ನೋಟಿಸ್ ಆಗಿರ್ಲಿಲ್ವಾ ಅದ್ರಲ್ಲಿ? ಇಲ್ಲ, ಆಗಿಲ್ಲ. ಹೇಳ್ತೀನಿ.
ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 34 ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ?
28/8. ನಿಮ್ದು 16th ಸೆಪ್ಟೆಂಬರ್.
ಲಿಸ್ಟ್ 34
ಅದು ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಬರ್ಬೇಕು. ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅದು ಬೈ ಮಿಸ್ಟೇಕ್. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಸರಿ ಮಾಡ್ತಾರೆ.
ಮೇಡಮ್ 28 ಕೊಟ್ಟ
ಹೋಗುತ್ತೆ. 52 ಫಸ್ಟ್ ಲಿಸ್ಟ್. 85 16 ಸೆಪ್ಟೆಂಬರ್. ಮತ್ತೆ 11th. ನೀವು ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಕ್ಕೆ 16th. ಈಗ ಇದೇನಿದು? ರಿಪೋರ್ಟ್ ಕೊಟ್ರು. ಎರಡೆರಡು ಇದೆಯಾ? ಅದೇ ಸೀರಿಯಲ್ ನಂಬರ್ ಅಲ್ಲ? ಸರಿ. ಆಯ್ತು. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 20/27/8.
ಎಲ್ಲದು 27/8. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ 27.
ಹೌದು.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
96/63. ಫ್ರೈಡೆ ಇಲ್ಲ. 16th ಸೆಪ್ಟೆಂಬರ್. 16 ಸೆಪ್ಟೆಂಬರ್. ಹೇಳಿರೋ ಡೇಟ್, ನನಗೆ ಹೇಳಿರೋ ಡೇಟ್ ನಾನು ಕೊಡ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ. 52 14% ಆದ್ರೆ ನೀವು 14% ಅಲ್ಲ. ಇಲ್ಲ 52 14% ಹೇಳಿ ಡೇಟ್.
ಮೇಡಮ್ ಇಲ್ಲಿದೆ ಮೇಡಮ್, ನಾನಾದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್
14%.
16 ಡೇಟ್ ಕೊಟ್ಮೇಲೆ ಅದ್ ಹೆಂಗ್ ಚೇಂಜ್ ಮಾಡ್ತೀರಾ? ನಾನು
14%
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು.
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ.
ಇರ್ಲಿ,
14% ಅವ್ರು ಕೇಳೋ ಡೇಟ್
ನಾನ್ ಕೇಳಿದ್ಮೇಲೆ 69 ಹೇಳಿದ್ಮೇಲೆ ನೀವು ಹೆಂಗ್ ಡೇಟ್ ಚೇಂಜ್ ಮಾಡ್ತೀರಾ? 15 ಆಗ್ತಾ ಇದೆ, ಡೇಟ್ ಕೇಳ್ತೀನಿ 69. ಅಲ್ಲಿ ಆ ಕಡೆ ಆಚೆ ಹೋದ್ಮೇಲೆ ಇವ್ರು ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ರ, ಹೆಂಗ್ ಕೊಡ್ತೀರಾ? ನೋ 69 ಇರ್ಲಿ, ಯು ಕಾಂಟ್ ಚೇಂಜ್.
14%
ಆಯ್ತು, ಏನ್ ಸ್ಪೆಷಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಏನು? ಐ ನೀಡ್ ಟು ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್. ಇಲ್ಲ ಅದ್ ಹೆಂಗ್ ಕೊಡ್ತೀರಾ? 69 ಇರ್ಲಿ.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆಯಪ್ಪ.
ಇದ್ಮೇಲೆ 69 ಅಂತ ಹೇಳಿದ್ಮೇಲೆ how can you change?
14% ಇದ್ದಾಗ ನಿಮ್ ಕೇಸಲ್ಲಿ ಇದೆ ಅಂತ ನೀವು ಹೇಳಿದ್ರಾ?
ಅಲ್ಲ, ನಾನ್ ರೆಸ್ಪಾಂಡ್ 52 ಅಂತ ಕೇಳಿದಾಗ ನೀವು 16
ಕೇಸ್ ಅವ್ರದ್ದು ಅವ್ರು ಕೇಳೋ
69 ಇರ್ಲಿ, ಅದ್ ಹೆಂಗ್ ಚೇಂಜ್ ಮಾಡ್ತೀರಾ?
ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆಯಪ್ಪ.
ಏನಂತ?
14% ಇದ್ರೆ ಅವ್ರು ಕೇಳೋ ಡೇಟ್ ಕೊಡಿ ಅಂತ. ಯಾಕಂದ್ರೆ ಅವ್ರು ದಿನ ಬರಕ್ಕಾಗಲ್ಲ ಕೋರ್ಟಿಗೆ.
ಸಬ್ಮಿಷನ್ ಮಾಡೋಣ, ಸ್ಪೆಷಲ್ ಟ್ರೀಟ್ಮೆಂಟ್. ಆಯ್ತು.
ಒಂದಾದ್ಮೇಲೆ ಒಂದು ಹೇಳಿ. ನಾನು ಯಾವ್ದು ಪೇಜ್ ತಿರ್ಗಿಸ್ಬೇಕಲ್ವಾ? ಯಾವ ಪೇಜ್ ತಿರ್ಗಿಸ್ಲಿ ಅಂತ ನನಗೆ ಗೊತ್ತಾಗಲ್ಲ. ಆಯ್ತಾಯ್ತು. 96 14% ಇಲ್ಲಪ್ಪ. 14% ಆಗ ಅಪಿಯರ್ ಆಗೋರಿಗೆ ಮಾತ್ರ. ನೀವು ದಿನ ಕೋರ್ಟಿಗೆ ಬರ್ತೀರಾ ಅಲ್ಲ ಸರ್? ನೀವು ದಿನ ಬರ್ತೀರಾ ಕೋರ್ಟ್ ಅಲ್ವಾ? ಅವ್ರಾದ್ರೆ ಬರಲ್ಲ ಅಂತ. 96, 16 ಸೆಪ್ಟೆಂಬರ್.
ಮ್ಯಾಮ್
ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ಯಾರಿಗೆ ಯಾವತ್ತು ಬೇಕೋ. ಅದು ಹೆಂಗಿದೆ ಹಂಗೆ ಬರುತ್ತೆ. 16 ಅದೇ ಡೇಟ್ 16. ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಮಾತ್ರ ಅವ್ರು ಕೇಳೋ ಡೇಟ್.
ಮ್ಯಾಮ್ 30th
34 ಲಿಸ್ಟ್ 28.
Madam,
ಗೊತ್ತಿಲ್ಲ. ಎಕ್ಸ್ಪರ್ಸ್ ಯಾರು? ಅದೇ ನನಗೂ ಅದೇ.
Madam,
16 ಸೆಪ್ಟೆಂಬರ್.
Madam,
ಸೇಮ್ ಎಲ್ಲ 16. ನಂಗೆ ಹೇಳಿರೋದು ಅದೇ. ನಿನ್ನೆ 15th ಕೊಟ್ಟಿತ್ತು. ನಿನ್ನೆ ಮೀನ್ಸ್ ಥರ್ಸ್ಡೇ, ಇವತ್ತು 16.
Court Officer, ma'am.
109, 16 ಅಷ್ಟೇ. ಇಲ್ಲ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ಯಾರಿಗ್ ಬೇಕವ್ರು ಹೇಳಿ ಮೇಡಮ್. ಈಸಿಲಿ
Madam, list one serial number 88 IU extend ಆಗ್ಬೇಕು madam.
16 ಸೆಪ್ಟೆಂಬರ್.
IU to be extended madam.